I won't be upgrading any matter for the time being. Please mention only the extension of interim orders. Let me take up serially now. Because upgradation is losing all meaning. I mean, no applications, extension of interim order, and to be mentioned for non-prosecution or correction, please hand over.
97 is releasing the matter, my lord. My lord appeared in this matter.
Oh, yes, yes. To be mentioned sort of matters, releasing, non-prosecution, withdrawal, correction of my order, these matters, please mention.
My lord,
Like that. For the time being, no.
New electricity matter, my lord. The petitioner is surviving without electricity in the summer.
I'll take up serially all matters now.
Lordship,
Please, I'll practice this. I'll stop this practice of upgradation for the time being. Losing meaning.
Maybe, my lord, just hand over the slips, my lord, in that case, my lord.
Don't, Mr. Bhattacharya. I won't lie in open court. I mean, even in a closed court, I wouldn't lie. I wouldn't like to lie.
my lord, a new electricity matter, my lord. The
No,
petitioner
I wouldn't lie to you. For the time being, I won't be. No, I by no means no, Mr. Sinha.
For judgment,
Call on the list.
item number 1.
Call on the list, sir.
My lord, mentioning for
Number one.
listing. My lord, mentioning for listing.
Item 1, accordingly, WPS 17245 of 2022 is dismissed on contest without any orders to cost. However, nothing in this order shall preclude the petitioners from applying before the appropriate authority for refund of the deposits already made by them by way of registration fees and stamp duty. If the petitioners are so entitled, otherwise in law, the said authority shall decide such application in accordance with law without being deterred by any of the observations made herein. Urgent certified copies. Action.
Since I was waiting for judgment, item number 2. My lord, kindly.
WPA 3876 of 2024 is dismissed on contest without, however, any orders to cost. Urgent certified copies. Peter call karo.
We mention item number 3.
Non-prosecution.
Strategy is appearing on behalf of Union of India, Your Lordship.
Petitioner.
No one is appearing.
None appears for the petitioner at the time of call, since the matter was mentioned for non-prosecution, and none appears for the petitioner. WP 826164 of 2023 is dismissed for default without any orders to cost. Next.
Item number 4.
In this matter, I am for the petitioner.
I appear for the alleged contempt.
My lord, your lordship, my lord. My lord's order dated 15th of April.
Name and
PPO, yes.
rectification of the
PPO has been issued.
there is a confusion with regard to the communication of email and
Mr.
other.
Bhattacharya, please take the microphone.
There was a confusion about the sending of email and other things. Your Lordship may remember, Your Lordship directed. This is the latest communication. I am paying for 5 weeks time to process the PPO.
When was the communication made to you?
There is a confusion about the email. My instruction is, my lord, the email was not sent to the proper authority. After your lordship's order, I have instructed them to act on the basis of your lordship's order and documents submitted to your lordships. On that, my lord, they are proceeding.
Thank you. Yes. Today we are on 22nd. Mr.
And one other thing, I remind your lordship, in the initial order which your lordship passed,
yes.
here your lordship granted 1 month's time from the date of rectification.
Yeah,
Also.
long ago it has been.
Mr. Manna, I'll give them 4 weeks. I'll record this submission of Mr. Bhattacharya. I'll keep it exactly after 4 weeks, because here in the letter it's 4 to 5 weeks. I'll give them 4 weeks. Mr. Bhattacharya, I'll give you 4 weeks.
Lordship,
They're suffering.
for the state lordship, if that is the claim, then I'll come with the affidavit, lordship. Because not only by email, we have even sent it by speed post also.
Learned Counsel for the Union of India submits that there was some confusion about the email sent from the end of the state regarding the correction of the name of the petitioner. First, Learned Counsel for the state vehemently opposes such submission and contends that the communication was made by mail as well, by direct mode as well as by email. Be that as it may, a written instruction given by email is handed over by learned counsel for the union, which seeks further 4 to 5 weeks time for processing the PPO for ensuring that the amount in question is disbursed to the petitioner. Full stop. Next para. Although it was expected that the order of this court ought to have been complied with much earlier, comma, the purpose of this court in passing the order is primarily to reach the benefit of the scheme to the petitioner and not to punish contemners unnecessarily, full stop. Hence, comma, as a last chance to the alleged contemners, comma, the matter is postponed till May 20, 2024, when it will be listed under the same heading, full stop. The alleged contemner is given this opportunity is the last opportunity which will be given to the alleged contemner to comply with the order by issuing a PPO to ensure that the amount is disbursed to the petitioner. Full stop. Else, comma, appropriate order shall be passed on the next returnable date. The written communication stroke printout of email handed over by learned counsel for the union today in court be kept on record.
Lordship, only one indulgence, Lordship. We have sent it through speed post. Lordship, keep this also in record.
Very well. The purported copy of the the purported copy of the communications made by the state handed over by learned counsel for the state today be also kept on record.
Grateful, Lordship.
Next.
Item number 5. My lord, before lordship takes up 5, my lord, very innocuous, my lord. Item number 3, I missed, my lord.
I've dismissed for default.
Because of the non-prosecution.
Whatever. Yes, 4 who is appearing? None appears for the parties at the time of call. Full stop. The matter was mentioned by the petitioner for withdrawing the writ petition. Full stop. Since none appears today for the petitioner, comma, it transpires that the petitioner is not interested to proceed further with the matter. Petitioners are not interested to proceed further with the matter. Full stop. Accordingly, WPA 7160 of 2024 is dismissed for default without any order to cost. Next.
Item number 6 and 7.
My lord, I beg to appear for the petitioner, my lord. It was for submitting of the
Yes,
written
yes,
notes
please
of
file your
argument,
notes.
my lord. This is for the petitioner for in both the writ petition.
Petitioner, you are for respond number authorities? Yes. And who is that?
Husband.
Very well. Written notes of arguments filed by the petitioner, the respondent numbers 1 to 5 and respondent number 6 today be kept on record. Push up. Hearing is concluded in the matter and the same is reserved for judgment. Thank you.
Grateful, lord.
Thank you. এক সেকেন্ড অরিত্র আচ্ছা এটা ফার্স্ট
Upgraded
যাব
matter.
ফাইলগুলো রেডি রেখো হু ইজ অ্যাপিয়ারিং ফর দ্য পিটিশনার
Milord, item number 8. Milord, yes, Milord, I appear for the petitioner. Milord, sorry, Milord, I'm appearing virtually. Milord, item number 8. Milord, yes, Milord, item number is the matter, Milord, with regard to Milord 23 dog breeds when Milord being declared as ferocious.
yes Mr. Yeah.
I have an application for intervention, Lord, on behalf of
When did you file it, Mr. Banerjee?
file. Was filed, Lord, was not to be listed. It was not scheduled to be listed.
Please use the microphone so that he can hear.
So it was scheduled to be listed, Lord.
Was give the number, it will appear along with this tomorrow.
Yes, but, may I submit?
Milord, yeah, Milord, only one thing, Milord. Milord, only one thing, Milord. The notification for which we have challenged
It's
has
appearing.
been already.
No, the application is appearing today. Then I'll hear the application
It's
first.
appearing. It's appearing. It's appearing.
Yes, what is the matter?
Yes,
Yes, Mr. Dasgupta, what do you want?
Milord, the notification that we have challenged, Milord, when Milord 23 dog breeds were Milord declared as Milord ferocious, Milord have been set aside by both Karnataka High Court and Division Bench of Honorable Delhi High Court.
Very
Milord, I have the orders. Milord, my colleague is there with the Milord hard copy of the orders.
You don't want to proceed with this.
My lord will dispose of the Milord writ petition in view of those orders because the notification has already been.
Mr. Dasgupta, no. If I have to dispose it of allowing, setting aside, then I have to pass an order on merits. You have to argue on
Very
merits.
well, very well. My lord, we have not, my lord, we have not received the affidavit from, my lord, the Union of India as of date.
What do you say? Yes.
My lord,
What is your plea? Who are you?
Lord, I am
that affidavit is
for
yet to
ethical
be received.
treatment of animals, my lord. I have, my lord, I am, my lord, an NGO, my lord, looking after, my lord, animal welfare rights. In all the petitions, my lord, in which this particular notification has been challenged, my lord, I have applied, my lord, for getting added as a party. I have no, I am, my lord, humbly, my lord, submitting that your lordship may permit me to, my lord, to intervene and to make submissions, my lord, in support of what is actually, my lord, the logic behind, my lord, the ban. I have, my lord, certain materials on record, my lord, which I can bring to your lordship's, my lord, kind consideration if your lordship permits me to intervene.
Well, I like to file opposition then, my lord, to that,
Very well.
opposing the intervention. And
Yes,
my
yes.
lord, kindly extend the interim order in that event.
The order passes the Delhi High Court. Division bench of the Delhi High Court, my lord. My stand is.
You are for the union.
Yes.
Right. Delhi High
Now, my
Court.
lord, kindly text, my lord, kindly comes to, my lord, paragraph 6.
6, yes.
Learned Counsel for the Union admits the other than the government bodies, no private body was heard before the impugned circular was issued. He states that he has no objection if the impugned circular is set aside with a direction to the respondents to issue the fresh circular notification after giving an opportunity to all stakeholders to raise their objections. So
You are
my-
agreeable to this?
Yes, yes. My stand is clear, my lord. I cannot prolong it. My lord, this is a stand of the union that the union will hear all.
I can record your
Yes,
submission
yes,
and
yes.
do it.
Record in and dispose it of.
Yes, my lord can dispose it of in light of that, my lord, submission.
Yes, I will. Yeah, Mr. Banerjee, then I'll refuse your application
My lord.
in some other case.
Yes.
Probably when they pass a new circular.
Yes. And my lord, as a stakeholder, I'll be heard because Delhi High Court
So
has
I'll
said
just
that everyone-
dispose of because of this.
in view of the orders passed by the
Right,
Delhi High
right.
Court and the concession.
Learned Counsel petitioner submits at the outset that the same notification was challenged before different high courts. Full stop. Our division bench of the Delhi High Court as well as a learned single judge of the Karnataka High Court have already set aside the notification. Full stop. It is thus submitted that the matter may be disposed of in the light of such decisions. Full stop. Next para. Learned Counsel for the applicant in Can 1 of 2024 contends that the said petition, the applicant therein represents a body of, represents an organization. What is your purpose? To say, to save animals or humans?
My lord, animals, my lord, and my lord, consequentially humans.
Copy that.
My lord, to protect, my lord,
Of an organization which is directly interested in the outcome of the writ petition. However, comma, in view of the submission of learned counsel for the union, that since the Delhi High Court has already clarified in its order that the impugned circular is set aside with a direction to the respondents to issue a fresh circular stroke notification after giving an opportunity to all stakeholders to raise their objections, comma, the union does not want to prolong the litigation and are agreeable to the setting aside of the present circular, comma, subject of course to the rider as put in by the Delhi High Court, comma, the present application has been rendered infructuous. Full stop. Next para. It is expected that when passing a new circular, comma, if any, comma, the respondent authorities shall take note and give adequate opportunity and publish a notice to ensure that all stakeholders are actually represented and permitted to raise their objections before the union before passing such fresh circular stroke notification or taking steps accordingly. Full stop. Next para. With the above observation, comma, in the light of the submission of the Union of India, comma, the present cause of action has been rendered infructuous. Full stop. Hence, WPA 8632 of 2024 is disposed of as infructuous in the light of the above observations by keeping on record the photocopies of the judgments handed over by learned counsel for the union today. No rest to cost urgent certificates. Next.
Obliged, my lord.
Can 1 of 2020 is accordingly disposed of as well.
My lord, allegations, if any, my lord, is
Allegations are, it will be deemed that they have admitted everything.
My lord, apologize, my lord,
Call on the next matter.
my lord, item number
Don't disturb
9,
the court. Yes.
Milord 9, Milord, there's a private respondent.
Yes.
Milord, service on the private respondent could not take place, Milord, of the upgradation. Would your lordship, Milord, kindly take it up, Milord?
Goes out of the upgraded list. So, the private respondent could not be served as submitted
oh,
fairly by learned counsel for the
Oh, private
You are
respondent has
appearing.
come. Oh.
Hey. Very well. Yes, Mr. Banerjee, what is your matter? Mr. Banerjee,
My lord, I am
safely-
representing the private respondent, my lord.
Yes.
Only, my lord, we have not been served, but we have kept track of the list, my lord.
Thus, Mr. Banerjee thanks you for appearing. Because I was going to put it out of the list. Yes, Mr. Banerjee, what is the matter?
Inside, Milord, a hospital
Take
premises.
the microphone a bit closer.
Inside a hospital premises, Milord, in a part of the hospital premises, there is, Milord, a off shop of liquor, Milord, which is in operation.
Yes.
Now, Milord, I have, Milord, filed representation, Milord, before the authority concerned, complaining, Milord, of the nuisance that is being caused at the time, Milord, of operation of this liquor shop. Now, Milord, the persons, Milord, they queue up outside the liquor shop.
Let it be disposed of in this way. I won't decide on merit.
Just pay this.
No, Mr. Banerjee, let Mr. Banerjee finish. You have to add something.
No, Milord,
If that is the order, you don't have to add anything.
yes, if lordship can
Subject to Mr. Chakraborty, yes.
Milord, this shop.
Please use the microphone so that Mr. Dapke.
Yes. This shop pre-exists, this wine shop pre-exists the hospital, whatever. 30
What
years.
happened to you? You have been in the shop or?
No, I just came running.
Oh, I'm sorry.
Pre-exists.
No, I won't prejudge on the issue. You have to
But
consider it.
that decision already has been taken. I'm not aware that whether this
The
has been
decision has been taken.
I'm handing over a copy.
Give a copy to Mr. Banerjee. Mr. Banerjee, I'll give you leave to approach to challenge this.
Because Malad would kindly record this. My submission, this pre-exists 93. This is there. Originally, it's a Gaja shop, licensed Gaja shop. Thereafter, from 93, it has given license under Bengal Excise Act. That is recorded in the order.
Mr. Banerjee, it will be too cumbersome to add that in this writ petition.
Yes,
Just-
so I'll come back with
I'll do that.
I'll come back with a fresh one.
Learned
But-
counsel, Mr.
A copy
Mr.
may be given to my associate also, my lord, of the
Pardon?
report.
Please give a copy to them also.
Give all the.
Milord, only,
Yes, he
only,
will.
only
He
one thing is, which is the decision, if my learned friend can just point out, which is the decision according to him.
Which page is the decision?
The inquiry report at page 7, Malad. The inquiry report pursuant to their complaint.
No, what is a copy of the decision?
Decision.
This is the inquiry
The page 7 is the decision.
decision. When inquiry was done, this was communicated. What was the inquiry? That is communicated to the.
Oh, yes, yes. No apparent legal ground to. Para 6, page 7. Learned counsel for the petitioner alleges that the private respondent has set up an off shop for sale of liquor near the premises of the petitioner number 1 hospital, whose shop. Such off shop is creating extreme nuisance for which a representation has been given, which has not been considered by the respondent authorities. Full stop. Next para, learned counsel for the private respondent opposes such contentions. Full stop. Learned counsel for the respondent authorities hands over a copy of a decision which has been taken in the meantime by the respondent authorities, whereby the contention of the petitioner has apparently been turned down. Full stop. A copy of the said documents are handed over here and now to learned counsel for the petitioner, as well as to learned, ma'am, you have got a copy also,
Yes, Malad, I've handled.
as well as to the private respondent. Full stop. Next para. Since the cause of action of the writ petition has been rendered infructuous by such decision, comma, there is no use prolonging the same. Full stop. Accordingly, WPA 28867 of 2022 is disposed of as infructuous with liberty to the petitioner to challenge the decision taken on the representation given by the petitioner regarding the running of the off shop at the premises in question by the private respondent by way of a fresh challenge. Full stop. If such a challenge is preferred, comma, the appropriate court /writ court shall decide all issues involved without being prejudiced in any manner by the present disposal. Full stop. আচ্ছা, দুটো প্যারাগ্রাফ আগে একটা ঢুকিয়ে দাও। Learned counsel for the respondent যেখানে respondent authorities যেখানে বললাম, Learned counsel for the respondent authorities also adds that the off-shop is running since 1993. Full stop. This much.
Yes. Well, only one thing. The decision, my lord, is dated 9th of December 2022. In case, my lord, there is subsequently, my lord, any difficulty in identifying which is the court decision, 9th of December
You can challenge
2020.
this.
If your lordship, my lord, records it kindly in the order that the date of the decision, so that I get to know what I am challenging. Well, otherwise, my lord, subsequently.
Very well.
Yeah.
যেখানে private respondent authorities submit করছে,
This is the
decision has been taken বলেছি কোথাও একটা, taken on December 9, 2022. December 9, 2022. যদি না বলে থাকি তাহলে a copy of the documents handed over be kept on record.
I'm obliged.
I'm grateful.
Thank you. Yes. দাদা, আমাকে দিলে তাহলে xerox করে দিই।
Item number 10.
10, my lord, my affidavit in reply is due, my lord. Kindly, my lord, permit me to put in my affidavit in reply. They had come up, my lord, belatedly with their affidavit in opposition.
No, opposition is served. Move the matter, Mr. Banerjee. I'll take it without the opposition. Yes. Upgrade matters, I won't grant time. You pray for upgradation and then don't appear when the matter is called on. No, refused. Please move the matter.
Now, my lord,
yes.
This is in connection, my lord, with short delivery, my lord, of contracted amount of coal. If your lordship kindly sees, there was, my lord, a coal supply agreement, a fuel supply agreement on the basis of which coal was directed, my lord, coal would be supplied, my lord, by the respondent, my lord, to the petitioner in terms of a particular weightage which was agreed upon by the parties. Now, kindly, my lord, come to paragraph 8, my lord, of the writ petition. After the supply, my lord, was effected,
they were to supply coal to you.
They were to supply coal to me.
Yes.
So the entire 12,000 tons a year was divided into 1,000 tons a month.
Yes.
Into 12 installments. And, my lord, I was required, my lord, to make payment of upfront amounts, my lord, for the purpose of the said supply. Now, my lord, I had started, my lord, making payments, my lord. Now, despite, my lord, from paragraph 7 onwards, if your lordship kindly sees, there has been a short supply in spite of the fact that I had made the payment in advance. Subsequently, my lord, that supply in paragraph 8 on 16 July 2021, my lord, the respondent authorities, my lord, informed me that insofar as the drowning of the working phase at 27 number incline is concerned, for the purpose of the said drowning, they were unable to provide the G5 coal to us. And when production shall resume, we will communicate further. That was, my lord, their their letter at 16 July 2021. Now, my lord, at annexure P3. Now, my lord, after that, we have made several, my lord, requests to them. The mails of request, my lord, they are all annexed as annexure P4, saying that, my lord, they should inform us when they will resume the supply, but they have not, my lord, in the meantime, resumed the supply. Subsequently, suddenly, we are, my lord, slapped with a notice, which is, my lord, the cause of action. Please come to, my lord, page 100 of my lord's brief. 22nd April 2022.
Yes.
Option to pay higher between compensation penalty and security deposit to survive termination of FSA if level of lifting falls below 30%. This is to inform you that the approval of the CIL board has been accorded for NRS FSA consumers under NRS linkage auction route and pre-NRS linkage auction regime also, whose level of lifting falls below 30% for the year 2019-20 onwards, but want to keep their FSA alive, be allowed by paying applicable compensation or penalty or security deposit amount, whichever is higher. Having level of lifting 10.97 in the year 2021-22 for the FSA, executed with ECL dated 29 June 2020.
So, Banerjee, short, they allege that you have failed to lift.
That I have failed to lift.
Failed to lift, for that they impose penalty on it.
For that they impose penalty.
You are challenging on the ground that they themselves were
not giving. You know, that is not.
I'll pass an interim order and keep it for hearing on some. None appears for the respondent at the time of call. Full stop. No affidavit in opposition is filed either. Full stop. the petitioner has made out a strong prima facie case as to the claim of a substantial amount as penalty vide communication dated April 22, 2022, annexed at page 100 of the writ petition, was palpably dehors the law and in violation of natural justice in view of the previous admission of the respondents to the effect that it was the respondents who were responsible for not being able to supply the adequate quantity of coal to the petitioner, whereas the premise of the impugned levy of penalty is that the petitioner failed to lift adequate amount of coal during the relevant period. Full stop. Next para. The petitioner is justified prima facie in invoking the principle of one cannot take advantage of one's own wrong. Full stop. Having thus made out a prima facie case for hearing of the writ petition on merits, there shall be a stay of operation of the impugned communication dated April 22, 2022, and the respondents shall remain restrained from taking any coercive action against the petitioner on the basis of such impugned claim till disposal of the writ petition. Full stop. The time for filing affidavit in opposition is extended for a week from date. Full stop. Reply, if any, shall be filed within a further week thereafter. Full stop. The the writ petition shall be listed in due course for hearing in the monthly list of May 2024. Next.
Item number 11.
Lordship, I am for the petitioner, Lordship. Lordship, I am briefing the fact shortly. Lordship, petitioner has rendered a service to the works contract of the respondent. Lordship, after completion, respondent issued credential certificate in favor of the petitioner. Lordship, earlier occasion matter came up for the hearing. All the bill annexed with the writ petition, item-wise bill which is accorded by SDO Kolani. Lordship, earlier, but however, they sought to raise a fresh bill by the petitioner. By Lordship order, fresh bill was served. Lordship, on the order dated by Lordship order 6th October, there is a presumption that petitioner entitled for at least ₹8 lakhs. But till date, petitioner did not receive any amount, Lordship. Lordship, current condition, petitioner 72 years old, Lordship. I have all the medical documents and bedridden condition, Lordship. I have all the medical documents. If
72 years old. What is the age?
72 years, Lordship.
Yes, what do you say, Mr.
Lord,
This is a medical document,
the only
Lordship.
thing is that
Don't hand over documents.
With regard to the amount claimed by the petitioner.
Yes.
And the thing is that, my lord, kindly come to the credential certificate that was issued, that's supposed to be issued in favor of the petitioner, page 82, my lord.
Yes.
This is in respect of a work order, and the subject, my lord, if you like, Lordship, kindly go through the subject: supply work order for computer, printer, CC camera, LAN network, express. What I have, my lord, the work order, my lord, these were never the work order which was supposed to be supplied by the petitioner, my lord. My lord, these are the work orders, my lord. On
You have
which
given a credential certificate. Your SDO has given a
credential certificate itself is in, my lord, is in question, my lord.
Pay the amount and then question this
My lord,
credential certificate.
one thing, my lord. My lord, one thing.
No, no.
Oh, your lordship.
Your subdivisional officer has.
My lord,
Sir,
my lord,
June-
your lordship had asked for them to supply a bill, my lord, duplicate bill, so that we can
After the
verify.
credential certificate, you cannot reopen the issue, Mr. Ahmed.
Prayer, my lord, kindly come to the prayer, my lord.
Yes.
But they're claiming 15 lakhs, my lord.
Pay them 8 lakh for the time being, file your opposition,
My
and
lord,
then
that-
pay
that
the
is
rest.
not that is not
When
the
I decide the matter, I'll direct you to pay
My
the
lord,
rest.
my lord, there are some disputes, my lord, with regard to the bills which has been raised by
Maybe.
the, my lord, which has been raised by the petitioner, my lord.
You cannot do this in every matter. The state is doing. Several
But I have
matters.
not
Mr.
come in
Ahmed.
the way of making the payment to the petitioner, my lord, but they must
How
come
to
up with
overcome this credential certificate unless you prove that it is forged? If you say that it is forged, Mr. Ahmed, I'll record it and issue a 340 against your officer if it is found not to be forged. I'm telling you.
No,
These are not casual things to be
I'm
taken.
in respect to the work order, my lord, which was supposed to be given to the
Pay for this credential certificate? Whatever work order you have issued for other work orders?
the bills which has been supplied, my lord. Kindly go
Please
through the
tell me,
last
yes.
order, my lord.
Yes.
Your lordship's order was that they will supply me a duplicate bill.
They did not.
They have not. They have given me a synopsis of the bills, my lord. Rather than submitting those bills, they have
Where are
given me
those
a
bills? What has been given to you? Give me, show
Lordship,
me
page
this.
number 21 to 81, all the bills, itemized bill annexed, are all the bill accorded by the SDO
rather
Kolani
than
Lordship.
the duplicate bills which are supposed to be submitted, my lord. They have the invoice, my lord. The invoice for same invoice, my lord. The billing was done twice, my lord.
They have given the bill numbers.
They have, but my lord, if you kindly
Given the dates also.
my lord, the invoices which has been mentioned, my lord, there are the bills has been twice raised, my lord. This is the reason why I'm saying, my lord, these bills are disputed.
Calculate them. The screen out
At
which are
least,
the
they have a duplicate bill, my lord. They must submit.
They'll
that
provide
duplicate
nothing
bill,
else.
my lord.
Whatever has been provided, you'll be satisfied with it. If you say there's a double payment sought by them, screen out the double payments and pay the rest. I mean, you should have come ready with that. That these are the double payments. Point out the double payments.
My lord,
I'll deduct those. What is the deducted amount after deducting the double payments? What is according to you the amount? Say that. Pay that. Mr. Ahmed, you cannot take shelter of these vague allegations against them. Their bills have been annexed in the writ petition.
But those are not with respect to the work order they are claiming, my lord. But the bills are way back.
Every bill
Way
is
back then the
related
work
bill
order
number.
was issued, my lord.
What about the sir, bill number, Lordship?
Well, I'll direct you to file affidavit in opposition. Her age is 72. She is suffering from ailments. Pay her 4 lakh for the time.
We have filed an opposition. We have filed an.
You have filed an opposition.
opposition file kara আছে এটা.
I've directed you to file an opposition also.
Whether
the matter is ready. There was a direction for filing opposition.
Yes.
Lordship.
When was it filed?
করা আছে তো শিওর না কারণ কপি এখানে আছে কিন্তু এটা তোমার বলা নেই কিছু নাম্বার কিছু দেওয়া নেই তোমার
Lordship, what's happened as they raised the point, what's happened that sometimes in the year of 20 and 20.
No, when was the affidavit directed to be filed, Mr. Ahmed? I don't find any direction. Oh, yes. On 22nd of November. No, it was extended on your prayer on 15th of December, but never filed.
Unfortunately, my lord, I have the copy of the but I'm not sure whether the same has been filed or not.
No, I am sure it has not been
If
filed.
it's not
If it was
filed,
filed, it would be recorded. Rather, I extended the time for filing.
The instruction for my colleague is
Lordship, it's not filed.
I'll extend the time for filing opposition, but Mr. Ahmed pay 4 lakh within a week.
My lord.
Learned counsel for the petitioner contends that the petitioner raised bills for work done by the petitioner. It is submitted that credential certificate worth rupees 8 lakh out of the total 15 lakh claimed by the petitioner was issued, which has been annexed to the writ petition. Learned counsel for the state disputes the veracity of such bills, as it is pointed out that the credential certificate purportedly given to the petitioner does not tally with the work orders issued to the petitioner. There are several discrepancies in the synopsis of bills which was handed over to the respondent authorities by the petitioner pursuant to the direction of this court. Do you have other copies of this? Such copy handed over by learned counsel for the state today be kept on record.
The problem is
be that as it may, it is seen from the records that affidavit in opposition was directed to be filed, but the state is not yet ready with such affidavit. On the prayer of the state, the time for filing affidavit in opposition is extended for a week from date. Reply, if any, shall be filed within a week thereafter. The matter shall be listed for hearing in due course in the monthly list of May 2024. Next para, since a strong prima facie case has been made out by the petitioner, at least to the extent of rupees 8 lakh in terms of the credential certificate annexed to the writ petition, which is of course disputed on the allegation of double claims by the petitioner on behalf of the respondent authorities, the court is of the opinion that keeping in view the advanced age of the petitioner within bracket 72 years bracket closed and the medical ailments being suffered by her, an amount of rupees 4 lakh, that is half of the said amount mentioned in the credential certificate, should be paid immediately to the petitioner. Full stop. Next para. Accordingly, the respondent authorities shall pay rupees 4 lakh to the petitioner within a week from date. Full stop. Such payment will be treated as an ad hoc payment, subject to the outcome of the writ petition. Final outcome of the writ petition. Full stop.
Within a week, my lord,
Week, Mr. Ahmed. After that, the elections, you will be busy with the elections.
that
After that,
is
you will be busy with the elections. Week, 4 lakh. Paid from your pocket. Mr. Ahmed, you are sufficiently rich, paid from your pocket.
Lordship, kindly fix a date in the month of.
No. Next.
Item number 12.
Yes, what is the matter?
The petitioner husband was the one of the license consumer.
Mr. Chaudhary, what about file? Yeah, yes.
My lord,
You are appearing.
only one thing I'm taking the point that the petitioner before your lordship is not the registered consumer. Therefore, my lord, the registered consumer is the husband. Whether, my lord, the against the raising of bill, my lord, he filed an application before the, my lord, GRO.
He filed.
No, he filed. He filed GRO. Now, against that, my lord, ombudsman, this particular petitioner has filed. We have rejected on the ground that as he is not the consumer, we cannot entertain the
Only on that ground.
Only on that ground.
My lord, the husband was the consumer admittedly. My lord, after the death of the, my lord, the husband, my lord,
Husband has died.
Yes, my lord. The petitioner, my lord, running the, my lord, said pump, and my lord, they go on paying. My lord, ultimately, my lord, till my lord, September 21, my lord, the bill was raised, my lord, without any outstanding. My lord, subsequently, my lord, on the for the bill raised for October, my lord, huge bill, my lord, has been raised. My lord, then my lord, petitioner, my lord, raised objection before the, my lord, GRO. And that was that.
Why didn't you ask for a transposition of your name?
That was the, my lord, the mistake on the part of the petitioner. But RGRO, my lord, the consider and dispose of the, my lord, the objection raised by the petitioner. My lord, with specific finding, there was a mistake on the part of the licensee, my lord, in the reading of the meter. Kind of have a look at what's their objection, page 34. It's admitted position, it's their fault.
Ombudsman dismissed only on the ground of locus standi.
Yeah, only on the locus standi.
Mr. Mukherjee, I'll direct the ombudsman to treat her as the.
Because before the ombudsman, if they said the husband died, I don't know when the husband died. Now, your lordship knows, my lord, unless he is a consumer, your lordship knows under the regulation we cannot entertain. First of all, she has to
make an application.
No,
I'll do that. That application you will allow on payment of the regular costs without claiming this outstanding hours, subject to the outcome of the ombudsman.
Absolutely.
Happy? Mr. Chaudhary, you are happy also?
Yes, Mala.
You are not happy. Yes. What is your unhappiness?
Mala, in the meantime, Mala, what happened, Mala, my service connection has been disconnected by the Mala during pendency.
I think doing the ombudsman later, I'll fix a time limit within which the ombudsman to set. This is not domestic, this is for submersible pump.
Yes, Mala.
So not summer months does not affect you directly.
Mala, already, Mala, the Rabi crops is over, Rabi season
is over. Season is over. On the ground of Rabi season, so many connections are not being given by Mr. Mukherjee's client. So, learned counsel for the petitioner contends that the petitioner's husband was the original consumer who subsequent to his demise, the petitioner was sent exorbitant bills for exorbitant electricity bills for operating the submersible pump in question. The petitioner approached the concerned grievance redressal officer who decided the issue on merits against the petitioner without any demur as to the petitioner having any not having locus standi. Subsequently, when the petitioner approached the ombudsman challenging the order of the GRO, the ombudsman dismissed the same only on the ground of lack of locus standi of the petitioner, since the petitioner was not the consumer. Learned counsel for the WBACDCL reiterates such objection and submits that the petitioner was never the consumer and as such does not have locus standi to prefer the present challenge or the challenge before the ombudsman or the GRO. Next para, as the turn of events go, it is evident that the petitioner submits that her husband met his demise prior to the matter being decided by the GRO. Next para, thus, since the point was never taken before the GRO, it would be atrocious for the ombudsman to reject the prayer of the petitioner when the petitioner challenges the order of the GRO, on the ground of locus standi. However, to regularize things, it would only be appropriate if the petitioner applies for transferring the meter in her name, subject to payment of due charges for the same. Full stop. Next para. Upon such transfer, simultaneously with such transfer, comma, the ombudsman should also redecide the issue by deeming that the petitioner has locus standi to prefer the challenge, comma, on merits. Push up, in view of the above observations, comma, WPA 25425 of 2023 is disposed of by directing the petitioner to apply for transfer of the name in respect of the concerned electricity connection standing in the name of the deceased husband of the petitioner within a week from date. Pushed up. Immediately thereafter, the WPA-CTCL shall raise immediately thereafter, and upon the petitioner complying with due formalities regarding the necessary charges, the WPA-CTCL, comma, without insisting upon the petitioner paying the disputed amount of outstanding dues, comma, effect such transfer in the name of the petitioner on an ad hoc basis, subject to the outcome of the adjudication before the ombudsman regarding such outstanding, such disputed amount. Full stop. Next para. Simultaneously with such process, comma, the ombudsman shall also re-adjudicate the challenge of the petitioner against the order of the GRO, comma, positively within 4 weeks from the date of such approach being made by the petition, from the date of the communication of this order to the ombudsman by acting on a server copy of this order. Full stop. This court has not entered into the merits of the issues taken up by the petitioner in such challenge, and those will be decided independently upon giving adequate opportunity of hearing to all concerned by the ombudsman in accordance with law, comma, within the time frame as stipulated above. Full stop. It is further reiterated that the transfer of the name in favor of the petitioner shall, for the time being, is for the only for the time being, comma, subject to the outcome of the decision by the ombudsman. No address to cause urgency.
Only one thing, my lord, they will apply for by 1 week. We will do that. If your lordship kindly make it 5 weeks or 6 weeks, because within 1 week name will be changed. And my lord, your lordship directed that from today, kindly make it
not today, not today, from date of communication.
Communication of the order.
Yes, yes. Great. Do it simultaneously.
Item number 13.
Yes. Mr. Chaudhary, you?
Yes, my lord.
Yes.
My lord, identical issue, my lord, the petitioner, my lord, is the, my lord, here, my lord, consumer. My lord, the going, my lord, bills were raising, my lord, in regular basis. My lord, petitioner go on paying. All on a sudden, my lord, in the month of, my lord, of September, my lord, till September, there was no outstanding. My lord, all on a sudden, my lord, the high bill has been raised, my lord, in the in the month of September. My lord, I raised objection against the, my lord, that high bill. My lord, that is, my lord, at page 30. My lord, the considering the objection, RGRO, my lord, with RGRO heard the matter, my lord, with a specific finding, my lord, it's a fault on the part of the, my lord, licensee. My lord, kindly have a look on page 33.
Let us read that. Yes.
My lord, the contrary, the mishap on the part of the AE, my lord, station manager, Gokarno, even then, my lord, they have, my lord, did not. My lord,
don't make your comments. Read it out.
Yes, sir. Sorry.
Read this.
My lord, the observation is the, my lord, the agriculture,
the usual sermons. Yes.
Yes, my lord. The, my lord, ultimate, my lord, observation is the, my lord, the in favorable observation is, but on the contrary, this was the mishap on the part of the AE and station manager Gokarno, that the accumulation of reading should have been occurred due to not taking timely meter reading, for which the representative readers agency may not be pardoned and should be penalized as per norms. Well, that was the observation. Right? Fault on the part of the licensee. Even then, well, there no benefit was given. Well, the
Mr. Chaudhary, it is more or less settled that if there is a mistake, they can also later on claim the bills.
Yes, well, the same issue has been, well, decided by the, well, my lord, in the relying upon the,
not by me. There are judgments of the Supreme Court that later on, if there was a bona fide mistake, they can raise bills.
Yes, relying upon the, my lord, the
so why are you citing that? I mean, so They are entitled to claim.
Yes, yes, well, on the basis of they are restrained from disconnecting the supply of the
Oh, that.
on
This
the-
was after 2 years.
the identity.
No, that was not.
This claim was after 2 years.
This claim was the 21st when the due claim that is not the mention.
That is not. Show me the bill.
Kindly have a look, kindly have a look, page 26. In August bill, August bill, the reading date was 11th August 2021. Kindly have a look the previous reading and present reading. Present reading was the present reading is 6,564. Have a look. Got it, Malad?
No, where is that?
Malad, page 26.
In portion.
Middle.
Yes, 6564. Yes.
Middle portion. Malad, the present reading was in three categories type of reading. Malad.
Yes.
6564, 4310 and 9496. Malad, kindly have turned on next page. Malad, page 27.
Yes.
Malad, it's a reading date is 7th September 21. 7th. Right hand side top column. Malad, the present reading is Malad. Kindly have a look. Malad, there is Malad 6,824. In the month of
When
September.
was this bill was raised in September 2021?
Yes, September 21. Thereafter, Malad, the all on a sudden, kindly have a look on page 29.
Yes.
It's a bill for month of October. Kindly have a look on the reading. Reading present reading 35,460. How in 28 days the such difference can
Breakup was not given.
no was how such huge amount units can be consumed one by a consumer.
Let me go to Mr. Naik. Yes, Mr. Naik, you have not disclosed the time for which these readings were taken.
This amount, this complaint was before the RGRO. Then they are not.
That I know, Mr. Naik, it wouldn't
No,
have
they
to
approached Ombudsman also.
Yes, Ombudsman, that is the order under challenge.
The Ombudsman has not admitted their claim.
That is why they are before me.
Now,
What are you saying?
What I am submitting is this.
Ombudsman order is absolutely non-speaking. You have not revealed as to what is the period of the outstanding.
That would be done, lots of people.
I'll set aside the bill and direct you to raise that bill. But if it is before 2 years, Mr. Naik, obviously you know the law.
It is nobody's case also.
How can they make out a case on that? You have not even disclosed the period. How can it be anybody's case?
Point is not before the either before the RGRO or before the Ombudsman. My lord, direct us, we shall do that.
Learned counsel for the petitioner challenges an order passed by the Ombudsman in a challenge preferred in turn by the petitioner against an order of the grievance redressal officer, where the petitioner challenged exorbitant amount of bills raised by the WBSCDCL. Full stop. Learned counsel points out from the relevant bill annexed at page 29 of the writ petition, where it is seen that a huge spike in the regular charges is seen without any reflection as to the exact period for which such outstanding dues were shown. Full stop. The order of the Ombudsman proceeds on the premise that there was a mistake in the meter reading. Full stop. The Ombudsman, however, glosses over the issue of the period for which the outstanding bills was raised, which was never disclosed in the bill itself by the WBSCDCL. Full stop. Learned counsel for the petitioner is justified in arguing, that in the event the bills are raised after a period of 2 years from the date when they became due first, the WBSCDCL is debarred under section 56 within bracket 2 from taking any coercive action of disconnection of the electricity supply of the petitioner without the amounts having been disclosed all along in the bills. Full stop. In the present case, there is no previous reflection of the outstanding amounts in any prior bill. Full stop. However, since the WBSCDCL failed to disclose the exact period for which the outstanding amounts have accrued, even if the allegation as to faulty meter reading was justified, it is doubtful as to whether the WBACDCL can resort to disconnection, comma, since the outstanding might very well have been for a period beyond the period of 2 years. Full stop. In the absence of such disclosure, comma, the subsequent disconnection,
Still, I have.
the subsequent bill is vitiated due to lack of sufficient particulars, which hence, comma, the ombudsman as well as the GRO acted palpably without jurisdiction in affirming the said bills and turning down the challenge of the petitioner. Full stop. Accordingly, WPA 26295 of 2023 is allowed, comma, thereby setting aside the order of the ombudsman as well as the GRO and the impugned bill dated January 24, 2022, annexed at page 29 of the writ petition, full stop. The WBACDCL, comma, however, comma, shall be at liberty to raise a fresh bill on the outstanding amounts, comma, if due from the petitioner, comma, clearly disclosing the exact periods and months for which such outstanding amount was due to faulty reading of meter. Full stop. Upon such bill being raised, comma, in the event the petitioner is aggrieved therewith, comma, it will be open to the petitioner to approach the GRO afresh with a challenge against the same. Full stop. If so approached, comma, the GRO shall decide the issue afresh without being prejudiced in any manner by the previous observations made by the GRO or the ombudsman or this court. Full stop. Next para. No orders to cause, urgent certified copies.
But he will be obliged to go on paying the regular bills. Yes,
I have not touched that. That is not the subject matter here.
Well, they are not accepting without payment of a previous bill, my lord.
I have set aside that.
Yes, my lord.
Yes.
Item number 14.
Apply for the petition.
Yes.
Well, identical issue, my lord. Here, my lord, page, only page, my lord, the.
Which page?
My lord, page is different, my lord. The order of GRO is, my lord, page 31. My lord,
which page? The bill?
Bill, my lord. Just a minute, my lord. Bill, my lord, page 26, my lord, the bill for the month of, my lord, February, my lord, then, my lord, page 27 is the, my lord, page, my lord, 28 is the impugned bill. 28, my lord, page, April 2022, my lord. Can we have a look, my lord, the previous reading, my lord, the March, 4th March 2022.
I'll pass the same order, Mr. Naik.
Only below small submission, lord.
Yes.
Page 38, lordship comes.
38?
That's the order of the ombudsman.
Yes.
They have challenged the Milord enter the observations of the GRO. I do not know exactly what the Milord facts and figures are there. But his observation is this: matter was fixed twice before the ombudsman, but he Milord preferred to remain absent. So ombudsman could not Milord apply his mind on the issue. And for the fault of the petitioner, he did not Milord, he is again preferring the repetition on the same, he is taking the same plea, which is not Milord equally applicable here. Because since he has approached the ombudsman, that his fault, he did not attend the court.
Yes, you did not attend on 2 dates.
One of the it's fault on the part of the counterpart of my petitioner, my lord, due to his sudden indisposition, he the advocate not appeared, my lord.
অত কথা লেখার দরকার নেই, এটা ছোট করে দিন। The petitioner has challenged the order of the ombudsman, whereby the ombudsman has dismissed the challenge of the petitioner on the ground of repeated absence of the petitioner. For sub next para, the facts are that the petitioner was aggrieved with an exorbitant bill raised by the WBACDCL, which in the perception of the petitioner was not justified. First of the petitioner approached the grievance redressal officer. First of failing there, comma, the petitioner took the challenge before the ombudsman, but due to his absence on 2 repeated occasions, comma, the ombudsman dismissed the matter for default. Full stop. Next para, learned counsel for the WBACDCL submits that in view of the conduct of the petitioner, comma, the ombudsman did not have the opportunity to decide the matter on merits. Full stop. Although the ombudsman could not be said to have palpably erred in law, since the petitioner repeatedly chose to remain absent, comma, For the ends of justice, comma, the ombudsman ought to have taken a more lenient view and given another opportunity to the petitioner to present his case. Full stop, next para. Accordingly, WPA 26309 of 2023 is disposed of by setting aside the impugned order of the ombudsman dated April 20, 2023 and directing the ombudsman to give a fresh opportunity of hearing to the petitioner and the WBA-CTCL and thereafter to adjudicate the petitioner's challenge on merits in accordance with law. Full stop. It is, comma, however, comma, made clear that if the petitioner remains absent on the date next fixed by the ombudsman, within bracket, upon prior notice to the petitioner, bracket closed, comma, it will be open to the ombudsman to take appropriate steps on the challenge. Full stop, no address to cause urgency.
During pendency of the proceedings,
Your fault, this one. Yes.
Get fruits. Item number 15.
Mr. Chattopadhyay, what is the matter?
Matter, my lord, in
What is service? What about service of copy? Please check up whether good service has been effected.
Only state. Only a state. Only a state.
Only?
State.
State has been served.
State has already been served.
What about the others? Backward classes have to be served. What is the matter about? Let me see the service. You have not sent to the other respondents. Oh, then it goes out of the list. Normal hearing. File the affidavit service. The affidavit of service filed today shows that the service has been effected only on the state and not the other respondents. Full stop. Next para. Accordingly, let the matter be listed under the regular heading tomorrow. এটা আবার regular heading এ চলে যাবে, আর upgrade থাকবে না. Next.
Item number 16.
Yes. Yes, please. What is the matter?
This is matter relating to the connection of electricity. This is second time litigation, my lord. Earlier occasion, my lordship was pleased to pass, give direction to supply the electricity to the.
Please file your affidavit of service.
Yes, my lord. After the filing.
Private respondent has been served.
Yes, my lord.
Yes.
After the filing of affirmation, my lord, I have.
Yes, what happened?
I don't know whether upgradation has been notice given to the.
Yes. What is the matter about?
Matter, my lord. The petitioner is the roadside shop owners. They applied for the electricity. Due inspection, meter board was built by the cost of the petitioner. Suddenly, in the meter board of the petitioner, private respondent block meter was supplied. Petitioner make representation to the.
If a block meter has been supplied to the private respondent, you can also take connection from there.
Yes, my lord. My lordship was pleased to pass an order. My lord, come to page.
Kindly your lordship's order.
My lord. Earlier occasion.
No, that's annexed here. Okay,
The necessity of the block meter, purpose
from
of
the block meter, yes. Then what happened after this?
Thereafter, my lord.
Para 7, I've seen.
Thereafter, my lord, the order of my lordship was communicated, that is page 26, with the request to.
So they have not given that connection?
Yes, my lord. Thereafter, my lord, come to page P6, page 32.
Yes.
Only one line order, my lord. You are requested to contact respondent number for getting electricity connection. And spaces. And my lord, next page, page 33, the private respondent also are requested to supply the electricity. These are the order of the respondent number 4.
So they have to be given independent connection from that meter by a sub-meter.
I'm telling you, lordship.
Yes, my lord.
What happened is, kindly show lordship's order, my lord.
You have seen my order. You will give connection.
I'm just saying. Kindly see Learned Council appearing for the CSC Limited submit that already there is an existing block meter in the name of the respondent number 6 from which the petitioner requirement are to be catered. Number what happened, these are the shops, unauthorized shops in the area.
Maybe.
Number kindly, but there are block meters. Pursuant to lordship's direction, a block meter has been installed. Number he has to take the connection from that block meter because that is the order. Kindly see the portion.
Yes.
Now, my lord, now dispute between them. They are not, my lord, now the person is not, my lord, the whatever connection others has already been taken. Others has already been taken. Now kindly see, my lord, your lordship order, my lord, but paragraph 4. Learned counsel appearing for the private respondent submits that the petitioner are not licensee or otherwise related to the respondent number 6. However, it transfer from the regulation cited by the learned counsel for the CSC Limited that there is no necessity of the other consumer to be any jural relationship with the person in whose name the meter stands. The block meter is only for the purpose of enabling proper connection being given to all the consumer in the congested area in order to take care of apprehended electricity and fire hazards. Thus, the objection of the respondent number 6 does not have any legal stand. This WPA.
You are granted police help for this purpose only.
We have already, my lord. Now, what happened, my lord? In spite of the same, we could not. Now, what happened, my lord? Now, my lord, we have to install another block meter. We have to install another block meter. If he wants, my lord, the separate connection, now, my lord, we have to take, my lord, the separate, my lord, block meter, my lord.
Why? There's a specific direction of this court. With police help, we have to give from that block meter only. That impression was given to the court that if there's a block meter, they can take an individual connection from there. Why should he be dependent on respondent number 6?
Now, my lord,
no, Mr. Mukherjee.
My lord,
I'll keep it day after tomorrow, give the connection by tomorrow.
my lord, kindly
From that
come
block
to
meter.
page
Take police help.
42, my lord. The block meter in the name of Rita and 5 others. In 5 others, we are.
Yes, Mr. Mukherjee, give the connection tomorrow.
And, kindly keep it on, my lord, Friday, my lord.
Very well. Learned counsel for the petitioner points the affidavit of service filed to be kept on record. Full stop. None appears for the private respondent. Full stop. Learned counsel for the petitioner points out that by a previous order dated October 6, 2023, passed in WPA 21763 of 2023, a specific direction was passed on the CS Limited to give electricity connection to the petitioners from the block meter existing in the vicinity of the shop rooms of the petitioners, subject to compliance of all formalities by the petitioner within a fortnight from that date. Full stop. Police help was also given to the CS Limited if so required at the cost of the petitioner. Full stop. Next para. Learned counsel for the CS Limited cites the objection taken by the private respondent while giving such connection. Full stop. It is submitted that the block meter is standing in the name of the private respondent. Full stop. Next para. A perusal of the order of this court dated October 6, 2023 shows that the private respondent specifically took an objection that the petitioners are not licensees or otherwise related to the respondent number 6 and should not be given an electricity connection. Full stop. Such objection was categorically turned down by this court by observing that there is no necessity of the other consumers to have any jural relationship with the person in whose name the meter stands. Full stop. It was observed that the block meter is only for the purpose of enabling proper connection being given to all consumers in a congested area in order to take care of apprehended electricity and fire hazards, and the objection of respondent number 6 does not have any legs to stand on. Full stop. It is not understood as to why the CAC Limited failed to literally interpret the said order and give the connection by now. Full stop. As rightly pointed out by the petitioner, since the block meter is for the purpose of giving connection to several persons and merely the first consumer is named as the private respondent, it was the bounden duty of the CAC Limited to already have given connection to the petitioner with police help. Full stop. Having not done so, the CAC Limited shall do so immediately. Full stop. Next para. Hence, the CAC Limited is directed to give an electricity connection to the petitioner from the existing block meter in terms of the order dated October 6, 2023 within 48 hours from now. Full stop. Next para. The matter shall next be listed on April 26, April 25, Thursday, Mr. Mukherjee.
Madam, can it be 72 hours? Kindly keep it on Friday.
Acha, very well. 48 na kore 72 hours. Full stop. The matter shall be placed under the heading to be mentioned on April 26, 2024 for passing further orders when the CAC Limited shall apprise this court of the compliance of the above direction.
My lord, only yes,
But only one.
Within 72 hours, they'll give you that connection from that block meter.
electricity will be given from the block meter through a sub meter, my lord.
Through
One or-
sub meter, my lord, there was not.
The sub meter you have to install.
Yes, my lord. Seriously,
Yes.
they are,
You do whatever you have to do, Mr. Mukherjee. Ensure that your client
I
cooperates with him.
they have not done.
No,
the
Mr.
report, my lord.
Both of us cannot speak together. Mr. Mukherjee, please ensure that your client cooperates and he is informed what he has to do.
We have
No, I don't want to see any paperwork. I want to see the electricity connection being given.
Absolutely, he asked for submitting.
I want to see the connection being given. Mr. Mukherjee, I'm not interested in your
only
literature.
one submission, can I?
No. Next.
Number 17.
My lord, 17 to 30, my lord, analogous matter, my lord, this is the educational loan.
17 to 30?
Yes.
Only one. Only police shall be
Educational loan.
আচ্ছা previous order টা আরেকটা line add করে দিন
My lord, I have annexed.
if necessary
page
police help
29.
shall be given at the cost of the petitioner for such purpose. Yes, I'm sorry, Mr.
My lord, in item number 17, I'm appearing,
17 to 30, what is the commonality between the matters?
My lord, respondent
from you
number
appearing.
8, it will be respondent number 8, SBI. Branch loan.
So what is the matter about? Education loan?
Application has been made for educational loan, but that has not been considered into.
You are for the bank in
I'm
another
for
matter?
the bank, my lord, we both are for the bank.
I have
My lord,
annexed.
All five of you are for the
My lord, in item number 17.
My lord, I have
You open the
annexed.
case first. That has been refused or not considered?
My lord, in 17.
Not considered.
My lord, I have been a little bit indisposed in item number 17
My lord,
because today I have received the instruction over phone to appear in this matter.
You have appeared.
Other advocates will appear. I do not know the some
Consideration of representation.
Consider,
Mr.
my lord.
Aha, if you are indisposed in that also, should not practice in court.
Respondent number.
Should not have
8.
studied in our college also.
Respondent number 8.
My lord, one thing, my lord.
I'll say the respondent bank. That will be a common order for all.
No, my lord. Not all matters are not common.
Not respondent number
All
8.
matters are not common.
Matters are common with regard to education loan.
Different.
Even the banks are common, but in some cases we have already rejected. And in some cases disbursed.
That has
Some
not
cases-
been communicated.
In some cases
Let me
disbursed.
take up one minute.
Item number left.
First, item,
Lordship, I am appearing on behalf of Punjab National Bank, item number 25.
item 17 is being called on. Yes.
My lord, will
Which page
be
is the
considered
representation?
by the page, your lordship's order, page 27. That they consider the respondent number
There was a
6,
direction.
8. 8 will consider. A different matter.
Oh, achha, this is a different. Where is the representation I'm asking?
Page 25. That is the application.
Page 25 is the application. Achha.
Yes, my lord. Your lordships have considered the.
Who is for the
Annex
bank in this
22.
matter? Item 17.
My lord, I am appearing.
I'll direct you to consider the representation within a limited
If not
period.
already done, my lord. I do not know because some of the cases they
Very
have.
The grievance of the petitioner is that the petitioner applied for education loan, but her application has not yet been considered by the respondent bank. Full stop. Learned counsel for the bank seeks some time to take instructions regarding whether the representation has been already considered or not. Full stop. However, comma, in view of the innocuous nature of the prayer, such prayer is refused. Full stop. WPA 28027 of 2023 is disposed of by directing the respondent bank to dispose of the representation of the petitioner annexed at page 25 of the writ petition, if not so already disposed of, comma, within a fortnight from date, comma, if necessary, upon giving an opportunity of hearing to the petitioner, comma, in accordance with law, and immediately thereafter to intimate the outcome of the consideration to the petitioner. Full stop. In the event such representation has already been considered, comma, the bank shall communicate the outcome of the same to the petitioner within a week from date. Full stop. In the latter event, comma, the petitioner will be at liberty to challenge the outcome of the same if agreed. No address to cost. Prathame affidavit is filed to be kept on record.
Next 18, my lord, identity.
My lord, item 18 number,
Number
item
18.
number 18, my lord, this has been rejected, my lord. In view of the fact, my lord, it is,
Give a copy of that rejection to him.
my lord, I have
But that
received
is
today,
not communicated to us.
not communicated.
I can record it has been rejected.
It has, my lord.
The next matter. Affidavit is filed to be kept on record. The petitioner contends that her application for her application for education loan has not been considered by the respondent bank, which is refuted by learned counsel for the bank, who contends that the bank has rejected the said application. Full stop. Learned counsel for the bank shall hand over a copy of the decision of the bank rejecting such application to the petitioner within 48 hours, full stop. Next para, since in view of such rejection, comma, WPA 28032 of 2023 is disposed of as infructuous with liberty to the petitioner to challenge the subsequent rejection by the bank by way of a fresh writ petition.
If no order has been passed in.
I will supply.
Then he'll be guilty of contempt.
48.
Personally impede Mr. Shahad.
Item number 19.
19 identical issue.
Identical with which one? Previous or this?
17.
Let the bank speak. Yes.
19 and 20, my lord. Just now I check up on the phone. I am told that amount have already disbursed. But I have not written instruction. I have not got.
Achha, very well. I'll keep
if
it.
Not, if
no, I'll keep it day after tomorrow.
No, my lord can.
If not, then they, your lordship kindly dispose of. If not, then I shall take the.
Take what? Then you will have no remedy.
Steps, if it is given.
If not considered in the meantime, the line will be.
They will, if not
consider,
like the immediately previous matter.
Consider the matter. If not considered in the
so that is the previous order, just the previous order. তাহলে মাধববাবু এটা previous order যে ওই যেটা consider হয়নি, just আগেরটা যেটা।
That I have annexed.
Affidavit of service filed to be kept on record. 19 আর 20 similar order আলাদা আলাদা করে copy paste করে দেবেন। একটা দেখিয়ে নেবেন আমার।
দিয়ে দে। Affidavit of service টা দিয়ে দে।
Affidavit of service filed to be kept on record. Learned counsel for the petitioner argues that the petitioner's representation stroke application for education loan has not been considered by the bank. Full stop. Learned counsel for the bank refutes such contention. Full stop. Next pair.
Not refutes, my lord. I've just got the instructions.
Learned counsel for the bank is not equipped with appropriate instruction as to whether the said representation has been decided in the meantime. Full stop. In view of the innocuous nature of the prayer, comma, there is no necessity to keep the matter pending. Full stop. In the event the bank has not considered the representation of the petitioner, comma, the bank shall do so within a fortnight from date and comma, giving an opportunity of hearing to the petitioner if need be. Full stop. Immediately thereafter, comma, the outcome of the consideration shall be communicated to the petitioner. Full stop. In the event the bank has already decided on the petitioner's application stroke representation, comma, the outcome of the same shall be communicated to the petitioner within a week from date. Full stop. The petitioner shall be at liberty to challenge, comma, if aggrieved by the said outcome, comma, by way of a fresh writ petition. Full stop. WPA 28035 of 2023 is disposed of according.
Then 21.
And 20 also same order, but different.
Then 21.
21 is for the bank.
21.
What instruction?
As like a
not yet considered. If it may be considered.
Well, thank you. Rejected. The petitioner's limited affidavit of
service.
Go on filing the affidavit of service.
Yes, ma'am.
The affidavit of service filed to be kept on record. The petitioner's grievance is that the petitioner's application for education loan has not been considered by the respondent bank. Full stop. Accordingly, WPA 28046 of 2023 is disposed of by directing the respondent bank to consider and dispose of the representation stroke application of the petitioner for education loan within a fortnight from date, comma, if necessary by giving an opportunity of hearing to the petitioner. Full stop. The bank shall, comma, immediately thereafter, comma, communicate the outcome of the same to the petitioner. Full stop. The petitioner will be at liberty to challenge the said decision of the bank if aggrieved by a fresh writ petition. No address to cost. 22.
Next on, my lord, Central Bank of India.
22, who is appealing for the bank?
Central Bank of India, Union of India is represented.
You are for the Union of India.
Yes. Then your lordship's order is 28 page.
Affidavit of service filed to be kept on record. Despite service, none appears for the bank, although the petitioner and the Union of India are represented through counsel. Full stop. In view of the innocuous nature of the prayer, further service is not directed. The petitioner's application for education loan has not been considered by the bank till date. Full stop. Accordingly, WPA 28053 of 2023 is disposed of by directing the respondent bank to dispose of the petitioner's application for education loan, comma, if necessary by giving an opportunity of hearing to the petitioner, comma, within a fortnight from the date of communication of this order to the respondent bank. Full stop. Immediately thereafter, the bank shall communicate the outcome of such decision to the petitioner. Full stop. If aggrieved thereby, comma, the petitioner will be at liberty to challenge the same by way of a fresh writ petition. No orders to cause. Urgent certified copies. The parties shall act on a server copy of this order for the purpose of compliance. Please serve a copy because 2 weeks from that service.
My lord.
Next.
23
Number 23.
23 bank.
Union of India.
Union Bank of
Union Bank of India.
Who is for the bank?
Union Bank of India. Nobody is.
Same order as the just previous one. Union is present, but bank is not.
Yes, present.
Union is present, but bank is not. Yes. Next.
Union Bank.
Item number
Let it be
24.
called. You are for the bank.
My lord, I am for the bank.
You are for the union.
SBI, my lord. SBI.
SBI, you are Mr. SBI.
In this
Yes.
matter, my lord, what happened? The
Such a big
petitioner
file.
is not visiting the branch with all the original documents. Because they are saying unless the original documents are verified at
এটা একটা order record করুন মাধববাবু 24
24, my lord.
Observation having.
the petitioner alleges that the respondent bank is sitting tight over the petitioner's application for education loan, comma, whereas the respondent bank alleges that the petitioner is not appearing before the bank with relevant documents despite being asked to do so. Full stop. Next para, the problem can be resolved if the petitioner appears before the bank with the necessary documents as sought by the bank. Full stop. Learned counsel for the bank shall, comma, by tomorrow, comma, communicate in writing to his counterpart appearing for the petitioner as to what exact documents or nature of documents are to be produced by the petitioner before the bank. Full stop. Upon such communication, comma, the petitioner shall approach the bank with such documents personally. Full stop. Upon such approach being made, comma, the respondent bank shall decide the petitioner's application within a week thereafter and communicate the outcome of such decision to the petitioner immediately thereafter. Full stop. The petitioner will be at liberty, comma, if aggrieved, comma, to challenge such outcome by way of a fresh writ petition if required. Full stop. No orders to call. WPA 28066 of 2023 is disposed of in the light of the above observations without any orders to cost. So, Mr. Shah, you have this responsibility within 48 hours. You have to give in writing to her. Please take her address and communicate the copy. Yes, next.
Item number 25.
25, my lord.
Bank.
Punjab National.
My lord, I am appearing on behalf of the Punjab National Bank.
Yes.
Lordship, in this case, Lordship, some necessary document are required to approve the loan, Lordship.
What
The petitioner is
What necessary?
he is some relevant document to approve the loan. Petitioner is not submitting to the concerned branch, Lordship.
Yeah,
That is why the
yes,
application is pending.
I understand. I'll pass an exactly similar order as the last one. I'll say that you take this but within 48 hours, within 2 days, please communicate to your learned friend in writing as to what are the documents required.
Lordship, Lordship.
Exactly the same order as the previous one. ওই bank document দিচ্ছে না? Next.
Mr.
Union of India.
Just give your names. Yes.
Item number 26.
My lord, in 26, I beg to appear on behalf of Union of India.
Union of India.
I'm for the bank.
Bank. What has the bank done?
Mala not yet considered.
Very good.
Branch manager, PNB.
20. This is item 26. 26, Madhababu.
Mala could be a same order as 17, your lord.
17. Thank you very much for that. 17 এর সঙ্গে
I shall provide her copy of the petition.
Thank you, Mr. Yes.
27.
হয়ে গেছে
27.
Item number 27.
Bank of Baroda.
7. I appear on behalf of the bank, my lord.
Have you considered?
My lord, they haven't communicated yet, my lord.
Well, I'll direct you to decide it. Consider it and decide within fortnight. Oh, it's same as 70. Madhababu, same as 70. Please consider and
Item number 28.
28
SBI. Considered?
No, my lord, it was considered from. I was not satisfied. I tell
70.
consider it again.
17. Madhababu,
27, my lord, in 27, I was appearing.
just give your names, whoever you are appearing for.
Yes.
Make sure that you are actually appearing. It's a
No, my lord, 27, I am there for Union of India.
I understand. This
For
is just,
Union of India.
just ask your junior to give your name so that it is recorded.
All right.
Used. In other matter, my lord, what happened in this matter
29,
28, institution is not matching.
Yeah,
Name of
Bank
the
of
institution
India.
is not matching. So, my lord, in one matter,
Then decide.
one
Dismiss.
matter, my lord told that you consider it leniently. Do not be so harsh. So, I told them to consider it again.
Thank you very much. Education loan, Mr. Shah, you understand.
Yes.
All of us may have suffered someday. Yes.
29 my Union Bank of India, Miss Gosal. Miss Gosal, my lord.
No. She is consistent for the union, but the bank is not consistent.
Union Bank of India, North.
Achha, none appears for the petitioner, for the bank. Despite service, affidavit of service filed to be kept on record. The innocuous prayer of the petitioner is that the bank is not considering the petitioner's application for education loan. Full stop. Accordingly, WPA 666 of 2024 is disposed of by directing the respondent bank to consider and decide the application for education loan filed by the petitioner as annexed to the writ petition within a fortnight from the date of communication of this order to the bank, by acting on a server copy of the order. Full stop. Immediately thereafter, the decision will be communicated to the petitioner. Full stop. If aggrieved thereby, the petitioner will be at liberty to file a fresh writ petition against the said decision. No address to cost.
30 same as
30.
previous one.
17.
Same as previous one. 29.
Oh, 29. None is appearing.
My lord, item number
Union Bank is same.
My lord,
Madhav, 30.
item number 20, 29, 41.
51 chapter. Next.
32.
You are appearing in for Union of India.
Yes, you also Mr. Partha.
Then give your names.
Lordship.
But then 32.
SBI.
I am for the
31, let it be 31 be called on.
Number 31.
31, who is it?
31, my lord, I am for the private response.
Private response. Who is for the petitioner? 31.
My lord, I have, my lord, pursuant to your lordship's direction, my lord, my affidavit of in opposition is ready. But I am sorry, my lord, I could not serve because the, my lord, learned advocate for the petitioner, he is not attending the phone. My junior, my clerk, myself also. Thereafter, my lord, I sent this opposition to the petitioner. That was written with the postal endorsement that there is no such person is.
No, keep it with you. Keep it with you. Keep it with you, Mr. Rao.
Sir, we were also directed to file the AO manner. I have served the petition.
The affidavits in opposition filed today be kept on record. Full stop. None appears for the petitioner at that time.
I'm upon the petitioner, my lord. I beg to upon the petitioner.
You could not, you did not pick up the phone of Mr. Rahman. That's why.
Lord, I have not received, lordship, any I have received the affidavit opposition of the CSC Limited, lordship.
My lord, he is not attending my phone, my lord. My junior, my clerk, my lord, he is sitting with my lord, bar assistant, room number 18. I am sitting in room number 13.
Can you give a copy right now?
My lord, yes.
Full stop. Affidavits in opposition filed today be kept on record. Full stop. Since the affidavit in opposition of respondent number 6 could not yet be served on the learned advocate for the petitioner, the same is a copy of the same is handed over here and now by learned counsel for the respondent number 6 to the learned advocate for the petitioner. Full stop. The time for filing affidavit in reply is extended for a week from date. Full stop. The matter shall be listed on April 29, 2024 under the same heading. Please
I'm grateful, lord.
Thanks.
Item number 32.
32, yes.
SBI.
SBI. Who is for the SBI?
I am for
Not considered. Not sure.
no, why not the same case? My lord, I told them to consider it.
Thank you very much.
Partha Ghosh appearing for the Union of India.
32 টা 17 মানে ওই appear করছে direction. Like 17. Please consider within 2 weeks and usual. Yes.
Item number 33.
Please, your lord.
Yes.
চলবে এটা তোর এটা
Mr. Bose, you can probably provide the education loan yourself after today.
Another 3 matters there. 37, 38, 39.
Oh, other matters. Those matters I'll direct you to provide the education loan to your client by waiving your fees. Yes, who is appearing in this matter? This is item 33. You are for the petitioner.
Respondent number 7.
Yes.
My lord, I'm appearing on behalf of the petition. I'm being led by Mr. Kaushik Gupta, my lord. Can I get a short pass over?
No pass over. Start the matter. Otherwise goes down.
My lord, affidavits have been exchanged, my lord.
So what? You're enjoying an interim order?
No.
I'll put it in the regular list then.
My lord, kindly grant me a short
No.
pass over. My lord, he's on his way.
No. No, an adjournment is sought on behalf of the petitioner. Full stops. let the matter be adjourned for the day and be listed now under the regular heading. Next matter.
नाम दिए थे Item number 34.
34, who is appearing
I
for?
am appearing for the petition.
Yes, please come. Yes, what is the matter?
Well, I for the state respondents, my lord, along with KJ Yusuf, my lord.
Yes, please file your affidavit of service. Right. Affidavit of service.
My lord, affidavit of service.
What is the grievance?
Page 7 shows that the private respondent has received it, then refused, therefore returned to me.
Move it.
Yes. My lord, the petitioner is a tenant with respect to the ground floor of the premises in question.
You agree that due to resistance of the landlord is not being
They have
given?
caused inspection, but the meter room remains inaccessible. Page 31, my lord.
I'll direct police help for inspection as well as if feasible, then give the connection.
Grateful, my lord.
Affidavit of service filed to be kept on record. Full stop. Despite attempt to serve, comma, the envelope sent to the private respondent has returned as refused, comma, denoting good service. Full stop. Since the other respondents and the petitioner are represented, comma, the matter is taken up for hearing. The grievance of the petitioner, comma, a tenant in respect, an alleged tenant in respect of the premises in question is that due to resistance by the respondent number 6 landlord, electricity connection cannot be given to her. Full stop. Even inspection could not be held due to resistance of the said private respondent. Full stop. Learned counsel for the CESC Limited corroborates such contention. Full stop. Since the petitioner, comma, as an occupant, comma, has a right to get electricity connection, comma, the resistance on the part of the respondent number 6 on the ground of purported legality of such possession is not tenable in the eye of law. Full stop. Accordingly, WPA 2019 of 2024 is disposed of by directing the CESC Limited to hold an inspection at the premises in question for the purpose of ascertaining the feasibility of giving electricity connection to the petitioner from the existing meter board position within a week from date. Full stop. If it is found so feasible, comma, and pursuant to compliance of all formalities by the petitioner, comma, such connection shall be given by the CESC Limited to the petitioner within a fortnight thereafter. Full stop. Next para. Either at the juncture of holding the inspection or giving such connection, comma, in the event the CESC Limited personnel are obstructed in any manner by respondent number 6 and or her men and agents in doing so, comma, to the CESC personnel to approach respondent number 6, comma, the officer in charge of the Koraya police station.
Respondent number 5.
Respondent number 5. To approach respondent number 5, the officer in charge of the Koraya police station for adequate police assistance. Full stop. If so approached, comma, respondent number 5 shall act on the server copy of this order and provide such assistance to the CESC Limited at the cost of the petitioner, comma, if necessary, removing any hindrance stroke padlock if put in the way of access of the CESC personnel to ensure such access. Full stop. No arrest to cause urgent certificates.
Grateful. My lord, I sincerely apologize, my lord.
No, Mr. Gupta, I have to be consistent for all.
Came running from the other.
It will be in the list, but on a regular heading.
Kindly.
Your junior should have started, Mr. Gupta. You should prepare him.
No, I told my junior, maybe he got a bit apprehensive.
No.
I came running from the
No,
other
Mr.
room.
Gupta. No, I'm sorry.
Kindly makes it not today, my lord.
No, I've made it not today, but it will appear under the regular heading, not under this heading. I cannot afford that.
My lord, if it's under.
Mr. Gupta, even 1 minute is precious. I'm sorry. Call on the next matter.
Item number 35.
Yes.
35, my lord, I'm the respondent bank, my lord. As per your lordship's direction, my lord, I'm filing my opposition.
My reply, my lord.
There is a reply, my lord, which is provided to us, my lord. There is no annexure, but in the reply, they are saying that.
No annexures. I'm not.
No, they are not. They have not annexed in my.
Mentioning annexure.
Oh, wrongly. Yes, Mr. Faraduddin, what is that?
My lord will kindly see the opposition. My lord, the plain thing is that a retired pensioner from his account, for what reasons they have been deducting? Nothing. One application, he was a co-borrower. At that point of time, yes, he has given an authority. Subsequently, after the entire balance has become zero, he says no more, nothing. Then he started again deducting. My lord, I'm being covered by, they have not.
The balance is zero. How can they deduct? From your pension, monthly
Yes,
pension?
My monthly pension. Because 7,000.
This is their submission, my lord.
They have not.
Yes, what do you say to this?
My
Let
lord.
me hear you first, then they'll.
Yes.
Yes.
My lord, the petitioner took loan in the year 2012 with for education loan for daughter, where he is a co-borrower.
Yes.
My lord, there,
Mr. Ghoshal, please take the microphone a bit closer.
my lord, where he is a co-borrower, my lord. In my lord,
Co-borrower with his
daughter took education loan 2012, my lord. thereafter, my lord, from 2014, the petitioner retired in 2014, my lord. The bank gave several legal notices to him and his daughter for recovery of the loan, legal notices. He replied one after another, my lord, from Annexure R4, page 55, where he says that I am the retired bank employee, I am getting only 2,000 rupees. Kindly wait for some time. I am paying that amount from my pension account when the pension will be started. In 2018, my lord, the pension from the 1st April 2018, as per the order of the Apex Court, my lord, the pension of the rural bank employees has been started and petitioner get the pension. Again, my lord, the legal notice issued by the bank to the petitioner and, my lord, the daughter of the petitioner. The petitioner written in his pension scheme that, my lord, there is a loan due amount of 5,84,000 pension scheme, and if it is lost cost to the bank, it will be given as per Form 9 of the bank to the bank. Thereafter, my lord, again petitioner asking for the money for the legal notice. He given a letter to the bank that kindly deduct it amount from my pension account and recover the loans.
Where is that letter?
My lord. The last letter, my lord.
Last letter,
my lord. Page 78 of the opposition, my lord. Thereafter, several letters. There before that.
So that's why you're deducting from that.
Yes, but thereafter, my lord, page 79, it was before the board meeting and it is confirmed and then deduction done.
Yes, what do you say? Your repeated letters.
My lord, they have repeated letter, but my lord, my answer is to this is that if I have given a letter at that point of time, then I have revoked it by subsequent letter. And how can, because my pension amount was withheld. They were not releasing the pension amount for long years. After the Supreme Court guidelines, my lord, my pension amount was released. And then when I have asked from them by way of RTI application, what is the balance?
You have authorized them to deduct.
My lord.
Repeatedly, not once.
No, once only, my lord. Only once, then no. This is wrong submission, my lord.
No, আমার দিকে তাকে submit করছে, sir.
Acha, only once it
Only
was.
once they did it.
Yes, only once.
My lord, he requested every occasion.
In writing, he said only once.
Only once, my lord.
Prior to that, my lord, in a pension scheme, she also, my lord. Page.
Acha, I'll come back in 5 minutes and hear you.
Lordship.
Yes.
Yes, my lord will kindly come to my writ application, first of all.
Yes.
Paragraph, my lord will come to paragraph 3, my lord. My lord, I've stated, my lord got it.
Yes.
Page 4.
Yes.
Your petition states that although your petitioner retired on 30th of November 2014.
What is your present age?
My lord?
Age?
Age is now, my lord, 69.
Yes, please continue.
Yes. Retired on 30th November 2014. On superannuation, he has been receiving his bank pension on and from 1st of April 2018. My lord, this was not within the ambit of the Supreme Court judgments and the circular issued to the bank authorities. My lord, he was denied pension. I most respectfully submit, my lord, he was denied his pension for all these years, rather than the day following the date of retirement or superannuation on
You are an employee of this bank only?
this bank only, my lord.
Oh.
And what happened, my lord, after at the initial time when my daughter needed a loan very much for her educational career, I said, I'm a co-borrower, I'm allowing you. My lord, subsequently, my lord, I have said that you can deduct this from my arrear account.
From your?
From arrear pension amount, which they have still not paid. My lord, they have...
There are two separate accounts. Arrear pension and...
Yes, my lord, I am entitled to my pension from, my lord, from the date of eligibility is 1st December 2014. But they started paying me from 1st of April 2018.
In the interregnum, that period was never paid to you.
Never paid.
So you say you can adjust from that.
Exactly, my lord. That is my only case. I have stated what the letter they have shown, it is stated that you may deduct from the arrear, my lord. My lord, kindly come to the letter now.
Yes, let us come.
Lordship. My lord, the annexed their affidavit in opposition annexure R9, page 78.
I'm there.
Lordship.
I'm there.
Lordship. The last para, my lord.
Yes.
Since I am not going to receive any bank pension for the month of February and March 2019, I do hereby authorize the bank PGBD to deduct monthly installment of said educational loan as usual from the amount of pension payable to me by the bank with immediate effect. And in this connection, I may further assure you of pay of entire overdue amount and other authorize the bank to deduct the same from the pension arrears, oblique the amount of commutation payable to me by the bank. Still, they are sitting tight over the matter.
Mr. Farhaduddin, was there any direction, order of court to pay pension to you?
My lord, those writ applications are pending and there is a Supreme Court guidelines, my lord, I can show that.
Please show that.
Yes, my lord. My lord will kindly see.
Yes.
And the government guidelines. These are the two.
So in terms of that, it has been started being disbursed from 2018.
Because instead of, my lord, the actual date of retirement they have given, but at a belated stage. I am entitled to the pension from that date.
Justice Kurian Josephs, this is only an order disposing of.
Yes, my lord, the disposing of the earlier order that was passed in the Karnataka court and regarding the pension.
What is the substantial portion of that order?
My lord,
must be in the communication. What is the original judgment? I'm just
original judgment is of Justice,
that
my lord,
Mr.
Justice Kabir. My lord will kindly see. From the pension account, it's no order, no amount that is being fallen due of any other things can be deducted. It's a retirement benefit account, my lord.
So Justice Kabir's judgment is on what point?
This,
Section 60.
No, judgment, judgment is regarding that no amount can be deducted from pension account.
That is settled. Section 60 principle is applicable.
Lord. So I am on that, my lord. Good. That's my case, my lord.
Again says, my lord, that issue 2014-2018, my lord, that issue already dealt by coordinate bench, they are again suppressed. My lord, already.
What is this?
My lord, the coordinate bench says, my lord, as the notification came to the light of the day in the 2018, my lord, the pension scheme started in the 18, he will get the benefit of 2018. Already issue dealt by the coordinate bench, entire, my lord, details.
Give a copy to him also.
So they are his case.
No, I'm not there, my lord.
His
This
case.
Give a copy of this
I'm
judgment to
giving
him.
only this matter. Not his case.
Well, let me pass my order.
Yes.
Ash. Sorry. The petitioner was, and both of you can please take your seats. I mean, the petitioner was an employee of the respondent bank and was superannuated on November 30, 2014. Full stop. Subsequently, the petitioner, for some time, was without any pension. Full stop. Ultimately, by a notification which was endorsed by the Supreme Court, a scheme was formulated for grant of pension to employees of the respondent bank, in terms of which the pension started to be disbursed in the account of the petitioner on and from from the month of April 2018. It is argued by learned counsel for the petitioner that although the petitioner agreed to the arrear amounts of pension payable to the petitioner from December 2014 till till March 2018, the same can be used for the purpose of deducting the outstanding dues on account of education loan taken by the petitioner for his daughter, who was a co-borrower. However, misusing the said concession, the respondent bank has been deducting the alleged outstanding dues every month from the pension account of the petitioner, thereby depriving the petitioner of his entire pensionary benefits. Full stop. It is argued that following the principle of section 60 of the Code of Civil Procedure, as endorsed by the Supreme Court in the judgment of Radheshyam Gupta versus Punjab National Bank and another, reported at AIR 2009 SC 930, no deduction can be made by way of attachment for dues from the pension account of a person. Full stop. Next para. Learned counsel appearing for the bank places reliance on the annexures to the affidavit in opposition and argues that the petitioner gave out that the petitioner was agreeable to deduction from the pension account of the petitioner, and only according to such concession by the petitioner did the bank start deducting from such account. Full stop. In view of such specific concession of the petitioner, it is argued by the bank that the present writ petition has been filed by suppression of material facts. Full stop. It is also argued that in a separate matter on the same issue, a coordinate bench by an order dated November 10, 2023, passed in WPA 9956 of 2020, specifically held that the petitioner was not entitled to pension from the date of superannuation, but in view of the notification having coming into force only from the year 2018, the pension would be payable from April 2018. Which it is, thus argued, the petitioner apostrophe's claim of arrears is a non-starter, and as such, there is no scope for any deduction from such arrears. Full stop. Next para. A peculiar predicament arises before the court in the present matter. Full stop. Whereas it is well settled, not only as per the judgment of the Supreme Court cited by the petitioner, but by other line of judgments in consonance with section 60 of the Code of Civil Procedure, which principle is applicable to writ matters as well, comma, that the pension account of a person cannot be attached by a creditor. Full stop. Next para. The present action of the bank in deducting the amounts of dues on account of education loan previously taken by the petitioner tantamounts to attachment of the account and deduction of the same. Full stop. Next para. Thus, comma, in law, comma, there is a specific bar of such deduction stroke attachment in respect of amounts of pension credited to the debtor. Full stop. Next para. The question which arises is how far the petitioner's admission can be held to be binding against the petitioner in the context of the case. Full stop. Next para. Although it is well settled that there cannot be any admission against the law, comma, there is scope of wider interpretation of such concept, comma, since the question here is whether the petitioner can take advantage of a loophole of the law by relying on the said proposition despite having himself agreed to such deduction. Full stop. Next para. However, comma, such proposition advanced by the bank against the petitioner cannot hold water for the following reason, colon, next. A careful scrutiny of the within double inverted admission of the petitioner relied on by the bank as annexed to the affidavit in opposition shows that the petitioner categorically stated that he was agreeable to the bank deducting the overdue amount from pension, তারপর italic say arrears, stroke the amount of commutation payable to the petitioner by the bank. Full stop. Hence, comma, the very premise of deduction as put forward by the bank, comma, that is the purported admission of the petitioner, comma, is not an admission regarding the payment of regular current amounts of pension to the petitioner at all. Full stop. The so-called admission was specifically restricted to the arrears of pension and or commutation payable to the petitioner by the bank, comma, if any. Full stop. The question which arises here is not whether the petitioner is actually entitled to such arrear, but how far the petitioner's admission is binding against him insofar as attachment stroke deduction is permissible from his regular stroke current disbursals of pension. Full stop. Next para. Even if the petitioner has been held by a coordinate bench not to be entitled to any arrear, comma, the same ipso facto cannot be a justification for the bank to interpret the admission of the petitioner in the context of such judgment. Full stop. It is well settled that a statement, comma, to be an admission, single inverted with the admission, comma, has to be unqualified, comma, unambiguous and clear on the issue of the person making such statement having actually admitted the contents thereof. Full stop. The admission of the petitioner was restricted to arrears, comma, if any payable to him. Full stop. Even if in terms of the coordinate bench judgment, comma, the amount of arrears is nil, comma, the admission of the petitioner cannot be extended beyond what was actually stated by the petitioner, comma, which was restricted to such arrears, comma, irrespective of whether the same was held to be payable by a different bench. Full stop. The admission cannot be interpreted in accordance with the judgment of a court or a subsequent decision by any judicial or quasi-judicial authority, but has to be taken as it is. Full stop. Next para. Another aspect cannot be entirely overlooked in the context. Full stop. The petitioner took the loan for education of his daughter and having failed to repay the same, comma, at his advanced years, comma, after having retired from the bank in the year 2014, comma, is in a state of indigence, full stop. Thus, comma, the difference in the unequal bargaining powers between the petitioner and the bank, with all the force of law behind it, comma, is rather evident, full stop. Hence, comma, the double inverted with the admission of the petitioner has to be taken in its appropriate social and economic context as well, and cannot be said to be binding insofar as regular payments of pension are concerned. Full stop. Thus, comma, this is not a case where the petitioner is precluded by principles of equity from claiming the defense of law within the principle of section 60 of the Code of Civil Procedure. Full stop. Accordingly, the action of the bank in deducting amounts on account of unpaid education loan by the petitioner from the petitioner's pension account is palpably illegal. Full stop. Next para, accordingly, WPA 2069 of 2024 is disposed of by directing the bank to restore whatever amount of pension has been deducted from the pension account from the petitioner till date from April 2018 within a month from date, full stop. 1 month, Mr. Ghoshal, so that you can prefer an appeal. Within a month from date, full stop. Please take your seat. I've not called for your arguments. Within a month from date, full stop, the respondent bank shall be restrained by an order of injunction from henceforth deducting any amount from the pension account of the petitioner by way of deductions for the unpaid education loan taken by the petitioner. Full stop. However, comma, it is made clear that nothing in this order shall preclude the respondent bank from taking appropriate steps for recovery of the dues from the petitioner, comma, if any, comma, in due course of law by taking recourse to appropriate legal action as permissible in law. Full stop. Next para, no orders to cause urgent certificate copies. Yes, what were you saying, Mr. Ghoshal?
My lord, his prayer is, my lord, not entered prayer B is, my lord, to refund the 38,100. But my lord, from the 2018, my lord, there is no prayer in the petition.
No, whatever has been deducted from 2018. I've said whatever has been deducted.
No, my lord, from 2018, my lord, given.
You have deducted from 2018?
No, my lord says 2018.
Yes.
I've said whatever I had to say.
Get full, my lord.
Next,
Get
yes.
Party number 36.
এই মাধব ওটা কিন্তু ঠিকই বলছে, আমি বোধহয় বলেছি yes. Yes, who is appearing in this?
Item 36, my lord. I am for the respondent number 7, my lord.
Right.
Led by Mr. Tanmoy Mukherjee. I am praying only for not to take
No,
it
refused.
out of station, my lord.
Refused. Yes, what is that?
PF for the petitioner, my lord, may I file, my lord, the affidavit of service, my lord? I believe, my lord, the respondents are anyway appearing, my lord.
What is the matter?
My lord, this, my lord, is perhaps, my lord, the third round of litigation, my lord. My lord, the petitioner, my lord, had, my lord, applied for new electricity connection, my lord, in the year 2011, my lord. It was not provided, my lord. So the petitioner filed, my lord, an application before the District Consumer Forum. That was allowed, but ultimately, my lord, set aside by the appellate court because, my lord, because of limitation, my lord, technically wrong. Then, my lord, the petitioner, my lord, approaches, my lord, this honorable court by way of writ petition, my lord. In the meantime, my lord, there is a my lord, civil suit pending, my lord, between, my lord, the writ petitioner and, my lord, one of his neighbors, my lord, who, my lord, does not want, my lord, the electricity pole to be, my lord, erected at his, my lord, plot of land, my lord. Although, my lord, there's some dispute with regard there to, my lord, not going into it. So, your lordship, my lord, after hearing the parties, my lord, had filed, my lord, passed an order on 7th of July, 2022, my lord. That, my lord, is at page 31. Only the operative portion I'll show, my lord.
I've directed the district magistrate.
Yes, my lord.
What is the order of the district
magistrate, my lord? Not complied with. So, file and
52.
So
Page
we
52.
file. I'm sorry.
Page 52 is that order?
No, my lord. That order is at page 45.
No, ultimately, district magistrate has decided.
Yes.
Against you. Show me that.
No. In my favor.
So what is your grievance now?
Well, that has not been complied with yet, my lord. Although, my lord,
What does the respondent 7 have to say?
My lord, in that I have to raise the maintainability issue.
Why not
Because,
maintainable?
district magistrate has directed the BLRO to inspect the premises and kindly turn to page 53, my lord.
Yes, 53. Demarcate the outer line.
Outer line, and they have come before my lordship that
They're
they
seeking an implementation of this.
implementation, but against the inaction on the part of the BLRO. Inaction of BLRO is a writ petition under 227 is maintainable. I have
No, you answer yourself also. What is maintainable? Civil suit.
My lord, BLRO, inaction of the BLRO is a special.
What should be done? BLRO should be called in my office and directed.
My lord, there is a special. This is a special statute, and
What
there is
special
a
statute?
appellate authority in the.
Under which provision, sir?
My lord, Land Reforms Act, my lord. BLRO.
The order has been passed by the inaction of the BLRO is under which provision?
My lord, they have.
You have absolutely no idea of what you are talking about. WBLR Act, the Land Reforms Act, the tribunal will act only if it is passed under the West Bengal Land Reforms Act. Is this an order under the Land Reforms Act? Then what are you saying? Mr. Mukherjee has told this to you. Remind me next time when he leads you in a matter.
He has
I'll physically rebuke him and hit him physically.
My lord, Mr. Mukherjee is out of station, and
because Mr. Mukherjee is out of station, the law changes.
No. Instruction.
No, this is a ridiculous
Line
argument.
instruction. My lord can see the.
I can do many things, but what is your other defense? This is your only defense.
Only because in the
I'll direct police help.
in the order, my lord, I have in the previous page 52 last paragraph. I have suggested that both the petitioner and opposition.
There is an allegation against you here.
No.
So then why are you so bothered?
I am just praying for not today because Mr. Mukherjee.
Not today is refused long back. Yes, you must give the report BLNL.
Add to this, my lord. My learned friend just said, my lord, in fact, my lord, they had suggested, my lord, that, my lord.
I'm not on this file.
And
Yes.
they were-
BLNL, how soon will you file your report? Mr. Dev.
Within 4 weeks.
What 4 weeks? File it within a week. BLNL has to go there, demarcate. I'll give you 2 weeks.
But that's our
Election, 2 weeks.
that's the only issue before us also.
Election is the issue before everybody.
No election.
Well, I'll give you 3 weeks. 3 weeks time. Learned counsel for the petitioner contends that the petitioner has been running from pillar to post to get electricity connection. Full stop. After a previous round of litigation, the matter was turned down before the consumer forum in view of the bar of limitation. Full stop. The petitioner approached this court and an order was passed in pursuance of which the matter was referred to the concerned district magistrate. Full stop. The district magistrate has, by the order dated August 18, 2023, annexed at page 52-53 of the writ petition, directed the BL and LRO Ramnagar 1 to demarcate the outer line of the proposed approach road with pegging within 4 weeks from receipt of the order, and the assistant engineer and station manager to extend electricity connection to the resident of the petitioner as per provision of law. And the officer in charge of the Ramnagar was to provide all sort of assistance for enforcement of the order. Full stop. Despite having such order, the petitioner has not yet got such connection in the summer months, it is argued, due to the inaction of the BL and LRO in so demarcating. Full stop. Next para, learned counsel for the WBSCDCL submits that due to no such demarcation having taken place, the assistant engineer and station manager of the WBSCDCL are unable to give such connection. Full stop. Learned counsel for the state submits that in view of the recently commenced elections, the BL and LRO and other state officials are in extreme work pressure for which the demarcation could not be done. Full stop. However, it transpires that the order was dated August 18, 2023, and by now should have been complied with by the BL and LRO. Full stop. Having not done so, giving the widest leeway in view of the ongoing elections, the demarcation ought to be completed within an outer limit of 3 weeks from date. Full stop. Next para, accordingly, WPA 2691 of 2024 is disposed of by directing the respondent number 6, that is BL and LRO Ramnagar -Roman 1 to comply with the direction dated August 18, 2023 of the District Magistrate Purbo Medinipur and complete the demarcation as directed therein within 3 weeks from date. Full stop. Immediately thereafter, comma, the assistant engineer and station manager shall comply with the order of the district magistrate and extend electricity connection to the resident of the petitioner, comma, preferably within a fortnight thereafter. Full stop.
Subject to compliance of all formalities.
Subject, very well, comma, subject to compliance of all formalities by the petitioner. Full stop. If obstructed, comma, it will be open to the WBACDC personnel, comma, also in compliance with the order of the district magistrate Purbo Medinipur, comma, to approach the local police authorities. Full stop. If so approached, comma, the said authorities shall comply with the order of the district magistrate and give adequate assistance for the enforcement of the magistrate's order. No arrest to cause such is it. Thank you.
Grateful also.
I have not recorded your objection. Don't let that go on record. That is not a good objection. Or should I record it?
My lord.
I can record it because if you have to, I mean, Mr. Mukherjee told you to, then there is a bad objection.
That number 37.
Yes.
37. Lordship, I'm for the petitioner.
Yes.
Lordship, same.
Education. Which bank?
Bank lordship, matter number 13.
PNB. You have considered or not considered? Only that is the
I am for the Union of India. I do not know who is applying for the bank, my lord.
Achha.
Whether bank has been served or not.
Very well.
Stop, Lordship.
The affidavit of service filed today be kept
I am
on record
appeared
of the petitioner.
International
Not
Bank
for
lordship.
education loan. Full stop. However, such application of the petitioner has not yet been considered by the bank. Full stop.
Lordship, I am appearing on behalf of the Punjab National Bank in this matter, Lordship. As per instruction from the bank, the loan has already sanctioned in 19th March 2020.
Very well. Give the details, please. Give the particulars. I'm sorry, you're.
Sanction in the name of my lordship. Sanction loan amount 3,75,000.
Have you got any document in that regard?
Yes, lordship. Copy of sanction letter bank through mail, lordship.
So if she approaches you, she can get that loan right now. Thought passover, I'll take up whenever she comes online. Next matter.
Item number 37, 38.
Lordship.
Well, I am for the Union of India, my lord.
Same bank.
Lordship, SBI.
SBI.
Madam, we can-
Considered, Mr. Shah.
Madam, we have rejected. Madam. We have, this is a copy of the rejection letter.
You have rejected. Very well.
I'm handing over the copy.
The grievance of the petitioner is that the petitioner's application for education loan has not yet been considered by the bank, whose learned counsel for the respondent bank hands over a document to the learned advocate for the petitioner, indicating that her application has been rejected. Full stop. Since the said rejection renders the cause of action infructuous, WPA 3949 of 2024 is disposed of as infructuous with liberty to the petitioner to file a fresh petition on the fresh cause of action by challenging the rejection of loan by the respondent bank. Full stop. No arrest to cost. Next. এবার পাসওয়ার্ডটা আবার ডাকুন। Yes, ma'am, you're back. Have you got any document?
Yes, lordship. Sanction letter is there, lordship, and borrower sign is also there.
Hand over a copy. We can approach you and get that loan right now.
Lordship.
Have you paid the amount? They have not got the amount physically.
No, as per instruction from the bank, they have got the amount. Thus, in the sanction letter, borrower has signed the sanction letter also, lordship. Sign is there. And the petitioner, Maina Khatun.
Document, you have to produce the document physically. I cannot take it online.
Lordship, in the second half, I will produce, lordship.
No, I'll keep it tomorrow. I'll keep it tomorrow. Hand it over. Bring extra copies. Give a copy to them also.
Lordship, much obliged.
Learned counsel for the petitioner submits that the petitioner sought for education loan, which was never granted by the respondent bank. Such contention is controverted by the respondent bank. Learned counsel for the bank contends that education loan was granted to the petitioner and was disbursed as well. Full stop. Learned counsel for the bank shall produce necessary documents to substantiate such claim tomorrow when the matter shall be placed under the same heading. Full stop. Learned counsel for the petitioner is also requested to take instruction from her client, from his client on such issue. It will come back tomorrow. the matter will be returnable tomorrow. Take instruction, Mr. Bose. If she has got it, then just be candid. I'll dispose of it.
Much
Yes.
obliged.
Next
Item 39.
Lordship, PNB Bank.
39 PNB, who is a,
same bank, my
I
lord.
am appearing on behalf of the Punjab National Bank in item number 39, Lordship.
what is your instruction here?
Lordship, is the same matter as item number 25. Some essential document is required for sanctioning the loan, Lordship.
So within 48 hours, furnish those. Give a list of those documents required.
Lordship.
I'll pass a fresh order because I have a fresh officer here.
Okay, Lordship.
The petitioner sought for an education loan, but the application was not considered by the bank as per allegation of the petitioner. Full stop. Learned counsel for the bank submits that the petitioner did not furnish certain documents to enable the bank to consider such application. Full stop. Learned counsel for the problem can be resolved if the bank discloses to the petitioner the exact documents required. Full stop. Accordingly, WPA 3954 of 2024 is disposed of by directing the learned advocate on record for the petitioner for the respondent bank to furnish within 48 hours to her counterpart appearing for the petitioner in writing the exact documents which are required by the bank to consider the application for education loan of the petitioner. Full stop. Upon so furnishing, the petitioner shall approach the bank with such documents, upon which, within a fortnight thereafter, the bank shall process the loan application of the petitioner and decide the same. Full stop. Immediately thereafter, the outcome of such decision shall be communicated to the petitioner. Full stop. The petitioner will be at liberty, if aggrieved with such final outcome, to challenge the same by way of a fresh writ petition. Affidavit of service filed to be kept on record, no orders to cost.
Grateful, Lordship.
Yes, much obliged.
37 will appear tomorrow.
Whatever I directed.
Yes.
I've forgotten so many.
Item number 40.
40, Mr. Bhattacharya, what is the matter?
40, I appear for the respondent number 6, your lord.
Yes, Mr. Mondal.
My lord, may my lord, file my affidavit in opposition, your lord.
Yes. Any reply, Mr. Bhattacharya?
He is giving me a copy just now.
1 week. Let this appear under the regular heading. What is the urgency?
An inquiry has been sought to be initiated, my lord.
This
Inquiry
matter
under
has
what
virtually become infractuous, your lordship.
To your lordship's order.
Inquiry under what provision?
My lord, under no provision.
No.
For what? Inquiry to look into what?
Inquiry to look into, my lord, the functioning of an organization at the behest of a person, my lord, who has, my lord, usurped the post of the registrar.
Absolutely, my lord, no. My lord, I
opposition filed to be kept on record. Since a copy has only been recently served on the petitioner, the time for filing reply is extended for a week from date. Full stop. The matter shall be listed on April 29, 2024 under the same heading.
I've served. My lord, the state has not filed their opposition yet.
Let us go through this.
No, your opposition, if Mr. Sen has a copy, then he will be.
I've served them. Deeply obliged.
Item number 41.
Yes, Bishop. What is the matter?
Yes, this is my matter, my lord.
Please file an affidavit of service.
Yes, my lord.
Yes.
I am appearing for the private respondent.
Private.
My lord, there is a connected writ petition which is pending at my instance, my lord, at the instance of the private respondent assailing an order made by the Excise Commissioner in the proceedings, my lord, of 2023 March. My lord, that writ petition.
What is, Mr. Shorkar, what is your challenge here?
My lord, an excise license was, the partnership firm was the licensee. It was comprised of 3 partners.
See, the 2 writ petitions are related. I'll take up both together.
My lord, that your lordship can.
Please give the number, Mr. Bhattacharya. Just give. Ask your learned junior to keep it on a slip of paper. Otherwise,
your lordship may record it. 11061. If your lordship wants.
Learned counsel for the private respondent submits at the outset that a connected writ petition bearing WPA 11061
of 2023
061 of 2023 is also pending in the list. Push up in view of the issues in both the writ petitions being connected, let both the writ petitions be listed under the same heading. Day after tomorrow, that is on April 24, 2024. Affidavit of service filed today be kept. ওটার সঙ্গে এটা আসবে।
Item number 42.
Yes. Yes, Mr. Banerjee.
My writ petition, my lord,
Yes.
served, my lord, all of them, my lord.
Before mentioning and after.
Mentioning also, yes.
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 I am applying for respondent number 4, civil.
Civil, correct.
My lord, this is a matter
my lord, it has a little bit of a, my lord, story which I must tell you, not history. Is that, my lord, this is a company. There was a company in which, my lord, the brothers were the shareholders. So the, my lord, was a share purchase agreement in respect of which I sold the entirety of my shareholding to my brother for a consideration, not in dispute. He paid me, I had sold the shares. Now, my lord, in that share purchase agreement, there is a clause which by which he indemnifies me for all, my lord, liabilities which were there and which may even arise after he has taken over. So, my lord, everything was indemnified by him, which he is also not denying till date. I'll show the orders of the court also, my lord. So, my lord, in view of this, there was, my lord, at the time when I was in the company, there was a bank guarantee which was, my lord, a personal bank guarantee I had given. Now, my lord, the company may have, I'm saying may have, had some default. Now, prior to that, my lord, what had happened is that when I had sold the shares to him, immediately he also wrote to the bank. I also wrote to the bank. The bank acknowledged it and said that we will release the bank guarantee as far as my clients are concerned over, my lord, giving my lord, another security. What was there apart from that? Immovable properties. So, my lord, my brother has actually given another security. That is also not in dispute. So, there is no non-compliance on his behalf. In view of this, my lord, I should have been discharged of the liability. My lord, claims arose from the bank. Bank, my lord, issued me a notice that I am invoking the bank guarantee. We, my lord, preferred a Section 9 application. In the Section 9 application, bank was also a party. My lord, they were injuncted from doing it. My lord, in view of this, they preferred an appeal. In the appeal court, there was a consent order given. My lord, the bank had preferred an appeal that my brother will be the person taking care of everything, since in view of the indemnification clause, my lord, which is there in the agreement.
Bank consented.
Yes, I'll show that, because it was bank's, my lord, appeal. And the bank said very well. In view of that, an order was passed. Now, my lord, I have certain claims.
So the injunction was not disturbed then.
The injunction was, my lord, on in view of this, my lord, it was disposed of. So I would say, my lord, it has merged in the appeal court's order. Everything was fine. My lord, obviously, I have a claim, an inter-party claim with respect to the share purchase agreement. So, my lord, an arbitration was going on, which is still going on. In that arbitration proceeding also, there is an order passed under Section 17 that I am indemnified in view of the appeal court's order, considering
but the bank guarantee was never released.
No. Now, my lord, what has happened is that, my lord, this was going on, so I was happy. So was my brother. I wouldn't say that he has done anything wrong. Bank has now issued a notice to me under, my lord, Rule 7.1, saying that, my lord, that the properties of mine would be attached and, my lord, it would be invoked. Now, the question is that my brother has given, my lord, properties. Not only that, there is an injunction against the properties of the, my lord, brother also under the Section 17 order. Additional security, my lord, as I said, was given earlier also. I'll show from the records. So, my lord, this invocation or this letter is what is under challenge before my lord, because the bank, being a nationalized bank, my lord, cannot, my lord, bypass an order which they have obtained in their appeal. And, my lord, also,
Mr. Banerjee, first please show me the Section 37 against Section 9.
Yes,
that
my lord,
order.
the appeal court's order.
Appeal court's order.
Yes. My lord, kindly comes to page 282, dated 29th of January 2024. My lord, kindly sees the
Mr. Somava Ghosh was for the brother.
Yes. My lord, kindly sees the cause title. Appeal is from the bank. Now, my lord, kindly see the cause of grievance of the appellant is no longer there. The order of injunction restraining the bank from invoking the personal guarantee has expired by efflux of time. Mr. Such and such client of the respondent number 2 has purchased the shareholding of the respondent number 1 and wants to deal with them, to which both the appellant and the respondent number 1 do not have any objection. Then, my lord, respondent number 2 will carry out the terms and conditions of the agreement between the respondent number 1 and the respondent number 2 with respect to the claim of the appellant. So it's submitted by him. To this appeal, connected applications are, my lord,
with the above observations is disposed of. So a bank has accepted it that my brother who has taken over the company in terms of the agreement would be liable for all liabilities. Now, if they proceed against them, my lord, my brother is not saying anything.
And what about the section 17 order? Have you annexed that?
Yes, of course, my lord. May I show the section 9 order? First, the section 9 order, my lord, which is at page 208.
No, because that explains
Yes.
with effects of time.
Yes.
So let
Now,
us-
my lord, kindly take the section 17 order 284 dated 10th of February 2024.
I want to be satisfied that there was sufficient security put in by your brother.
I
Only
will show that
observation,
also.
some observation.
Yes, my lord, I'll show, my lord. 284, lordship kindly comes. This is the order of the arbitrator.
Yes.
My lord, appearing for the claimant places an order dated 29 January 2024 passed by the Honorable Division. With this order was also shown, my lord. This is the order which I showed to my lord, and submits that in view of the said order, second application under section 17 of the Arbitration Act by the claimant may be disposed of, recording undertaking of the respondent before the Honorable High Court at Calcutta. That is my brother, wherein he has undertaken to carry out the terms and conditions of the agreement with respect to the claim of, my lord, the bank submitted that SIDB was the appellant in the aforesaid appeal before the Honorable Division Bench, and the respondent herein was the respondent number 2 in the said appeal. A website copy of the order is made over to such and such learned counsel appearing for the respondent, who after going through the submits that he has no objection in disposing of the claimant's application affirmed on such and such by reiterating the undertaking of his client before the Honorable High Court at Calcutta. A website copy of the order is given. So, my lord, nobody is opposing, my lord, that my lord.
Still, it may be a collusion between you and your brother.
No, there is not. Otherwise, I wouldn't have proceeded in the arbitration, my lord. My lord, we are at 210-0. But this issue, my lord, there is no, my lord, quarrel amongst us, because, my lord, obviously.
Your brother agreed.
Yes.
To abide by the undertaking. Whether
Yes.
he did that actually, whether he gave
My lord,
security.
let us take, my lord, if he has not, then they have to proceed against him. Because I'll show, my lord, the now, my lord, let me, that is why I said, my
Bank
lord,
is not bound by this section 17.
No, but bank is bound by the order of the appeal court. Bank is
Appeal
bound
court
by
is
the
that in-
appeal court. Now, my lord, let me show, my lord, why they cannot
Cause of
proceed.
grievance of the appellant is no longer
My lord,
there.
may I first show, my lord, the share purchase agreement, page 123. Kindly, my lord, comes to page 123.
Mr. Banerjee, the bank, nothing is recorded by the appellate court in that appeal of before Justice the division bench that the bank agreed to that.
Yes, kindly sees the order, my lord.
Let us revisit that page 282.
282, my lord, kindly
Yes.
takes.
The stand taken by the respondent one was, they were the appellant.
Yes, and my lord, he says, do not have any objection. So his submission is recorded.
No.
The cause of the grievance of the appellant is no longer there. So the
Because of the
grievance.
next sentence.
Yes, and my lord, the order of injunction restraining the bank from invoking the personal guarantee has expired by efflux of time. Yes. Now, my lord, kindly takes the next paragraph. Meanwhile, Mr. Such and such client, the respondent number 2, has purchased the shareholding of the respondent number 1. I am respondent number 1, my lord, in that appeal, and wants to deal with them, to which both appellant and the respondent do not have any objection. Bank is the appellant. Respondent number 2 is my brother. He is saying, I am the person, you catch me. Bank is saying, I'm happy.
If you can.
Yes, my lord. Obviously, he has an agreement. So
But
they
there's a
can.
movie to Catch Me If You Can.
Yes, my lord.
Brad Pitt, one of my
Yes,
favorites. Anyway.
yes, my lord.
Yes.
My lord,
So,
lordship.
Mr. Banerjee, then whether
I-
they can catch you now if they want, let us see that.
So, yes, that is what I want to show to my
Yes, yes. You are going to do that. I disturbed
Yes,
you.
yes.
Yes.
My lord, kindly comes to my lord, page 123. It's the agreement dated 19/6/2024. My lord, in 123, kindly comes to 128. Clause 2.3.1. 128.
Here, bank was not a party.
No. No, I'll show why bank has been informed. I'll show and bank has
I am
acknowledged.
only worried about the bank. I am trying to protect the
I'll
bank.
show, my lord, the bank is protected.
Yes, because these agreements, yes, respondent number 2 obviously agreed to this arrangement.
No, my lord, why I say that why he agreed in appeal is because of this transaction. Kindly
Yes.
takes 2.1.3.
Yes.
All liabilities from past, present, and or future of the company shall now be borne by the purchaser,
including but not limited to statutory liabilities, all commitments to financial institutions.
This does not bind the bank.
Look, I'll show, my lord, why it binds him. I'll show. My lord, let us see first the clause. Institutions, both public and private, all creditors of fixed and current assets, and any expenses which the employment benefits. Now, my lord, kindly comes to 2.3.3, page 129. The purchaser shall ensure release of all personal guarantees and collateral of the seller and its related parties placed on behalf of the company from the financial institutions or any other institutions latest by 31st of March 2022.
Till date, you have not been released from your bank guarantee.
Because of the conduct of the bank. Now, my lord, kindly sees. Apropos this. Now, my lord, kindly sees what happens. My lord, kindly comes to the letter. Resignation letter, my lord, is at page 143, which is dated 13th of December 2019. Kindly comes to the resignation letter. My lord, this is the letter, acceptance of resignation. Now, my lord, kindly sees the document of the ROC, which is, my lord, form DIR 11, page 148.
Still does not absolve you.
I'm showing, my lord. I'll show that all statutory liabilities have also been complied with. Now, my lord, 148 is the form DIR 11, which, my lord, according to the Companies Act,
You are a guarantor to that.
my lord, my resignation is accepted. I am no longer a shareholder or, my lord, a director. Now, my lord, comes to intimation to bank, page 152. The story starts from here. They are not denying it. Now, my lord, kindly sees the date, 2nd of January 2020. Lordship, at the corner left-hand side.
Yes.
To the branch manager SIDBI, change of management and resignation of Mr. Such and Such from the directorship of, my lord, such and such company. My lord, this is intimated. What is the reply of the bank? My lord, kindly comes to before that page 155, which I write for release of the bank guarantee, specific letter, not only for resignation. Page 155, my lord, to the branch manager, release of personal guarantee with reference to the above and my resignation from the directorship of the above mentioned company, which has been intimated to your good office on such and such. I would request you to release my personal guarantee as I am no more on the board of the above referred company. Now, what is the reply? Kindly comes to page 156. And lordship will see whether it has been abided by or not. This is the reply. Please refer to your below mail on the caption subject personal guarantee and securities given by you for securing the credit facilities given to Kannani Textex Print Private Limited. Will continue till those credit facilities are outstanding with us. Well, this is very important. However, CDB can consider your proposal for release of the security if the company offers additional security to the satisfaction of CDB. Now, my lord, kindly takes 180 first, because, my lord, that is when, my lord, we had taken the loan and the personal guarantee was given.
109.
The shit to aage bolche ho.
109. Sorry.
My lord, kindly
180
takes,
is the
no,
additional
my lord,
security.
kindly comes, my lord, first takes 109.
No, Mr. Dasgupta prevails. I won't waste
No,
time
he
on one.
wants to, my lord, go ahead before showing what was there. Otherwise, lordship will not
No,
be able to understand. My lord, I have to show.
109.
109, lordship kindly comes. (107) it starts, kindly comes to 109. My lord, kindly sees these are the properties which are there from item number 2 onwards. Lordship will kindly consider this with, my lord, কি হ্যাঁ দেখাচ্ছি তো হ্যাঁ 109 lordship will see, my lord, security clause 9 and the security is there under. Now, my lord, these were the securities at the initial stage. Now, my lord, kindly sees after this, my lord, additional security asked by them, what have I given them? My lord, will kindly come to page 180. When there is a compliance, my lord, they cannot go on, and since there is an order of court. Now, my lord, 180 lordship will find clause 3 is the new security, additional security I have given, accepted by them. First charge by way of mortgage of lease, hold rights of the borrower and the freehold rights of the
of such and such in favor of SIDBI on of movable property comprising of all that piece and parcel of land.
Has been given by the company.
Yes, because
which
they
is now
want
in
it.
charge of two.
Yes, yes.
The
So
other.
this is the additional security given which they have accepted and holding on to it. Now, my lord, before they, my lord, exercise the right to exhaust this, they cannot claim upon me.
And what is that claim, impugned claim now?
Yes. Now, my lord, kindly comes to the, my lord, impugned letter which has been issued by them. My lord, page 289. I'll show, my lord, the fallacy there. Kindly comes to page 289, dated 13th of February 2024.
But why are they still stalling your release of your bank guarantee?
I don't understand, my
Did
lord.
they give any reason?
No reason.
Look into
No
anything
reason. The
relevant.
only thing that they said, I showed the letter, give additional guarantee which was given. Now, my lord, kindly comes to page 289, my lord.
Yes.
Now, my lord, kindly sees this letter. I think, my lord, this has been issued even without reading the documents properly. My lord, 289, the letter starts.
Yes.
From, my lord, issued on 13th of February 2024. Lordship will find the petitioner, my lord, which who has been issued. Mohit Mal. Lordship has got, my lord,
But
at
Mr.
the bottom.
Banerjee, this is at the inquiry stage. I mean, they have just asked
Yes,
for.
this is a notice under 7.1. Now, my lord, kindly sees why. Kindly comes, my lord, to page 291. Very important. Very important.
Why don't you give a reply to this and explain everything? Why interference by the writ court at this stage?
Because, my lord, they're carrying on the process. My lord, 7.1, they have issued my letter of, my lord, reply will have no consequence at all. Because, my lord, they're not supposed to take my reply or even consider my reply. Now, my lord, kindly sees the fallacy, 291. 291 does not talk about the property which has been
Additional
given, my lord.
security is not taken care.
Yes.
I'll once look into section
7.1. Yes, my lord, kindly. 7.1 to mark on. My lord, may I just hand over the rule, my lord?
Oh, this is rule.
Yes, my lord. Right.
Regulations or rules? Rules.
Rules, my lord.
This is the application to several rules. Which rule? Tell me, then I'll look into that.
My lord, this is the 7.1.
2016 rules.
Yes, insolvency and bankruptcy application to the adjudicating authority.
Yes, I've got it. Rule 7.1.
Yes, 7.1.
I'll just find it out. 7.1. Yes, I've got it. Before Mr. Dasgupta. No, application by corporate applicant. This provision. I think.
My lord, application to adjudicating authority. But that is a separate rule. Application to adjudicating
No, that is.
authority
This is the 2016 rules.
for insolvency 2019.
Then I'm on the wrong.
Insolvency resolution process of personal guarantors to corporate debtors. My lord, may I read and hand over?
Please do that. Please do that.
Application by creditor. The application under subsection 1 of section 123 shall be submitted in form B along with a fee of 2,000 rupees. The creditor shall serve forth a copy of the application referred to in sub-rule 1 to the guarantor and the corporate debtor for whom the guarantor is a personal guarantor. In case of joint application, the creditors may nominate one amongst themselves to act on behalf of all the creditors. Now, my lord, kindly takes section 123 once of the IBC, my lord, which is more relevant.
Yes.
My lord, appointment of insolvency professional as bankruptcy trustee. My lord, I have no scope. Because kindly sees if an insolvency professional is proposed as the bankruptcy trustee in the application for bankruptcy under section 122 or 123, the adjudication authority shall direct the board within immediate. This is immediate. No adjudication within 7 days of receiving the application.
Stay, Mr. Banerjee.
But it is just like I'll say, my lord, like 95 to 100 of, my lord, which was there. No hearing, straight away appointment.
The petitioner has made out a strong prima facie case for hearing the writ petition on merits. Full stop. The petitioner entered into a share purchase agreement with his brother, who was a co-shareholder in the concerned company, the borrower company. Full stop. Pursuant to the share purchase agreement, the petitioner's brother was to take over the entire liability in respect of the purchased shares of the company. Full stop. Subsequently, the petitioner, comma, as is apparent prima facie from the documents annexed to the writ petition, comma, resigned as a shareholder and took due steps, which was recognized by the registrar of companies as well and intimated to the respondent bank. Full stop. Next para. Subsequently, there was an application under section 9 by the petitioner, which met with success but was challenged by the bank before the appellate authority. Full stop. Before the appellate authority, comma, an undertaking was recorded, comma, to which the bank agreed as well, comma, that the petitioner's brother, comma, the purchaser of the said shares, comma, shall take over the entire liability regarding the company. Full stop. Next para. Subsequently, comma, on the petitioner seeking release of the bank guarantee which had been initially furnished by the petitioner to the bank, comma, the bank wrote back to the petitioner, comma, which has also been annexed to the writ petition, comma, indicating that they were willing to consider the said request of the petitioner subject to additional security being furnished by the petitioner. Full stop. Next para. Learned counsel for the petitioner places reliance on the documents annexed to the writ petition to indicate that additional security was furnished in fact by the petitioner. Full stop. However, comma, despite the same, comma, the respondent bank issued a demand notice dated February 13, 2024 in respect of the purported unpaid debt in default due from the company. Full stop. It is argued that the petitioner has no subsisting liability in view of the additional security having been furnished by the company and the petitioner being absolved by the undertaking given by his brother, comma, which was ratified in a sense by the bank before the division bench taking up the appeal against the order passed under section 9 of the Arbitration and Conciliation Act 1996. Full stop. Next para. Despite service, none appears for the bank, although the civil authorities are represented through counsel. Full stop. The affidavit of service filed today be kept on record. Full stop. Since the writ petition is required to be heard on merits on the above question, comma, the respondents are directed to file their affidavits in opposition within 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. The matter shall be listed in the monthly combined list of cases for the month of June 2024. Full stop. The respondents shall remain restrained by an order of injunction from taking any coercive action pursuant to the impugned demand notice dated February 13, 2024 till June 30, 2024 or until further order, comma, whichever is earlier.
But only thing is that, my lord, if this can be expedited a little, because in view of this notice 7-1, automatically the name goes into civil. So I cannot do any business, my lord. It is automatic. So I cannot be doing, getting any financial assistance from any banks, my lord.
Very well. তাহলে যেটা বললাম ওই affidavit in
Can be
opposition
fixed
যেটা
any day, my lord.
না
I'm ready to
time
run.
no, it cannot be before that, Mr. Banerjee, because just look at the dates. Today we are on 22nd.
Yes,
If I
my lord.
give 3 and 1, then the
It's only a question of law, my lord. I don't
Summer
think
vacation interview.
interpretation of 123 he has to, my lord, argue.
Let it be on
Nothing.
the June.
My lord, then, my lord, kindly fixes a date. my
No,
lord.
no.
Otherwise, my lord,
Become
I will have to come and disturb my lord,
Don't
that, my lord,
disturb.
because my civil would be, my lord, affected automatic. My lord, I cannot do anything.
For the time being, no. Don't.
My lord, may this be done, my lord. In the meantime, my lord, let the bank give a note to civil then, my lord. Because this becomes automatic. 7-1 means my name would be there
No,
in
Mr.
civil.
Banerjee, not at this juncture.
Otherwise, my lord, I have to stop my business, my lord.
For the
And
time
even
being.
a note to civil that this is pending.
Prayer আছে
I have a prayer for that, my lord. I have a prayer for that as an interim measure, my lord, because I know
They measure that what? They'll not upload.
No, my lord, that they have already uploaded. It is automatic under 7-1. Only that, my lord, kindly, my
No,
lord,
Mr.
that is
Banerjee.
pending.
No, no.
Otherwise, I won't be able to get the
No, Mr.
amounts, my
Banerjee,
lord.
not right now.
কি করবি?
Next. Call on the next.
My lord, I am for the petition.
Yes, what is the matter?
My lord, I am for the petitioner. My
Lord,
lord,
I have
there
for
is
the
a
response.
new connection of the electricity. My lord,
Why not given, Mr. Kule?
Oh, my lord, many things has to be, my lord, brought into the record of this honorable court, because, my lord, in the same place, there is an existing bulk connections
on inspection, it has been found.
Short affidavit,
In the name of Vishnu Processing, there
Fortnight
is an
affidavit.
huge outstanding dues, 1 crore.
fortnight's affidavit.
Let them, my lord, file a report before your lordship, my lord, within a
My lord,
7 days.
my lord,
I will
kindly make
reply
it 3 weeks because
My lord,
it's
I am
the
with
old
you,
dues.
city, my lord.
No, my lord, it's a big project. It is not a case that he has applied and we will effect connection
Small,
immediately.
my lord, the electricity,
Because we
my
shall
lord,
have
required,
to
my lord, everybody,
prepare.
my lord. Big or
One
small, my
minute,
lord.
we shall have to prepare, my lord, the installation of the infrastructure and everything. It's not a case that one particular person's applied and we will effect connection. Automatically, it will take some time because there is an bulk connection, existing bulk connection is there. That has to be surrendered. Otherwise,
No, I'll give them the time. Learned counsel, but the
Otherwise-
petitioner argues that the
Your
petitioner
lordship,
applied.
see my when I made the application, my lord, for
and my lord, many
lord,
things.
my lord, your lordship, my lord,
Tell me when.
my lord,
If you open the-
2022.
Learned
My lord,
counsel for.
from then, my lord,
If you
that's
could
the-
wait
my
for
lord,
so long, you can.
even
wait.
my lord, today, my lord, they're
Why
saying,
did you
my
wait
lord,
for 2 years to file the writ
my lord,
petition?
I tell your lordship, my lord, entire building was, my lord, done.
No, if
my
you
lord,
have waited for 2 years for the writ petition, then we can. You
My
can
lord,
wait for
let them, my lord, what they are saying before your lordship now, my
The
lord, let them,
petitioner argues that the petitioner applied for electricity connection in 2022 for a project which has since been stalled due to the WBACDCL having not given such connection till date. Full stop. The counsel for the WBACDCL seeks 3 weeks time to file an affidavit in opposition to disclose relevant details. Full stop. It is contended by the WBACDCL, inter alia, that there is an existing bulk connection at the locality and
On the same premises.
on
No,
the,
my lord,
at
I'm
the
disputing.
locality at the same premises, and there are huge outstanding dues which are to be cleared by the petitioner for getting the connection. Full stop. Learned counsel for the petitioner controverts such allegations. Full stop. Since factual disputes are involved, the respondents are directed to file their affidavit in opposition within 3 weeks from date. Reply, if any, shall be filed within.
my lord, within 3 days, my lord.
Within 3 days thereafter, the matter shall be listed on May 20, 2024 for hearing.
My lord, I'm grateful, my lord. I'm grateful, my lord.
Thank you.
He is the owner of the property, nothing has been stated.
Yes.
He has stated that I am of the co-sharer of the property, but he didn't say anything about the bulk connection.
Let them, my lord,
If it
show, my
reserved
lord.
for your affidavit in
Yes,
opposition. Next.
Grateful.
বসে আছিস?
My lord, 20th, your lordship, my lord, the same position, your lordship.
No, definitely not.
My lord, otherwise, my lord, your lordship, kindly,
Yes,
my
who
lord,
is
consider
appearing in
this is the
44?
electricity, my lord, this.
Who is appearing in 44?
I'm for state.
Move it.
For the respondent,
Waiting for you.
I'm from the respondent number 3, 4, 5, and 7. But this is my
The petitioner is not appearing. None appears for the petitioner at the time of call. Full stop. This is your.
my affidavit opposition.
আমাদের একটা কপি
Your for respond number.
3, 4, 5, and 7. 3, 4, 5, and
None appears for the petitioner at the time of call. The respond numbers 3, 4, 5, and 7 file their affidavit in opposition, which is kept on record. Full stop. In view of the absence of the petitioner, let the matter be adjourned till next week when it will be listed under the regular heading. এবার regular heading এ চলে যাবে. Next.
Ma'am, for WBSCDCL.
I'm happy
But
for
is that
petitioner,
matter?
my lord.
Where
I'm
do you
praying
lordship-
for 1 week time, my lord.
Then it goes down under regular heading.
This is that matter where your lordship was pleased to direct to file their supplementary affidavit.
They are to file.
The petitioner.
Lordship remembers that high tension line underground, I had suggested.
Let them file the supplementary affidavit.
But they have been directed to file the supplementary affidavit.
I'm ready, my lord. I'm praying for 1 week time, my lord.
A week's adjournment is sought by the petitioner. Full stop. Accordingly, let the matter stand adjourned till July 29, 2024, when it will be listed under the regular heading.
Sure.
Not under upgraded. You have a fair chance of winning, I suppose. That's why he's asking for time.
I'm ready.
Anyway, under regular heading now. Regular heading. Arta taken.
46, I am for the petitioner.
Yes, what is the matter?
My lord, this is my affidavit of service.
They have received.
lord,
They have received.
Yes,
What is the
my lord.
matter?
My lord, this is regarding my lord, death retirement benefit of my lord, National Insurance Company. My lord, kindly come to page 21. This is the
21.
21.
Yes.
My lord, their statement is that, my lord, they have disbursed this amount, though I have not received. I made a TI, my lord, though there is no appeal. That if you disburse, to whom if you disburse, and the wife and the son.
Can you do this? Give a notice to them. I'll keep it day after tomorrow
Sure.
because their stand is very
My
essential
lord,
here.
my lord, my lord. I will. I will.
None appears for the respondent insurance company, although the petitioner is represented through counsel. Affidavits of service filed today be kept on record. Full stop.
Noted.
In view of the nature of the allegations made, comma, it would only be appropriate if the respondents are given a further notice, comma, since their presence is essential to ascertain the stand of the respondent insurer. Full stop. Accordingly, the learned advocate on record for the petitioner shall give a notice to his counterpart appearing for the respondent insurer, indicating that the matter shall be placed in the list under the same heading on April 24, 2024. Day after tomorrow, please give a notice
I will.
and file the receipt on
today,
that.
by
My lord, may I mention one
Yes.
May I allow to
popular matter?
mention matter item number 5 supposed to withdraw, but my lord, it is a dismiss for
What?
default.
Yes.
Milord, next item,
My lord,
7,
my lord, I to take the
Item number 74. I appear for the respondent.
Yes.
My lord, may I kindly drag your lordship's kind attention to the last order, my lord?
Yes. Patent sector the আমাদের patent sector আছে তো Mr. Bhattacharya probably was to reply. Yes.
I'm supposed to reply.
Yes.
Before I
Amendment Act to the, my lord, that Amendment Act.
The amendment introduces what?
My lord, that Amendment Act which your lordship was referring on the last occasion, my lord. I was not having the copy. Regarding section 53, my lords.
Yes, yes. 11A7 you are challenging.
My lord, I am challenging 53, and
Acha.
my humble submission is that it must be made as 11A7 in consonance with 11A7 in tantrum. My lord,
section 11A7, 53 and rule 24 is
And
contrary
80.
to each other for which he has suffered. And to that, my lord has asked me to give reply. Before
Yes.
I proceed to give reply on merit, I am one submission I am.
Take a seat, Mrs. Singh.
My lord, I just now during recess I have received an information from the office that he is no more the patentee, but he has assigned his patent to somebody else. But I have asked them to give me the documents by which, my lord, I can produce before the court, because oral submission will not do. My lord, if he is not a patentee, my lord, he cannot move this application as a patentee.
But
and
since
can-
I've already started hearing Mr. Bhattacharya argue on the merits also,
That-
I'll take that into consideration as well.
Yes, sir. Because according
I'll ask for a short written notes of arguments from you,
Yes.
where you will put in these
yes.
argument
I have
also.
also prepared.
Yes, Mr. Bhattacharya. Oh, you are prepared with that?
Yes. You, my lord, have direct.
Yes.
Well, in this case, 3 dates are very important. One is the date of application. Your lordship will get it, my lord, page 3 of my written notes of argument.
Yes.
2nd May 2005, date of application. आवाज होच्छे ना?
sir, the copy.
ये copy नहीं है मतलब. 3rd June, the date of publication, 2005, and 28th December 2012, grant of patent. His case is that section 11A says he will get benefit, start getting benefit on and from the date of publication. Section 53 says once the publication is made and once the patent is granted, it will go back to the date of application. In the instant case, his date of application is 2005 2nd May. Publication is 3rd June 2005. On and from 3rd June, he is entitled to all benefits under the Act 7 except to initiate proceeding against the any infringing. And date of grant is 28 December 2012. So due to this, since it has been granted after 7 years, his argument that he has suffered loss, and who will compensate this? He has suffered due to this inconsistency in the act itself. But your lordship kindly peruse 24 once 11A7 once. On and from the date of publication of the application for patent.
May I hand over the book, my lord?
Oh, thank you. No, I've got this book. If it's the same book, professional.
It's professional, my lord. In that book, 2002 amendment was not there, my lord, which may be required.
এই বইটা আনিয়ে নিতে হবে কিন্তু লেটেস্টে টানিয়ে না এখনই আনি না দাও দাও আরে এই বইটা এটা ওটা আমাকে দাও এটা ওকে দাও so I'll just
11A7. Page 16. 1/6.
Thank you. Yes.
on and from the date of publication of the application for patent and until the date of grant of a patent in respect of such application, the applicant shall have like privileges and rights as if a patent for the invention had been granted on the date of publication of the application. So in the instant case, my lord, is the 2005 June. He has enjoyed all benefits. 2000. So there is no, my lord, suffering on his part, at least from his own application says. Because, my lord, section, now your lordship kindly peruse, my lord, rule 24. This is at page 18. My lord has got it, my lord. Chapter 4, publication and examination.
Rule 24 of the 2003 rules.
Yes, 2003 rules.
Yes, got it.
The period for which publication of application, the period for which an application for patent shall not be ordinarily be open to public under subsection 1 of section 11A shall be 18 months from the date of filing the application or the date of priority of the application, whichever is earlier. So he is banking on this period, my lord, 18 months or above. My lord, date of publication from the date of application. This time will be lost. Am I clear to your lordship?
No, he is on section 53 itself.
I'll come to section.
Very well, yes.
And my lord, these 18 months will also not come into picture, my lord, if he requests for publication under invoking rule 9 of the said rules. In the instant case, he did it and he got benefit, and the law provides. My lord, he applied May and June, it was publication. Publication was made.
Rule 9.
Form 9, my lord, not rule 9. This is, my lord, that page I tell you, lordship. Page 70.
Form 9 I have got, yes.
Yes. Request for publication. If he, my lord, request for publication, it is be preempted. Date is preempted. Immediately it is published, if it is allowed. And in the instant case, so in that view of the matter, he has not suffered and not going to suffer any loss, my lord, for this 18 months and onwards. So that is provided in the act itself. So, my lord, now your lordship kindly, his only point, my lord, he cannot sue against the infringee. My lord, once the patent is granted under section 53, now your lordship kindly peruse section 53.
No, if the publication is made, then 24 does not come into play. Period for which an application shall not ordinarily be open to the public shall be 18 months.
The date is,
if publication is made, then this 18 month is no longer applicable.
He is not suffering any.
So if one applies simply, then the date of publication will be very close to date of application.
Very close. And in the instant case, it happened. This is not a public interest litigation. He has filed this for his own benefit or his own loss. And
the challenge to a virus is on a wider footing.
That is
it not be a public
interest. He has to also show that because he has suffered something for this. And he has argued on the last.
Let us take his best case, Mr. Bhattacharya. He has suffered for this 1 month also.
One month.
I mean, why should he suffer for that also?
Even on 1 month, he has not suffered. That I will go to. Now your lordship kindly peruse 53.
But you are not answering on the virus issue. Why should there be a discrepancy between publication?
There is no discrepancy. That is why I will tell.
Yes.
But
then somebody is at the mercy of the authorities.
Not mercy.
If the application is made, there is no time fixed here in any of the rules that if an application is made, publication has to be done within such and such period.
That period, my lord, is section 24. If any person wants, my lord, he can preempt the date from that to, my lord.
But there is no time-bound factor in your rules or your act to say that, yes, if an application is made under Form 9, the publication shall mandatorily be within a week or something like that.
That mandatory clause not in the, my lord.
The absence of that, the infirmity in the statute complaint of remains, Mr. Bhattacharya. It depends on entirely the will of the administration.
Not will the right has given to the applicant, but he can very well.
The right has been given to make an application
Make
for
an
publication,
application.
Mr. Bhattacharya.
That is
But
what-
in the absence of any mandate on the part of the authorities to make that publication very soon, I mean, there is a difference between theoretically date of application may be far off from the date of publication. I make an application for publication the very next date. There is nothing in the statute to compel you to make that publication within, say, a particular period. You can make it very well at your sweet will also. So what
not
is
my sweet will one? That is one at 24, 18 months.
18 months is the outer limit.
Right.
So why should this 18 months be there in the statute? That it's the
18
notional thing.
18 months is there, there are other procedural formalities to comply with verification and other things.
Mr. Bhattacharya, I don't grudge your having that 18 months. But the difficulty is, it is not a case of the petitioner alone. The petitioner says, if I make an application for patent, that application is published, say, 18 months after, which is the outer limit within which you can do it. So he loses this 18 months. But the tenure of the patent is all the same from the date of application till then. So why these 18 months or even one day will be lost?
To that, one other thing, you lost once kindly peruse 53, section 53.
Yes.
Subject to the provisions of this Act, the term of every patent granted after commencement of the Patent Amendment Act 2002 and the term of every patent which has not expired and has not ceased to have effect on the date of such commencement under this Act shall be 20 years from the date of filing the application. The moment it is granted, my lord, it goes back to the date of application. And in that view of the matter, if by that time, if any person, he has enjoyed the royalty, but if any person has not given him royalty, he can also, my lord, take steps against that in view of section 53, but it goes back to the date of grant of. So by no stretch of argument can be said that he has suffered or is going to suffer anyway by the inconsistency in the Act.
No, Mr. Bhattacharya, we are missing out on something.
My
It
lord-
goes back to the date of, it retrospectively goes back to the date of that application.
Yes.
Yes. But that only happens once it is granted.
Granted.
Before it is granted, from the date of the application till the date of the publication, that patent is useless for all practical purposes
Subject to
because he cannot use it.
Well, he is always at liberty to use this. Well, only he cannot initiate proceeding against that, my lord.
Achha. So very well. Only the initiation of proceedings is. Let us go back to 11A once.
Page 25. Object of the deduction.
Just page 25 Roman.
Page 15, yes.
Amendment, Patents Amendment Act 2005, Roman 25. The beginning.
Last year.
But the subsection 7 says, on and from the date of publication and until date of grant, the applicant shall have the like privileges and rights as if a patent for the invention has been granted.
Yes.
By necessary implication, Mr. Bhattacharya, he or she does not have that right or like privilege from date of application till date of publication.
That I have, what is passing through your lordship's mind, I have got. The only thing, if there is no mandate in the Act itself, that what would happen between the date of application and the date of publication.
Mandate is clear in by necessary implication.
Mandate is that my submission is that
it cannot
there
be.
is no specific mandate in the Act itself.
So, Mr. Bhattacharya, do you argue that in spite of 11A7 being there in the statute book, that like privileges and rights is conferred on him from the date of publication, he has those same rights from date of application till publication also?
No, that is not my argument. That cannot be. Only
that is the only implication.
That is only will be applicable when it is granted. If he loses anything,
when it is granted, Mr. Bhattacharya, that is his precise case. When it is granted, I file application today. Theoretically, you can make that publication after 18 months.
Yes.
Only when it is granted, it relates back to the date of the application. So this 18 months is taken within the tenure of my patent. But when the patent ends, these 18 months will be taken, included. But I don't have any privileges during this period.
My reply to this, my lord, only thing, my lord, that is provided, relief is provided under section Rule 24A of the rules, by which one can to preempt the date, and that has been
No,
done.
Rule 24 does not say
20
about anything about preempting. Rule 24, let us come back to Rule 24. Mr. Bhattacharya, please place Rule 24 once.
Yes.
The patent rules.
24 is, my lord, publication of application. The period for which an
Which gives you 18 months to publish.
18 months.
18 months. And Rule 24A is a request for publication shall be made in Form 9, which is the form of the application. That does not mandate you to do that within 18 months. So 18 months is the outer limit which you have. So why shouldn't 53 be that the date of publication is the date when, I'm not saying for date of grant, because like privileges are enjoyed by the patent holder from the date of publication.
Because he has enjoyed.
So for all yes, he can enjoy only after publication. Mr. Bhattacharya, before publication, he does not have any like privilege or right. Any.
My submission, my lord, 53 is once granted, it goes back to the date of application. And if anybody, my lord, by any means has not enjoyed the benefit and not paid him or infringed him, he can very well initiate proceeding against that person.
We are entirely at cross purposes, Mr. Bhattacharya. After 1 year, when the patent is granted, can I go back and have back those 18 years of my patent's life and use the patent during that period? Because your Rule 11, Rule 53, Rule 11A specifically debars that. Rule 11A(7) specifically by specific implication debars a patent applicant from having like privileges and rights as a patent holder before publication. So in the interregnum, and Rule 24 says publication within an outer limit of 18 months. So you can on paper, Mr. Bhattacharya, make the publication after 18 months. So if you make it after 18 months, and if I apply 18 months before that, during this interregnum, Rule 11A specifically debars me from having like privileges or rights. So I did not have the like privilege or right today, tomorrow, or day after tomorrow. If I did not have the right, why should that be counted within my patent tenure? I could have 18 months extra after that.
These 18 months, my submission, my lord, will be covered by this filing an application for request of, and then he will not suffer any prejudice. And second thing, in the facts of the present case, the petitioner has enjoyed this benefit for 18 years at the verge of his, my lord, expiry of the patent, 2005.
That is when the shoe pinches.
That is where, my lord, this is a malafide. This is malafide, and this type of application should not be, my lord, taken for consideration, is liable to be dismissed.
So malafide is one of your point, and the other point is that he actually, in reality, he had this benefit within a month.
Yes.
And your first argument is that he has assigned, so he has no right to challenge the locus.
That is my first, my lord. He has already assigned this patent to somebody else, my lord, and therefore he cannot.
Acha, Mr. Bhattacharya, tell me this. A patent holder, after he assigns the rights, what is left to him? What is left to him? Does he have any right any further?
No, my lord. So
no right whatsoever.
That I have told them that kindly come with documents, because this is a...
No, not documents. I take you on whatever you submit. Under the Act, an assignor, patent holder who assigns his rights.
Once it is assigned, my lord, he loses all rights.
All rights.
All rights. That is my submission, my lord. All rights. When he loses all rights, my lord, he cannot move, my lord, as a petitioner this application before your lordship's court.
All
and my first is, my lord, the locus standi. Second, my lord, the malafide, and third is, my lord, I have already done. And there is no inconsistency. And he has not made out a case that he has suffered during that period for which he has come before your lordship's court. There is no violation of fundamental rights. He has not also made out any case that due to this, my lord, any citizen of India will going to suffer or like that, my lord. That he has not made out personal, and any discrimination has been made with the others. That case he has also not made out. This is my submission to you.
Mr. Bhattacharya, I appreciate this, that in case when we are scrutinizing in judicial review a piece of legislation, we have to be on a much higher footing than an administrative action. We cannot impute unreasonableness on the intention of the legislature. There are several fetters. We have to be much more cautious. But if there is an inherent discrepancy in the legislation itself, which takes away rights by one hand, which the other hand gives in the same legislation, that patent and inherent contradiction, can that not be a ground for challenging the virus?
But that is a ground.
What you are giving, the legislation itself, legislature is giving, but it is taking away.
That be a ground. My lord, the petitioner by suppression of material fact cannot come before the court. My lord.
What is the suppression?
That suppression, he is not an, he has
Assignment.
This is suppression of material fact. Independent capacity, he can very well move before the public interest litigation before the appropriate forum, but not before the writ court as a petitioner, before your lordship, that I am the patentee, I should be given, my petition should be heard on this merits and the virus should be declared.
Now the next question which comes in, Mr. Bhattacharya, if I challenge a virus of a statute, how far I mean, the locus standi point has been diluted much in the meantime by the Supreme Court. If the government has a duty, not merely that I have a right, but if the government or an authority has a duty, it is not fulfilled, then also I can come up, I have locus standi.
But suppression of material fact is a very important issue in the fact. This is very important. And one humble request, my lord, if your lordship, on that point, what is, my lord, is that even in 1 month suffering, that may be a discrepancy and inconsistency in the act. For that, your lordship, kindly, you can give another week's time.
No further time, Mr. What you have argued. And I'll take your, whatever you have pleaded here, subject to his objecting, I'll take it as it is. And Mr. Kankani, you are for?
No, he is appearing.
With.
So to copy to the win, please.
Provisions, perhaps, my lord, with the lordship's leave, my lord, may I just indicate, my lord, perhaps, if the lordship kindly takes 11A7, my lord. My lord, very vital, very important, my lord.
11A7 is the...
No, my lord, I'll come to it. My lord, if your lordship kindly takes 11A7, my lord.
Yes.
Kindly allows me, my lord, 2 minutes, my lord. Now, my lord, my lord, adding to my learned senior friend's submission, my lord, that these two provisions cannot be compared. 11A7 and 53 work, my lord, independently. 11A7 is a provisional provision, my lord. That is when a person is applying for patent. My lord, there's a distinction. There's a distinction between a person who has got patent and a person who's under process. If your lordship kindly sees 11A7, my lord. My lord, this provision was not initially there. This came in by way of an amendment because of a TRIPS provision.
1 minute.
My lord.
Wait, ekhon asheni? Librarian. Have a book, yes. Yes, I cannot label it because it's not.
My lord, I'd handed over. Oh, my lord, I'm sorry.
You have handed it over, not for eternity.
Well, if your lordship kindly takes 11A7 once, my lord.
I'm there, Mr. Kankani.
Now, if your lordship kindly sees when this provision came in, and from the statements of objects and reasons, I will show, my lord, which is very material, my lord. Now,
absolutely, yes.
Your lordship will kindly see 11A7 on and from the date of publication of the application for patent and until the grant of patent. My lord, so this is it during the interregnum period, my lord, because a person cannot claim to have the same right in the process of a patent grant and a person who has been granted patent.
Right.
Of a patent in respect of such application, the applicant shall have such like privileges and rights as if the patent for the invention had been granted on the date of publication of this application. Now, this amendment comes in, my lord, inserted by the, if your lordship will kindly see the italics.
2005.
2005 with effect from 1/1/2005. Now, your lordship will kindly take the objects and reasons, my lord. Why it has come in, my lord. Now, this provision was not there for any person. It only came in to give some benefits to a person who is under the process. Now, my lord, that is at page, my lord, Roman 25 of this. In the beginning.
125.
My lord, Roman 25.
Roman 25.
In the beginning, my lord, the...
Yes, yes.
If I may place this, my lord. Notes on clauses. Patents Amendment Act 2005, Roman 25. Clause 10, my lord.
Clause 10, yes.
My lord, if your lordship kindly takes last...
Put it on a piece of paper later on, Mr.
I will. My lord, I will make a...
Put the clauses on a piece of... Need not put your arguments in. I'll note your arguments.
My lord, only your lordship will kindly see subclause C seeks to provide... My lord, this is the amendment. Subclause C towards, my lord, 6 lines from the bottom, my lord.
I got
clause
it.
10.
Yes.
Clause 10.
Subclause C?
My lord. Subclause C seeks to provide a new subsection 7 relating to provisional rights. My lord, these are provisional rights, not full rights to any person, my lord. To the applicant on the publication of his application as per international practice. However, the applicant shall not be entitled to institute any proceedings for infringement until the patent has been granted. It further seeks to provide the rights of a patent in respect of the applications made under subsection 2 of subsection 5 shall be available only from the date of grant of the patent. My lord, first submission is, my lord, the workability, my lord. The applicability of both these two provisions are very different. They cannot be compared, my lord. First, my lord. Second, my lord, this is a temporary relief, my lord.
Difficulty is, Mr. Kankani, the difficulty is when we copy international law, we copy portions of it.
My lord, 100
Same thing happened when we copied the provision of challenging from the ancestral arbitral laws. Same thing happened.
I will.
Regarding challenge, we did not put in any provision. Although regarding jurisdiction, also in the ancestral model law, there is a provision. We have left it out.
My lord, classification.
Here also, we modify 11A very well. Well and good, you give additional privileges.
Yes, we are giving additional.
But then you are giving additional privileges at the outset to people who have patents from 2005. But supposing people who have
applied, my lord, at that stage.
Who applied at that
Yes,
stage. But
at that
people who applied just previous to that
My lord.
and whose patent expired subsequently,
My lord.
they do not get this benefit. For them, what will happen is you have to go back to the date of the
My lord,
application.
because for them in that case, it
Even
will
for
be a
these
different
people, you have
My
to
lord,
go
even
back.
for these people, my lord, a person who
Only
applied.
change, put in a corresponding change to section 53.
My lord.
Make it from the date of publication.
My lord, may I put it this way? Now, the person who has come before lordship, the petitioner, he says, I have lost 18 months. My lord, the right time for him to come before this honorable court was when his publication was effected, and that is the time he had suffered. That, look, my publication has been allowed, but the time period is not from the date of application. My lord, because if a person is suffering,
Mr.
that time
Mr. Kankan, I speak for him on
My lord,
this.
my lord.
Now, he is not aggrieved by that like rights and privileges being conferred on him from the date of the publication. He is not aggrieved by that. So he should not have come up at that juncture. He is aggrieved when his tenure expires. When the tenure expires, it is said to him that your tenure began from the date of the application.
My lord.
So his cause of action for challenging section 53 is when his tenure expires, not when he got the privilege, but when the privilege of this continuance is being denied to him by saying that you lose the period even 1 month in his case, because it's from the date of the application. When you brought in this 11A, why didn't you put in a corresponding amendment to section 53 also?
My lord, 56, my lord, 53.
It's like saying, I'm telling you,
My lord.
I apply for electricity connection. I get it after 2 months. And when it expires, that period, I mean, you say that you have to pay for the period during which those 2 months for which there was no electricity because you applied. I mean, he did not have the like privileges, but it expires before that.
My lord, 53 says that he gets the right from the date of application, my lord. So
That is
there
what
no-
he's saying.
My lord, that is where, my lord, may I place one
Why
more
should he
thing,
get the right from the date of application?
my lord,
If
because
you
the
don't give
thing-
him the rights.
My lord, because, my lord, now the question here comes is, my lord,
No,
when is the
I'm
period
sorry,
to
I'm
be
sorry, I'm
completed?
sorry, extremely sorry.
My lord.
It does not say he gets the rights from the date of application. He says that the period of his patent, the tenure of his patent expires by deeming the date of commencement from the date of application.
My lord,
Whereas he gets a like rights and privileges from date of publication, not application.
my lord, may I join issues here, my lord?
Yes.
Now, from the date of application, my lord, patent, my lord, I have applied for a patent, my lord. Let us take an example, my lord. Now, my lord, the day when I get the patent, the final grant is given to me, my lord. If there has been any breach, my lord, because till the time I don't get patent, I cannot sue. That is also very clear, my lord. I cannot sue, I cannot bring a suit for infringement, my lord. The day I get a patent, my lord, I have the right to sue, my lord. Any damages, any suit, my lord, is maintainable only then, my lord. So whatever I'm losing, I'm entitled to that. But here, a person who is provisionally applied, it does not even, my lord, it is not known that whether this application will succeed or not, my lord. So there is a distinction here, my lord. Secondly, my lord, this amendments, my lord, I will also show 2050.
He is not aggrieved with 11A in any manner.
My lord, he cannot be, my lord.
He
That
is
my
not.
lord.
Why should
Even
he
if-
cannot be? Whether he cannot be, we are not. He is not agreed by 11A at all. He welcomes those additional privileges given to him.
My lord.
But if those privileges were also not there, then his argument would be, why not the tenure of the patent commences from the date when it is granted? Why should it go back to the date of application?
My lord, because now if your lordship will kindly see the 2002 Amendment Act, my lord. My lord, may I place 53 once, my lord?
Yes.
My lord, there are over 100 countries who have ratified this, who have all accepted this in their commercial wisdom. My lord, may I give an
That
example?
is what I'm telling you, Mr. Kankani. We half-heartedly accept from here, some from here,
My lord.
some from ancestral law. some from some other code, some from British arbitration, some from Singapore. Similar thing has happened to arbitration.
My lord, now the purpose of patent, my lord, being granted to any person is, my lord, the reason is, my lord, the moment a person files an application, it is that date. It is intended that an innovation has come up. Now, your lordship will kindly take a situation, my lord. I have applied for patent, my lord. Let us say, my lord, there's a long tenure of time. It takes 10 years for me to get patent. I applied in 2010. I get the patent in 2020. Now, whether 20 years ought to be counted from 20 to 40 or from 10 to 30, that is the question which
What
arises.
does common sense say, Mr. Kankani?
My lord,
You get it from 2010.
My lord, reason I will tell your lordship a very practical example.
Suppose the tenure was for 11 years. Then he gets to use the patent from 2020 to 2021. And it will be counted from 2010.
My lord, he gets to use it, my lord, from the day he has, my lord, it has been
Applied.
published. It has been published.
Precisely.
But the rights, my lord, whatever loss has been caused to him, he gets it from 2010. Because, my lord, the technology shifts, my lord. In the meantime, what happens, my lord, another person can come and say, look, I had applied for this patent. I got this in 2020. Now you are giving me from 20 to 40. But in the meantime, the 10 years gap, the whole scenario has changed. The innovation which I had done has become outdated. This can be a counter argument to this, my lord.
Cannot be. Because then in the first place, he would not be granted that patent.
No, my lord.
If I apply today,
my lord,
and the patent is granted, say 2 months after,
my lord,
that patent would not be granted if during the interregnum somebody else got the patent.
My lord, it's not question about somebody else getting it. I am only getting it, but maybe after a long time, after 10 years. My lord, a very live example which has come up in another matter, my lord. LED lights, my lord, your lordship is aware, my lord, CFL and LED. CFL, my lord, components, my lord, were manufactured, my lord, in a suit for damages, which I am doing, my lord. This example came to my mind.
Won the suitor.
That is pending, my lord, but it's a very apt example in this case, my lord. Now, my lord, the CFL was manufactured, sold, there was a fire, my lord. Now, the person who suffered, who was manufacturing, comes up before the court for damages. Now, the question, my lord, here arises is from 14 to 18, he says, I have suffered damages. Now, my lord, it came out that the markets of CFL went down and LED came up because of the shift of technology. So, damages what he's getting is very less. Now, this can also be a reason, my lord, because a person, when he applies for any innovation, my lord, the time period becomes a material factor. Another patentee can come up and say before the court that, look, I am suffering because this is something which I had innovated 10 years back. As in his case, I had innovated this in 2005. I have got a patent in 2012. But as on date, the technology has changed, shifting has happened. My lord, over 100 countries have adopted this. This solely becomes a question of
Mr. Kankani, if 100 countries have adopted wrongly,
my lord,
I am happy to be the 101st country which corrects the mistake.
My lord, your lordship.
Don't say 100 countries have adopted. 100
personally,
countries have done so many mistakes in democracy, Mr. Kankani, you would be stunned.
My lord, your lordship will
I'm
kindly
not
take...
bothered by 100 countries doing a mistake and we are repeating the same.
My
No.
lord, your lordship will kindly take 53.
Convince me on law, convince me on logic.
I will.
I'll definitely accept your
Lordship will kindly take 53, my lord. Section 53.
I'm there.
Now, if your lordship kindly takes the, my lord's 53, your lordship, my lord, on the last occasion had gone through this.
53(1) is that relevant portion.
Yes, my lord. And my lord, the section as it stood prior to amendment, your lordship had seen, my lord, B towards the bottom. In respect of any other invention, be 14 years from the date of patent. My lord, now this was from the date of patent earlier. The parliament in its wisdom has changed this, my lord. And this change has come up for a reason, my lord. The reason is the Amendment Act of 2002, my lord. My lord, what had happened is, my lord, your lordship will kindly see the patent is also for 14 years then. In some cases, the patent was not there also. So all these things have been introduced by way of TRIPS agreement, my lord, so that the laws all over the world are common, my lord, and common protection is given. Now, your lordship will kindly see from the date of patent. So here, my lord, the parliament in its wisdom chose, they were aware that it was from the date of patent and they have made it from the date of application. Now, my lord, when, but on the legal point, my lord, when knowingly, when this has been done, my lord, my lord, my first respectful submission is, my lord, it lies within the wisdom of the parliament, my lord, knowingly when this has happened.
Of course, yes.
Secondly, my lord, the other point.
That's the most valid argument.
My lord,
as I said at the outset, Mr. Kankani, we must be more cautious in imputing unreasonableness to a piece of legislation.
But because Here, the petitioner has come up before your lordship saying that I am suffering because that period is not counted from date of publication, but it is being counted from the date of, I'm sorry, my lord, not from the date of application. Another patentee, my lord, he may so.
No.
My lord.
I myself.
My lord.
Not another patentee does not come in here.
My lord.
I myself am given a right by section 111, by section 11A, that I get the like privileges and rights as a patent holder from the date of the publication.
My lord.
But section 53 counts my days of patent from date of application.
My lord. Here, my submission is, my lord, the
So my rights are given and taken away.
My lord. My lord, the applicability of both these sections are at different stages for different persons, my lord. A provision, a temporary provision, which is for a person who is under the process, his patent may fail also, my lord. When it finalizes, it matures into a, my lord, statutory right, finality arrives, my lord. Then in that case, my lord, it goes back from to the date of application, and the logic is this, my lord, in this, that the innovation is counted from the date of application. That is the, my lord, my lord, this is my submission, my lord, on the point of 53 with 11A, my lord, because these are the application is at two different
Section
stages.
5, section 53 was amended 2 years before section 11A was amended.
My lord.
So it was already there when section 11A came in.
My lord, it may
So
be.
as you say, 53 was done in its legislative wisdom is not the factor. 11A was brought in, you're right, in a sense. 11A was brought in being fully conscious of 53.
11A was not there, my lord. 53 was
53
amended.
Being fully 11A was brought in being fully conscious of 53.
My lord.
That 53 is there
My
from
lord.
date of application.
And 11A is a provisional, my lord, section, my lord. That is also recorded in the statement of objects and reasons, and the section also records. It gives temporary relief to a person, my lord. He will have the same rights and privileges. Nothing more, nothing less to balance the rights, my lord. My lord, secondly, my lord, if your lordship will
If you
kindly-
say that, Mr. Kankani, he's on a sounder footing, then the tenure should expire not from the, because these are temporary arrangements. So his patent should expire after a particular period, not from the date of the application or even the provision of publication. It should be from the date of grant of the patent as it originally stood.
My lord, that is why here, my lord, if I may say, my lord, if I may ask myself this question, who decides this, my lord? My lord, the parliament, my lord, and I will also show the TRIPS agreement, my lord. Why I'm saying this, my lord, because there's a logic behind this, why this has been done.
Yes.
My lord, because technological advancements, my lord, a person has invented something today. My lord, 10 years down the line, he gets a patent. And if it is said that now you will get patent not from the date when you had invented, but after 10 years, for the next 20 years, he may also come and say that, look, what I innovated is meaningless today. There's a complete change in technology. There's a complete change in market usage. And my lord, patent is not just for the patentee. It
But
is
this
also
logic, how is the date of application and date of publication this for a valid yardstick?
My lord, because the time taken, my lord. That is why innovation is taken to be on the date of application. Suppose, my lord, if a person, my lord, he innovates something, my lord, the moment he files an application, that is the day, my lord. Logically, my lord, if in fact, this is, my lord, because that is the logic, my lord, also, my lord, if your lordship will kind, my lord, I'll come to that, my lord, also. 53, my lord, my first legal argument is 53 and section 11, 7A. My lord, they operate in very different fields. 7A is provisional, 53 is permanent, my lord. So there cannot be any comparison between the two sections, my lord. My lord, secondly, my lord, 7A, 11, 7A was not there in the statute, my lord. It had been brought in to give a temporary relief to a person whose application has been published. It may so also happen, my lord, that his application has been published, but when objections are called for, under process, when it is there, when objections are called for, my lord, it may be rejected. So we are at different stage, my lord. So there cannot be any comparison, my lord. The second, my lord, the other thing, my lord, he says, I'm losing. Now, when a person is granted, when his application has been published, my lord, it is that day. My lord, he is asking for changing of 53. At this stage, your lordship will kindly see the conduct. Patent is granted in 2012. He comes in 2024 saying amend 53. Why not amend 11A? If I may put this question to myself, my lord. Provisionally, when his application has been published, he should have, my lord, the other way around could have been, he could have filed a writ then saying My application has been published, but I am not getting right from 2005. My lord, what is the interest in seeking change in section 53 itself, my lord? My lord, the entire exercise is being done. He's enjoyed the benefit from 2005 to 2024. Next year, the patent is expiring. And this, my lord, there's a long delay and latches, my lord. This is an attempt, my lord, to get over, to do something indirectly, which is indirectly, and directly, my lord, I will also show his writ petition, which he otherwise could not have obtained, my lord. 53, my lord, in fact, takes care of the entire, my lord. Now here, my learned friend is coming under 53. He's been granted a patent, my lord. So if he says, my lord, first of all, on facts, he has to apply, my lord, let us assume that 53 is unconstitutional. He says it is ultra vires. My lord, now there's no argument in the writ petition how it is ultra vires. The body who has passed this legislation is competent. His only case can be that there has been a description, there's a discrimination, my lord. That is not his case. Now, to prove his case, my lord, I'll show what is argued in his writ petition. What is
here not discrimination. Here inherent contradiction in the statute.
My lord, inherent contradiction in the statute, my lord.
Ground, I'm saying.
My lord, let me take his case to the highest level. My lord, let us say there's a provision which is, for argument's sake, my lord, is unconstitutional. Even then, my lord, the law is settled, my lord.
No, we can read it down also to put it in consonance with some other.
My lord, now he has to come up that he is aggrieved with regard to some facts in the matter. A person just cannot come and challenge the law, my lord. It must be stitched with the facts, my lord. Your lordship will recall, I'll place that order also, my lord. These facts, my lord, he made a representation in those circumstances.
That will be a dangerous proposition for a virus challenge, Mr. Khan.
My lord, but I have to show it from the
that
facts,
would be,
my
because if you apply the facts post facto to the law, then so many draconian laws would go at the whiff of a court order.
Have to establish, my lord.
Don't put that I mean, power in the court's hand.
My lord, only, that is my lord, only argument on law which is merely academic without applying it to facts. He must establish how he has suffered. Lord, today,
what about the TRIPS agreement? You are tripping there every time.
I will, my lord. Only, my lord, the other thing, my lord, I will place the TRIPS agreement also, my lord. That
how is the TRIPS agreement relevant?
My lord, because the
in the
intention,
context.
yes, because the intention, why there's an obligation, my lord. India was also signatory to this agreement with, my lord, several other countries.
TRIPS agreement said that it has to be from the date of application. Don't change that.
Yeah, my lord, this is corresponding to Article 28 and 33 of the TRIPS agreement. The provisions of
28 and
33. It corresponds to that, my lord. And my lord, this, I'll place that also, my lord. This corresponds to Article 28 and 33, 11(7)(a), and my lord, Section 53, my lord. 53. It corresponds to that, my lord. Now, my lord, place, my lord, on the last occasion, your lordship wanted to see the Amendment Act of 2002. The object and reason, it was not
Why
there.
did I ask for it? What was my logic?
My lord, may I just place that? That is also very important, my lord.
In what context did I mean, anyway.
My lord, because your lordship was, my lord, interpreting 53 in that context, my lord.
Very good, yes. So
My lord,
you
this
get
is
that
at,
in your book? Yes.
Yes, my lord, it is there at the very beginning, my lord. The Patents Act, my lord, 39 of 1970, amendment of
2005 amendment.
My lord, may I? Yes, 2005 is there, my lord.
Yes.
Amendment of Amendment Act 38 of 2002, my lord. My lord, before this, may I show the statement of objects and reasons, my lord?
Of the 2005 amendment?
Of the 1970 Act, my lord.
Yes, absolutely.
My lord, in the beginning, my lord. Just beneath that is the statement of object of 2002. My lord, statement of objects and reasons. The existing Indian Patents and Designs Act was enacted in 1911, and since then, there have been substantial changes in the political and economic conditions of the country. The need for a comprehensive law so as to ensure more effectively that patent rights are not worked to the detriment of the consumer. My lord, may I pause here for a moment? It is not only for a patentee, it is also in the interest of the consumer, my lord. Or to the prejudice of trade or industrial development of the country was felt as early as 1948. And in that year, the government appointed the Patents Inquiry Committee to review the working of the patents law in India. My lord, then thereafter, my lord, may I just come down, my lord, to Amendment Act 38 of 2002, the objects and reasons, my lord. My lord, two major amendments happened, 2002 and 2005, my lord. The law relating to patents is contained in Patents Act 1970, which came into force on 20th April 1972. The act was last amended in March 1999 to meet India's obligations under the agreement on trade-related aspects of intellectual property rights, which forms part of the agreement establishing the World Trade Organization. Apart from the aforesaid amendment, the act has not undergone any change so far. Since 1972, there has been considerable technological innovation and development of knowledge, and the concept of intellectual property as a resource for knowledge-based industry has become well recognized the world over. Development of technological capability in India, coupled with the need for integrating the intellectual property system with international practices and intellectual property regimes, requires the act to be modified into a modern, harmonized, and user-friendly legislation to adequately protect national and public interests while simultaneously meeting India's international obligations under the TRIPS agreement, which are to be fulfilled by 31st December 1999. My lord, now, if your lordship kindly takes the next page, my lord, these are the salient features. I will write it down in the notes, my lord, as your lordship had said to write the provisions. Now, my lord, in these, if your lordship kindly sees, my lord, 4C and 4E, my lord, some of the salient features of the bill are as under. To modify Section 3 of the present Act to include exclusions permitted by TRIPS agreement, also subject matters like discovery of a living or a non-living substances occurring in nature in the list of exclusions, which in general do not constitute patentable inventions. My lord, C, to provide a uniform term of patent protection of 20 years for all categories of invention as per Article 33 of the TRIPS agreement, my lord. My lord, this is so that it's not only the patentee's interest, the interest of the business of world at large, my lord, the other. My lord, so this is one of the reasons also, my lord, why this has been done, my lord. And my lord, if your lordship will kindly take, my lord,
That's why 14 years was made into 20. There were two categories previously. One was 14 years, one was 7 years.
Made it to 20, my lord.
7
yes.
and 14 was made it to 20 to comply with Article 33, Mr. Kankani. I've looked into that.
Yes, well,
That
not
was the
just that,
tenure, not the commencement point.
But commencement point is the issue here. I will show it.
That is not part of the preamble, as
Well,
the
that is there in
statement.
the treaty. My lord, it records to bring that in consonance with Article 33. Article 33.
Sir Kankani, you are placing the statement of object and reasons,
My
right?
lord, my lord.
It is very picky and choosy regarding Article 33. This says the statement and object is regarding vis-a-vis Article 33
My lord.
to provide a uniform term of patent protection
My lord.
of 20 years
My lord.
for all categories of invention as per Article 33 of the TRIPS agreement.
My lord.
We have to read that much, no further, no less.
My lord.
So it's to ensure that the term is uniform,
My lord.
20 years
My lord.
for all categories of invention.
lord.
This is the statement.
My lord. And it is from the date of application. That is what Article 33 says, my lord.
Article 33 may say that,
My
but
lord.
that is not a part of the statement of object.
My lord, because if the time period is the same.
Because each country's statute
Yes.
may differ on the date of commencement.
My lord, it may differ, my lord, but here the tenure is very important, the time period, my lord, because of the technology, my lord. My lord, we cannot be, my lord, if something is happening in some country, some innovation in respect of something is happening during a particular time period, 10 years down the line, my lord, we adopt that, my lord, giving excess patent from the date of grant of patent. That could also, my lord, be a, my lord, so it's something to think about, my lord.
Yes.
My lord, now the other thing, my lord. My lord, if your lordship kindly, my lord, 7H, my lord, to harmonize, my lord, with the patent cooperation treaty to which India is a signatory, my lord, which I think I placed, my lord. Now, my lord, if your lordship will kindly take, my lord. My lord, just to reiterate, 11A7 has got nothing to do with 53, my lord. There is no conflict, my lord. He says amend 53 so that I get the right from the date of grant of patent, my lord. So, my lord, why not amend 11.7a, my lord? If I put this question to myself, my lord, the intention is very clear. Now, my lord, I'll place your lordships in the writ petition, my lord. I must place writ petition before your lordship, my lord, because that is very important. What is this case made out in the writ petition and the representation? What is arguing?
You won't place Article 33 first because we are on the law. Let us be on the law.
Well, I'm very sorry, my lord. I have not taken up. May I just place this?
If I give you my very well, I'll search on Google.
Well, I will.
I need the link only. TRIPS agreement,
my lord, and also Article 28, my lord. If your lordship will kindly
28 and 34,
30,
33.
I will, my lord. I will note it down in a.
So 33 says the term of protection available shall not end before the expiration of a period of 20 years, counted from the filing date.
Filing date.
So that is what you are.
My lord, that is what the
And
change has come.
and there is a rider to that. Filing date.
My lord.
It is understood that those members which do not have a system of original grant.
My lord.
May provide
My
that the term of protection shall be computed from the filing date in the system of original grant.
My lord. So this does not apply here, my lord, because he has come under 2005 and there's a.
Forget him. Now we are into TRIPS and you are.
My lord.
Pulling in Mr. Sinha and SABYASACHI Bhattacharya and all this.
So, my lord, the date is very clear. It is from the and 20. Date is from the date of filing.
28 now, yes. Rights conferred.
My lord. So this is the right which has been conferred under 11(7)(a), which was not there, my lord.
But it does not give a commencement point of the rights.
No, my lord. That is, my lord.
Rights are there. 28 is not relevant as
rights, my lord. I think my lord, may I just cross check, my lord?
You can read out.
Provisional.
You can just read out.
Because
এটা দিন খুব সাবধান পড়ে না যায়. You can read out.
My lord. A patent shall confer. A patent shall confer on its owner the following exclusive
This
rights.
is not so German, probably.
My lord, it is not. My lord, because 11, he wants amendment of 53. My lord, why not 11A? My lord, so, my lord, may I just place B, where the subject matter of patent is a process to prevent third parties not having owner's consent from the act of using the process and from the acts of using, offering, sale, importing. My lord, this is on the, that is why those rights under 11(7) have been given to him in the proviso, my lord. My lord, now, if your lordship will kindly take the writ petition, my lord. Well, all along he has argued there's a delay of 7 years, 7 years, 7 years. Now, when he summed up his argument, his case was, yes, there's a delay of 18 months. My lord, he's been shifting his stand, my lord. He's been shifting his stand. He has not been able to make out the case, my lord, in the writ petition. And what he's arguing is not there in the writ petition, except 53 is ultra vires. My lord, ultra vires is, my lord, subject to correction is by a body who makes the law who did not have the power, my lord. His case ought to have been, my lord, or any patent.
Not necessarily.
My lord,
ultra vires that
my
cannot.
lord, there's no discrimination. His case is not that of discrimination, my lord. He has to be very specific in his case.
Constitutionality is a test.
So he's challenging the constitutional validity of a section, my lord. So his pleadings must also be very, my lord, careful, my lord. He cannot, my lord, argue anything and plead anything, my lord. Lordship will kindly see his writ petition, my lord. My lord, my lord, 1, 2, 3, my lord, all these are just stated, my lord, from.
You read the grounds of the writ.
No. I'm just saying, my lord. Now, if your lordship kindly comes to paragraph 8. Now, how this writ petition has been couched, my lord. Your lordship never granted this liberty that you challenge 53. Your lordship said, challenge it, point is open on its own merits. Now, he is using paragraph 8, that the petitioner submit that the Honorable Court, upon hearing a review petition being number such and such, has been pleased to dispose of the review petition, granting liberty to challenge vires of section 53, 1970 independently, my lord, on its own merits.
Of course.
Your lordship, my lord, now I will show that, my lord, why I'm saying that, my lord. My lord, here my submission is no law can be challenged without the facts, my lord. He's come up for an academic discussion before this Honorable Court without showing any discrimination with any third person. Even if this section is bad, my lord, it applies to all. There can be 10 people who can have 10 interpretations to this, my lord. And it is the wisdom of the parliament, ultimately, my lord. My lord, secondly, my lord, if your lordship kindly sees, paragraph 9, the petitioner submit that due to non-consideration of petitioner's representation dated such and such and challenging the impugned section 53 of the Patents Act 1970, introduced by Act 39 of 1970 on date such and such, as kind interference of this Honorable Court is highly warranted. Now, my lord, your lordship will kindly take page 37. That is his representation, my lord. What is the case he's making out there, my lord? My lord, may I place the fourth paragraph from the bottom, my lord? That the government of India took fees for renewal for 20 years.
This is from?
My lord, this is at page 37 of the writ petition, my lord. My lord, this is the representation which he says he is aggrieved due to non-consideration of this, my lord. And
yes,
that the government of India took the fees for renewal for 20 years, that is 2005 to 2025. The period which patentee not received exploited due to patent was not granted by the government of India. That only after 2012, grant issuance of letter, patent certificate, and the patentee is able to file the enforcement proceedings before the court of law. Well, may I pause here for a moment? He has not shown that he has suffered because in 2010, somebody used this patent and he has suffered a loss. My lord, nothing is coming out from the facts in the writ petition, whether actually he has suffered or not. It is all hypothesis, my lord. No factual foundation in the writ petition, my lord. That despite the grant of injunction, my lord, now what is his actual grievance, my lord? Now that despite grant of injunction by the Honorable High Court on such and such, the government of India still not enforcing the said judgment orders passed thereon, for which contempt proceedings are going on. Therefore, despite High Court recognize the rights of patentee, the government of India is not enforcing the said judgment and orders and unnecessarily dragging the case so that the term of the patent could come to its natural end. As such, at one hand, government is belatedly granting the patent for 7 years of its application. Thereafter, despite passing of the 7 unused years, the government of India demanding and accepting renewal fees for the said unused period, meaning at the first, patentee has to compensate by giving off his tenure, thereafter by paying renewal fees for the unused period, which is a clear double jeopardy and in violation of Article 22 of the Constitution of India. As such, the continuance of the said impugned Section 53 by defining the term of patent of 20 years, and on other hand, granting of patent belatedly and thereafter demanding accepting renewal fees for unused period is a clear case of double jeopardy, and as such, undersigned most humbly prays for withdrawal amendment, rescinding of the said impugned section, being Section 53 of the Patents Act 1970, so the patentee can get his full 20 years terms of patent in true letter and spirit, my lord. Now, your lordship will kindly peruse your lordship's earlier order.
Mr. Kankani, this amendment of 2003 in Section 53 that has been made retrospective.
My lord, the
difficulty is in 2000 when he got the patent.
My lord, that was already there then.
It was already there, right?
It was already there,
right.
my lord.
Let us forget.
It is already there. His right is already there.
Yes, you're right.
Now, if your lordship kindly takes the order, my lord, your lordship's first order, my lord.
He entered into the thing knowing fully well, but now when it is going to, yes, that argument is always there.
In 2012, he could have filed a writ petition that I have got this, but I'm losing this period. Right, not that. At the fag end, my lord, he says, I'm at 53 to give me way.
Yes.
Now, your lordship will kindly see, your lordship has decided this issue on the facts of the earlier writ petition. Lordship has held that this 7 years, his remedy lies in damages, my lord. Your lordship will kindly take page 144 of the opposition, my lord.
Yes, because it was kept held up for so long.
That is the whole idea, my lord, under the Patents Act. My lord, may I give an example, my lord? Suppose, my lord, he shows in the writ petition or in any other proceeding that he has suffered any loss or damages, whatever it is, my lord, from 2005 to 2025, he is entitled to damages, my lord. Not today, my lord, he wants to give up that period from 2005 to 2012 and seek extension for 7 years from 2025 to 32. Now, my lord, whether the period from 2005 should be counted or whether it should be after the grant of patent 20 years, my lord, it squarely lies within the wisdom of the legislature, my lord. That is my respectful submission. Well, may I just place your lordship's order? This order was, I had to put it in the opposition, my lord. What your lordship has decided, my lord.
No, the order where I gave him the leave.
Yes, my lord.
So he has annexed
just 2 paragraphs. No.
He has annexed at page 39.
That is the review order, my lord. The main order by way of which your lordship had dismissed his writ petition, my lord. That is at page 1.
For 7 years, I am not bothered with 7 years. Definitely not. He's not going to get that 7 years. Because that chapter is closed.
And 2 judgments, my lord. May I, if your lordship kindly permits me, my lord? One is. My lord, this I am placing, my lord, just 2 paragraphs in this paragraph 314 and 1 more paragraph. I'll just point out, my lord.
Give the citations for
my lord. This is, well, I'm giving a copy to my learned friend.
Yes.
It is a case by my learned friend, my lord. May I just, my lordship kindly gives me a moment, my lord. Paragraph 3, my lord. If your lordship comes at page 3, my lord.
Yes.
My subsequently, second line, my lord, subsequently such order was modified to the extent that the respondents were directed to register battery operated eco-friendly e-rickshaws in favor of assignees of the petitioner number 1. My lord, he has assigned and he has come up before. Yes, he has assigned. He has come up before this honorable court. In this proceeding, the assignee was a party. Here, my lord, everything is suppressed. Lordship will kindly take paragraph 14 at page 5. Moreover, it is contended that the petitioner number 1, being the alleged patentee, assigns such rights in entirety in favor of the petitioner number 2, and as such does not have further locus standi to maintain the present writ petition.
This was the argument.
Well, this was the argument. My lord, I pulled out this judgment for other reason. My lord, I found this in this. My lord, your lordship will kindly take paragraph. Lord, your lordship has held in this judgment.
TRIPS agreement was considered.
It was, my lord. And your lordship dismissed the writ petition, my lord. On the, my lord, I'll place it, my lord. Paragraph 42, my lord.
That was on the concept of homologation.
My lord, and also, my lord, that if the statute does not permit, if it is not there, your lordship held, my lord, this does not lie
But
within
in that context only, when he filed the review, I had categorically observed that statute says this, you are bound by this,
my lord,
so you have to go by it.
My lord.
That's why his writ petition was
Yes,
rejected.
yes.
At the same time, I had observed that since he had not challenged the virus of section 53, I could not go into the question.
My lord, now, yes.
This will not preclude him from challenging the
My lord,
virus.
but it has to be on different facts of another matter, my lord.
No, he has to
Because-
independently show me that the virus is
My lord,
under.
because my lordship will kindly envisage a situation, my lord. One set of facts, my writ petition is dismissed, but a liberty is granted to challenge the virus.
Yes.
He comes on the same facts, my lord. My lord, facts are the foundation, my lord, to show any discrimination or whatever it is, my lord. My lord, that facts upheld by the division bench, my lord. Upheld by the division bench that yes, there's no
On
information.
the statute which was on that date.
No. On facts, my lord, I'm saying, my lord.
On facts in the context of the statute as it stood on that date, and it still stands.
My lord, he has to come up with new facts, my lord, because in respect of the same fact, my lord, order upheld by division bench, he comes back again and files a writ petition. This is a second round of the same thing, my lord.
All right.
My lord, your lordship will kindly take of this your lordship's judgment, my lord, paragraph 42. Just one more paragraph of this judgment, my lord. Providing a patent linkage to the page 18, paragraph 42 at page 18.
Yes.
Providing a patent linkage to writ petitioners in whatever form would be a controlling handle to the writ petitioners beyond the legal remedies available to them as provided by the Indian Parliament in its legislative wisdom. As rightly reflected in Bear Corporation, the court ought not to transgress the domain of legislation which reflects the opinion of an elected body of people's representatives by imposing theories felt prudent by the courts. Unless there's some specific violation of legal and constitutional rights and the boundaries implicit in the basic ethos of the Constitution of India, in the present case, the petitioners have failed to make out any commission or omission on the part of the respondent authorities which violates the boundaries of constitutionality or legal rights of patentees to justify granting the relief as paid.
These are not valid enough virus challenges.
These are not related to virus challenge.
This was rendered in the context of the statute being there, and if the statute is there, courts are bound by the statute unless we interpret it to be unconstitutional.
My lord, the question is whether whose wisdom is to be applied, my lord, when the parliament in its wisdom has chosen that the computation of 20 years will be from the date of filing of the application and not from the date of grant, my lord. My lord, that is the only
legislative wisdom has primacy, provided it is shown that
it has to be shown, yes.
Unless it is shown by the others.
Subject to judicial
But
review,
presumption is of correctness of a legislation wisdom.
Yes,
Definitely. There is no doubt on that.
One more
Cannot.
Of I'll just go 2 paragraphs.
Because we don't have the mandate of people. That is a simple reason.
My lord.
Actually, that our private ideas cannot substitute legislation. Unless it is shown, certain yardsticks have been put in by courts.
And your lordship will kindly see his pleading and
those yardsticks have to be definitely complied.
My lord. My lord,
those are
judicial
satisfied.
Review, I'm not, my lord, judicial review is there, my lord. There's no
judicial review is there, but judicial review under very strict circumstances.
Strict circumstances, my lord. So here a person said it should not be from this period, should be that period. Well, now who decides that? And who, my lord, the other patentee can come and say that it should have been from the date of application. I'll give it up.
Yes.
My lord, in this, my lord, kindly grants me a minute, my lord, in this judgment, my lord. My lord, now in this case, the facts of this case is...
Mr. Kankan will continue tomorrow because the original side I have to take up. Heard in part for further hearing tomorrow at 2.
Grateful, my lord.
অন্য থাকলে তারপরে থাকবে That is a difficulty, Mr. Mitra. এই অরিত্র দিকে এসো। নেক্সট ডেট বলো। Mr. Mitra, choose your date. No, I have both the dates free at 2. I'm at your hands. I mean the hands of the bar, because all the other 2 p.m. slots are fixed. So 29th and 30th are the 2 days which are at present available. So you take one. That definitely, yes. 30th, very well. তুমি একবার ম্যাটারটা কল করো ফর্মালি। কল করো ম্যাটারটা। 25, due to paucity of time, the matter cannot be taken up today. Hence, let the same stand over till April 30, 2024, when it will be taken up at 2 p.m.
This one is tomorrow at 2 p.m.
This will appear tomorrow. This will remain in the list at 2 p.m. tomorrow. I want to get it over with. Let us see if I can reach it.
Not more, my lord.
No, there is another 2 p.m. matter every day before 29th.
Yes, yes, whatever it is, my lord.
So
Not
whatever it
much,
is.
great.
With my lord's kind leave, may I mention the matter?
Original side?
Yes.
Let me officer come at least. Yes. Yes, Mr. Datta.
My lord, I am mentioning upon notice item number serial number 54 of the day's list. My lord, certain credit from my credit card, certain amounts were debited. About 2 lakhs. My lord, unauthorized transaction. I immediately complained, and my lord, I undertook all the steps that I was supposed to take. The writ petition was pending. It is being contested by the respondent, the bank. Yesterday, they sent me a notice that this amount is going to be deducted, and today it deducted from my savings bank account.
Cannot help, Mr. Datta. Cannot reach those matters because of the other top matters.
I have, my lord, also made an application annexing the, my lord, email that I received.
That will be taken up along with the writ petition.
My lord,
Cannot upgrade any matter.
may I only pray for one thing, my lord? My lord, let this money that they have deducted
Mr. Datta, I cannot pass
my lord,
orders just like that.
let this money that
Nobody
has been
take up the
deducted
matters.
from my account be kept in a separate
No,
account.
whenever the respondent is a bank.
It's a bank.
So what is the question of, I mean, your apprehension that the bank will flee with the money?
There is
The bank.
no free. They have taken it from my account. My lord, if tomorrow, my lord,
Whatever order, it will abide by the result automatically, Mr. Datta. I cannot. Call on the list, please.
May I be permitted to mention, ma'am?
Yes.
Item number 45 of the today's
Cannot
list,
upgrade matters, sir.
It's a very simple matter, my lord. The renewal of the passport is pending, my lord, since September 2023. My lord, there
I
are
understand, but cannot help it.
orders of the Honorable High Court at Delhi, my lord, that says the renewal of the
No, not right now. Call on
Item
the
number
list.
1 and 2.
Yes. Yes. Let us get it over with now.
Convenience volume to
Mr. Bhattacharya, put your main points in a nutshell and come ready with written notes of arguments. I cannot give much time to either of you. Thank you.
Just a convenience volume for your lordship. It's
Oh, yes,
all
yes.
recorded in the writ petition.
Right. Be precise, Mr. Bhattacharya, what is the point?
Lord, the writ petition here was initiated by Ram Kumar Jha, claiming himself to be a vice president at a point of time when he had admittedly put in his papers.
Right.
The fact of, my lord, non-disclosure of that document in the writ petition, my lord, whatever be the outcome of the writ petition, my lord, it is an action, my lord, akin to, or my lord, may, my lord, be stretched to an action, my lord, which is, there is an element of fraud. practiced on the
Mr.
court.
Shah, there are mosquitoes flying around. Yes. We have been able to mesmerize Mr. Shah, but not me as yet.
Lord, there is an element.
Akin to what? Fraud. Say fraud in his face. Yes.
Lord, why?
Elements akin to
Lord,
suppression, fraud.
Because,
Yes.
Lord, because non-disclosure of page 597 of the papers, non-disclosure thereof, my lord, has a bearing on the ultimate decision which your lordship has been pleased to hold. My lord, I am showing your lordship one by one. My lord, before I show your lordship 597, my lord, kindly comes to the judgment. My lord, I invited your lordship.
Mr. Bhattacharya, judgment is also annexed here.
Yes.
In this conversation.
Yes.
So let us.
It is, my lord,
since it
page
is-
57. It is, my lord.
Yes, I've.
F. Serial number F.
Right. Got it. 30th of January.
Yes.
Yes.
Lord, kindly comes to paragraph 7. I invited your lordship's attention to this. Although the petitioner resigned from his post as vice president by an email dated October 11, 2023 to the CA, requesting the same to be accepted with effect from October 7, as on October 10, when the show cause notice was issued, the petitioner was still a vice president. My lord, this is per se relying on, my lord, the documents disclosed in the writ petition. Then, moreover, my lord, paragraph 8. Moreover, the resignation of the petitioner was never accepted by the CA, and on October 14, that is, before passing the impugned order on October 17, the petitioner had already withdrawn his resignation. Hence, non-service of show cause on the concerned parties vitiates the same. My lord, this notice that your lordship is talking of in paragraph 8 is a notice of October 10. My lord, relying on paragraph 7. Now, my lord, please skip over. And my lord, kindly comes straightway to paragraph 19. Paragraph 20. At internal page 7.
Yes.
Your lordship has been pleased to record that the petitioner tendered his resignation on October 11, 2023. Thus, on the date of issuance of the show cause, that is October 10, a notice should have been given to the petitioner in the capacity of vice president, who was still functioning since the president had already tendered his resignation. This again is, my lord, relying on the averments in the writ petition and the documents disclosed. Then 23. Thus, I'm sorry, my lord, 21, that the petitioner Ramkumar Jha was acting in the capacity of vice president of the association at the relevant point of time. Clause 13(1) such and such of the bylaws stipulates who are the office bearers. As per the provision, the vice president of an association is included within the said office bearers, who are to be elected by and from the managers of the board. So, my lord, your lordship took him as the vice president functioning. Then 23. Thus, on the date of tendering his resignation, again, my lord, that is October 11, 23, the petitioner was the vice president. And thus, an office bearer within the contemplation of clause 13. Hence, the resignation of such office bearer could not be complete unless the matter was considered at a meeting of the board and the resignation formally accepted under the clause such and such. Then 24. In any event, the petitioner had tendered the resignation to the CA, but the same had never been accepted. My lord, there is, I'm not coming to that, that's a scope of an appeal. But, my lord, this resignation part all throughout has been, my lord, the October 11 resignation is being talked of here. On October 14, the offer to resign was withdrawn by the petitioner. Thus, there was no formal resignation at any point of time by the petitioner at all. Hence, the petitioner has the right to maintain the writ petition in the capacity of a vice president. And last, my lord, 26. Coming to the other issues, the petitioner is justified in arguing that the show cause notice was vitiated on several scores. First, it proceeded on the premise that there was a complaint by a member, whereas the complaint was not by a member. More importantly, the show cause notice was served as a personal email ID of the president, who had already tendered his resignation on October 7, had informed the same to the CA himself on October 9, 2023, prior to the issuance of the show cause. But then kindly comes to 28. That apart, there were at least 5 existing members, even apart from the petitioner, who was the vice president, none of whom were ever served with the show cause notice. Hence, no proper opportunity of hearing was given. And ultimately, my lord, your lordship has revived the position prevailing prior to October 7, 2023 at paragraph 38. Now, my lord, coming to the fundamental issue, my lord, Ramkumar Jha initiated this writ petition, presented this writ petition on his own personal capacity, claiming himself to be the vice president, and my lord, not disclosing, my lord, page 597. Now, my lord, in his affidavit in opposition, just to cut the matter short, my lord, in his affidavit in opposition to the present review application, this is his stand. My lord, kindly takes the affidavit in opposition by the respondent number 1. I just show your lordship 2 paragraphs.
Yes. Yes.
First is page 8, internal page 8. He says, somewhere in the middle, 10 lines from the top. I deny that I had suppressed my resignation from the BOM as alleged or at all. In my email dated this, addressed to the competent authority, I have clearly stated that I had tendered my resignation with effect from 7th October. I have duly annexed this email to the writ petition as annexure R1 thereof. Then, kindly takes the trouble to come to page 11, paragraph 16.
Yes.
I deny that I have played any fraud on this court as alleged or at all. I say that I have duly disclosed that I have tendered my resignation with effect from 7th October 23. However, such resignation was not accepted. I continued to hold the post of vice president. I say that on 10th October, I was a vice president of the association and I deny all allegations contrary. I say that the email dated 7th October 2023, copy whereof has been annexed to the application and marked as annexure L, that is page 597, was sent from my official email ID as vice president of the association to the president of the association at about 10:41 p.m. This email was sent from my official laptop, which was provided by the association. This laptop was subsequently made over by me to the added respondent number 6. It is now clear that the added respondent number 6 is acting in collusion with the private respondents, as the private respondents have obtained document being annexure L to their application from the added respondent.
So number 6, the president.
He is the administrator.
Yes.
And this is, Milord, in a way, he has admitted about the existence of the 7th October email. And he has also admitted, he has questioned as to how we have come into possession of this email. And he has, Milord, cast aspersions on the respondent number 6 by suggesting that, Milord, the respondent number 6 must have parted with this email and given it to us. Milord, apart from this, there's another issue which, Milord, also has a bearing. Milord, today the government of West Bengal has disclosed an affidavit to the review, Milord, stating Milord, in paragraph 5.
Found by Shuli Banerjee.
Yes. Milord, kindly takes the trouble to kindly come to paragraph 4 and 5.
Yes.
In this connection, it is pertinent to indicate and bring to the notice of this court that admittedly the respondent number 1, being erstwhile vice president, had already submitted his resignation on 7th October from the BOM as per the list of BOM and their status as on 7th October 23, submitted by the then president of the association on 9th October 23. As such, taking advantage of the same, the respondent number 1 herein had suppressed the fact that he had already resigned from the BOM on 7th October 23 and that he could not have held the post of vice president, nor did he have the right to represent the BOM. As such, he had no locus standi to file the petition. 5. It is further stated that as on date, as on date means on the 1st of March 2024, out of 45 managers in the BOM, already 43 of them has resigned, last of them resigning on 28th October 2024. 28th January 2024, leaving behind 2 members in the BOM. As such, in any event, they do not fulfill the minimum qualification in terms of bylaws such and such. Further, in absence of any provision for acceptance of resignation by any particular authority in the statute, the same is deemed final and cannot be allowed to be withdrawn at anyone's whims and wishes.
So this takes care of that observation that it was not
Yes,
accepted by
but
the.
I am not, troubling your lordship with that observation because that may sound to be an observation, which may be carried in appeal. But, prima facie.
No, an appeal was preferred.
No, no. From this judgment, no.
Was.
We have not preferred any appeal.
Very.
Here, your lordship is looking at a writ petitioner who has carried a writ petition to your lordship's court by, by not disclosing proper facts and not coming very candidly with all facts, whatever he has up his sleeves. Your lordship is looking at a writ petition at the instance of a writ petitioner who has suggested to your lordship that he has put in his papers on 11th and withdrawn on 14th, whereas, on the face of it, documents, subsequently, and, one humble submission, I do not want to, make anything, apart from the records. Admittedly, this document at page 597 was sought to be shown to your lordship by way of a supplementary affidavit at a point of time when the hearing was concluded and the judgment was reserved. So, in a technical way, it is not a non-disclosure at the time of hearing, yes, but post-hearing, prior to delivery of judgment, that document was brought to your lordship's kind notice. Your lordship disallowed. And, another thing, in the bunch of papers, your lordship will be pleased to find that they had, the gentleman, the president, had disclosed two names. Suggesting that these two persons are continuing or officiating the post, or they are taking charge, or they are doing the needful. Now, these two persons also had, tendered their resignation. In, there is an app in that housing complex, which is supposedly My Gate app. In that, things are uploaded. It appears that, on the 10th, there was an upload made in the My Gate app, where, including Mr. Jha, his name was also, shown to have resigned. And, on that date, 5 persons were remaining on that date. And, the persons who were shown in that letter, they were also, put in their papers, their documents, your lordship will be pleased to find at pages, 587, 588. Those also were not disclosed. October 8, 2023 and, October 6, 2023. Vikas Kumar and, the other gentleman is,
What are these documents? What are these?
These are emails.
To?
Addressed to Akshay and addressed to the association. And this also to the office bearers and board managers.
Very.
So, this being, the sum and substance, I respectfully say, that
this happened before the date of my order.
Yes, yes. And, this being the factual, backdrop, I most humbly request your lordship, that this judgment warrants a review. I don't propose to burden your lordship, judgment. This is, reported in 2007, 94 DRJ, page 338.
What is BRJ?
Delhi.
D.
DRJ. Paragraph 11. The only question, I'm sorry. Mr. Mukherjee request me to read paragraph 10 also. Thus, omission and concealment, I'm sorry.
Yes. Omission and concealment.
Which involves breach of legal or equitable duty and confidence justly reposed is equal to fraud. Similarly, the Supreme Court in such and such reported in such and such has held that suppression of a material document would amount to fraud on a court. In another case, in such and such, the Supreme Court was critical and did not agree with the High Court that there is no legal duty cast upon a party to come to the court with a true case and prove it by true evidence. It was held that fraud is an act of deliberate deception with a design to secure something by taking unfair advantage. Deception to gain by another's loss is fraud. Failure to disclose relevant and material facts and non-mentioning of even a document can tantamount to playing fraud on the court if it is done with the intention to gain advantage with a view to procure and obtain procure an order or an advantage from the court without disclosing all facts. Obtaining relief by deliberately suppressing facts which were fundamental to entitlement of relief and foundation of the claim amounts to practicing fraud. Then, my lord, the only question is whether we should entirely recall our judgment and order dated such and such in view of the admitted position that the petitioner had worked during the period such and such. To follow the second option will be put to the petitioner in the same position in which he would have been if the true facts were informed to this court before the judgment was delivered. This would not meet the ends of justice. By doing so, the petitioner would be let off lightly and will send a wrong signal to litigants that they can conceal material and true facts and then get away with relief even after fraud is revealed. This will result in miscarriage of justice. Much harsher and stricter order is required in such matters. Confidence of the court is betrayed. A writ court is a court of equity, and exercise of jurisdiction is discretionary. Parties must approach the court with clean hands by disclosing true and relevant facts. A party concealing facts to obtain relief which he does not deserve cannot be let off. Accordingly, we feel this. But this is one. Milord, I'm sorry. I should have also shown your lordship paragraph 14, which says, Milord, the order may be reviewed or recalled, both. Milord, we may mention here that we have exercised our power and inherent with a court to recall an order and not merely exercise right to review an order, such and such. Order 47 of the court applies when a new and important evidence, facts come to the knowledge, notice of one of the parties which were not known earlier. There is nothing on record to show that any clearance was obtained by such and such police verification. Then thereafter, in the facts of that case, this is the judgment which has been relied on in this, 94(1) SCC page 1. This is on fraud. Judgment and decree obtained by fraud. Paragraph 5, to be precise, Milord. The short question before the High Court was whether in the facts and circumstances of this case, Jagannath obtained the preliminary decree by playing fraud on the court. The High Court, however, went haywire and made observations which are wholly perverse. We do not agree with the High Court that there is no legal duty cast upon the plaintiff to come to court with a true case and prove it by true evidence. The principle of finality of litigation cannot be pressed to the extent of such an absurdity that it becomes an engine of fraud in the hands of dishonest litigants. The courts of law are meant for imparting justice between the parties. One who comes to the court must come with clean hands. We are constrained to say that more often than not, process of the court is being abused, property grabber, etc. Then, Milord, in the context of this. So, Milord, the first and what I am trying to, press reliance specifically on is this: the principle of finality of litigation cannot be pressed to the extent of such an absurdity that it becomes an engine of fraud in the hands of dishonest litigants. And Milord, last on this, Milord, it appears from one of the documents, annexure O to my affidavit in reply, Milord, where, Milord, it has been where it has been, Milord, this is page 21. Milord, that is the last document of the compilation that I have handed over to your lordship. Last document. These persons have said, Milord, this is addressed to the special officer appointed by the government. These persons have said, we all...
After the order, after my order.
Yes. And this is after... Before your lordship's order. 20th October 2023. 20th October 2023.
My order was dated?
Milord, this is 17th of 30th January 2024. There, my lord, he has said, they have said, we also wish to bring to your notice that the writ filed by R.K. Jha, who is claiming to be the president, is purely on an individual capacity and he has no vested right on the chair. We are not aware of any meeting of the board of managers which has been convened, nor any resolution by the board to make him the president. Moreover, we record that neither have we withdrawn our resignation nor are inclined to do so. Kindly listen to the first two names here.
Is this German? Is this does this come within the purview of Order 47?
My lord, what I am trying to show your lordship is, my lord, a strong reliance was placed on the president's communication.
Cannot look into new evidence in review.
Very, your lordship need not.
This will be taking it a bit too far, despite whatever Mr. Mukherjee says.
Well, he wants me to cite another judgment, my lord, kindly.
No, do that.
My lord, I am sorry.
Don't multiply this.
My lord, only the judgment I have shown from the Delhi High Court.
Yes, which is the
No, that
paragraph
is-
you have missed.
My lord, paragraph 7, last portion.
Yes. Premeditated and intentional
No,
contrivance.
the petitioner, non-applicant, was fully conscious of the relief he had prayed for and claimed that the order that the Lord has, my lord, kindly got.
The more you try to mellow down the allegation, Mr. Mukherjee is inciting you to make it harsher. Anyway,
Well,
so I'll take note of this.
This.
From there to the end of that paragraph.
My lord, the SLP filed from this judgment was withdrawn. That is just for records. My lord, those are my submissions in the review.
Yes. Yes, Mr. Thakur.
My lord, I will refer to the papers, my lord, as they are. I have not been convenienced with a convenience compilation.
Oh, acha. Mr. Bhattacharya, give a copy of the convenience
No,
compilation.
my lord, now I have made my notes here. So
Anyway, we'll read
I have
from-
also not been favored with the affidavit which the competent authority has filed before your lordship, my lord. I will restrict my arguments, my lord, to the judgment which is under review and now to the new ground which is sought to be raised before your lordship. My lord, a lot has been said about fraud and suppression. The impression which is given to your lordship is this, that they were not aware of this tendering of resignation, if at all it is a material fact, because your lordship has dealt with this. Paragraph 25 of your lordship's judgment, all this, whether I was president, not president, was argued in the context of my locus to maintain the writ petition. In paragraph 25 of your lordship's judgment, your lordship has held that irrespective of whether he was president or vice president or tendered his resignation or not tendered his resignation, the fact remains that he's a member of the association and he has a right to say how the affairs of the association are administered. Kindly come to paragraph 25, please, my lord. At page 8. If I may just place paragraph 25, my lord. Even otherwise, I'm sorry. Well, kindly see paragraph 17 once, please, where this argument starts. This argument was raised in the context of locus. Kindly see paragraph 17. That apart, learned counsel for the respondent numbers 3 to 5 hits at the locus standi of the writ petitioner who has tendered resignation. It is contended that borrowing from service, jurisprudence, etc. Last sentence, hence the petitioner having resigned as a vice president cannot maintain the writ petition. In this context, now your lordship's discussion at paragraph 19 onwards, issue of locus is considered, irrespective of whether I tendered, did not tender. Kindly see paragraph 25. Even otherwise, the petitioner is admittedly a resident and apartment owner in the concerned apartments. Thus, the petitioner definitely has a right as resident and a member of the society to have a say in proper administration of the society. Such interest of the petitioner is direct even in such capacity. Hence, the petitioner has the locus to maintain the present writ petition from every perspective. This is not assailed before your lordship, cannot be assailed in review, if at all, can be challenged in appeal. So, my lord, the question of whether I tendered my resignation
The vice presidency was not a German factor at all.
is one of the factors, but is not the sole factor on the basis of which your lordship has decided the maintainability of this writ petition. Today, my lord, all the arguments have been urged on locus. Day 1 locus, day 2 before your lordship also locus, but locus is decided not on one factor, 2 factors. The second factor cannot be denied even today. Now, my lord, so much has been said about suppression that I have suppressed this. All that I have said is that in my email to the competent authority, I have said I have resigned with effect from 7th. So there is no suppression. B, the issue is, my lord, was this fact known to my learned friends when this writ petition was heard? They don't say when they came to learn of this for the first time. If this is supposed to be a new fact, some new document which they get, were they aware of this fact or not before the writ petition was heard? Kindly come to, my lord,
volume 1, paragraph 17, page 10. This fact was known to them before the writ petition was heard. It's their own avowment. They may not have had the document, but kindly see 17A. On 10th October 2023, for the first time, the review applicants came to know from the MyGate app, which my learned friend talks about the resignation of Ram Kumar Jha, the writ petitioner. This fact was known to them prior to the filing of the writ petition. This is not a new fact which has been discovered subsequent to Malad, the order being made, which can be a ground for review. The email which I sent from my official email ID from my official laptop was neither available to me, but the fact was known to them. Fact of my having tendered resignation on 10th. 10th October, they came to know that I had tendered resignation from the MyGate app. So this is not a new fact. Entitling them to beseech your lordship or invoking the review jurisdiction of your lordship. As is what is now made out on the basis of this email, that this email was suppressed, therefore I come before your lordship. I come to learn, that is the reviewist comes to learn for the first time that I had tendered on 7th. That is incorrect from his own avowment.
Would it have made a difference, Mr. Thakkar?
It would have not made any
Why
difference.
do you say that?
It would have not made any difference. Because, my lord, kindly see, your lordship has discussed all this in the order. The only person...
I proceeded on the premise that on 11th, you tendered your resignation with effect from 7th.
7th. The 7th date is
14th
there.
you withdraw.
I withdrew.
And what happens?
Now, my lord, kindly bear in mind two things.
Yes.
This email of 7th is not addressed to the competent authority by me. The decision which is under challenge is the decision of the competent authority in the writ. The decision has to be seen on the basis of the reasons given in the decision. Today, those reasons cannot be improved. That is settled law, my lord, as far back as in 1978, 1 SCC 405, Mohinder Singh Gill versus Chief Election Commission. The reasons given for a quasi-judicial or a statutory authority's order have to be found from the order itself, cannot be supplemented. So what was the ground, my lord, for my coming before your lordship, assailing the decision of the competent authority? That competent authority, my lord, kindly see his submissions in paragraph 15, and now the volte-face which is sought to be made. Obviously, the review applicants have long hands, my lord. Kindly see paragraph 15 of your lordship's order, and how the competent authority in this affidavit is now trying to change its stand. Kindly see paragraph 15 of your lordship's order, what the competent authority submitted on that date.
Yes.
Now, my lord, kindly see, learned counsel for the competent authority candidly submits that no copy of the complaint petition was given with the show cause notice. This was the first ground which I have urged. I am required to show cause. You are requiring a president to show cause who, to your knowledge, has already retired. President had addressed communication to the competent authority that I am resigned. You issue him a notice to show cause, but you don't give him the grounds. And now he admits that, yes, the grounds on which to show cause was not even given to an erstwhile president. Then he says, moreover, it is submitted that in view of the fact that the board members were reduced to only 5, upon mass resignation being tendered by around 40, and all the office bearers in the interest of proper functioning, the impugned order was passed. My lord, the Apartment Ownership Act requires not less than 3 to be there at any time. There were 5 even according to the competent authority. My lord, what was being tested was the knowledge of the competent authority when it issued the show cause notice, and what was in the knowledge of the competent authority when it issued the order of dismissal or removal. When it says the entire board has become kaput, on that date he knows there are 5 persons there. He knows. It is his knowledge, my lord, not my learned friend's knowledge. If he was, my lord, before the competent authority, he would advise the competent authority that 5 people are there. Even then, the competent authority could not have come to the conclusion kaput, because it has to be 3. The resignation has to be accepted by the board, not by the president, not by the competent authority. The bylaws provide for that, my lord. Kindly see the bylaws once. I'm sorry to re-argue all this. All this was argued before your lordship earlier also. Kindly see 13(2)(b) of the bylaws. Resignation of office bearers. Competent authority is not the authority to is not competent to accept resignation, my lord, the president, secretary, or any other elected officer may resign his office by any time by a notice to the board addressed to the president or the vice president if the president resigns. So here the president has resigned. Now let us say even the vice president has resigned, it has to be addressed to the board. On receipt of the notice, the board shall as early as possible at a meeting consider the matter, and on the resignation being accepted, there has to be a board meeting. Neither, my lord, the competent authority says there's a board meeting, nor my learned friends even in review say that there was a board meeting accepting the, my lord, mass resignations which were given. Shall forthwith elect another officer from among the members in place of those who have resigned. So office bearers have to be, and if there is any vacancy, my lord, then it provides for holding of a special general meeting to fill up that vacancy. Kindly see, my lord. Holding of special general meeting to fill up the vacancies at clause. Kindly give me a minute, my lord. (10B) of the bylaws. Kindly see 10B, please, my lord. Any other casual vacancy, manager may be removed. And then kindly see any other casual vacancy in the offices of any manager by resignation shall be filled up through a special election for this purpose. The board shall take steps to hold special election for this purpose within 6 weeks from the date of the vacancy. Election shall be held in the manner prescribed. So I had 6 weeks. There were 5 people present in the board. Elections could have been held. Before that, the competent authority comes in, gives a notice to somebody who's already resigned, does not give a notice to the official email ID of the association, and my lord, the entire board is removed. Then, my lord, kindly see 2 findings in your lordship's order once, please, my lord. Kindly see, my lord, paragraph. So paragraph 25, your lordship has seen. And your lordship has held on this, my lord. Kindly see paragraph 23, please, my lord. When your lordship is deciding the issue of locus in paragraph after paragraph 19, kindly see paragraph 23. On the date of his tendering resignation, that is on October 11th, that is submitting to the, bringing to the knowledge of the competent authority that I have tendered resignation. Petitioner was vice president, thus an office bearer within the contemplation of clause 13. Resignation of such office bearer could not be complete until the matter was considered at a meeting of the board. Resignation formally accepted under 13(2)(b). And then, my lord.
So you say the same logic also applied, would have applied to October 7th?
Yes, October 7th also. Nothing changes. And I have only informed the competent authority that I have resigned. He is not the authority to accept my resignation. He cannot accept my resignation in violation of the bylaws. Which
you did not inform the competent authority, you informed the president.
I informed the president on 7th.
7th.
Yes. So which they say?
11th also same.
11th to the competent authority. But there, my lord, I was honest enough to say with effect from 7. So they can't run a case of fraud against me. This case of fraud which is being run against me, my lord, is most unfortunate from his own pleadings in 17A that he came to know of my resignation on 10th. Now to come up and trouble your lordship in the review jurisdiction is very unfortunate, my lord. To say that he came to learn for the first time of my resignation of 7th when he comes upon this email, which now this gentleman has handed over to him very conveniently. Now, my lord, kindly see 2 more findings in your lordship's order, my lord. Paragraph 25, your lordship has seen. Now, my lord, kindly see paragraph 26, where your lordship has decided on whether there was a genuine complaint or not. Coming to the other issues, the petitioner is justified in arguing show cause notice was vitiated. Proceeded on the premise that there was a complaint by a member. Complainant was not a member. The show cause notice was served on the personal email ID of the president who has already tendered his resignation, informed the same. On 9th, that is prior to the issuance on 10th. Even after issuance of the notice, the president informed the CA that 2 members had taken up the duties. Then, my lord, kindly see 28. That apart, there were at least 5 existing members, even apart from the petitioner. So 5 members apart from the petitioner who was the vice president, none of whom were ever served with a show cause notice. This is on the submissions of the CA himself. None of them were served. No notice was given at all to the existing board to set up a defense. Then, my lord, kindly come to, we never had any opportunity to deal. Then, my lord, kindly see paragraph 30. The show cause notice is also vitiated on other serious grounds. It is settled that any show cause notice had to mandatorily contain the specific particulars of the offense which are alleged. Whereas the only premise of the show cause notice was a complaint petition which was claimed to have been enclosed, it has been admitted by the CA that the said complaint petition was never actually enclosed. With the writ petition, this should be the show cause notice, not the writ petition. That's a typo.
Yes.
Yeah, with the show cause notice or served. The show cause notice contains no specific allegation of offense apart from those mentioned. Then, my lord, kindly sees the order is impugned on vitiated grounds. Beyond the statements in the show cause notice, the order of removal is beyond the allegations in the show cause notice. Not only were they never mentioned, particulars of the same were not discussed in the impugned order, nor were copies served on the board. Then I did not have any opportunity. The CA in the impugned order mentions that a number of other BOM members have also sent their resignation, kaput, non-function. Defies logic as to how merely due to resignation an entire board. Then, my lord, your lordship has referred to 10B of the bylaws about constitution of holding of the special general meeting. Then, my lord, kindly see, moreover, the reduction of 9 members of a board below the stipulated quorum as provided in clause 7(2) of the bylaws is not a valid ground for removal of the board altogether under section 16B. 16B now, with the power which has been exercised in 16B, does not say that the board has become kaput, non-functional, non-effective. Is not a ground available for removal. So, my lord, your lordship has not held on one. Then 16B2 has been resorted a functioning of a BOM to be detrimental to the interest of the association or against public interest, none of which has been established or reflected. Although the CA has made a bold statement is for the proper functioning, it is imperative to supersede. Statement is not supported by any reason whatsoever, nor any material or evidence has been adverted to or discussed by the CA in coming to such a serious conclusion. Particulars of the complainants have not been discussed while arriving at such a conclusion. Conclusion is palpably perverse. So the only issue now urged is locus, which is even otherwise I have locus by reason of 25, which is not assailed before your lordship. And there were serious infirmities in the notice and in the order, and the entire process was vitiated. Those are my respects.
Yes, Mr. Bhattacharya. Reply. Wake up, reply.
Kindly comes to page 372, volume 3.
Yes.
Milord,
372, right. Yes. What is there?
kindly see, this is a supplementary affidavit filed in connection with the writ petition. Affirmed on 12th of affirmed sometime on 5th of December 2023. Milord, in this, Milord, kindly compares this with page 582.
What is there? Tell me.
Milord, this is, he has disclosed this document. Milord, this letter, communication from ex-president, BOM, Kolkata, Milord, this document 383, Milord, 383 is a document addressed by the ex-president, Milord, to the competent authority. To the competent authority, where the ex-president says that I have resigned on October.
I am not here rehearing the matter on merits.
No, Milord, only
You have some mistaken notion there. This is a rehearing of the matter. This is not a review ground at all. Sorry.
Milord, what I am respectfully trying to, Milord, lay stress, emphasis on is, Milord, the
Your
document
is the 7th October document.
597 document,
Yes.
read with page 580, 380, 582, 83, 84, and 85. Those documents. 585 is a document, Milord, where all these persons have demitted office. And, Milord, it includes, Milord, on the date when, on the 7th.
This is a discovery of new matter.
Milord, this is, this document, Milord, I have explained it in my affidavit.
How?
Kindly see.
These are not available to you.
Yes. Paragraph 14, page 9.
Yes.
I have said in paragraph 14, after conducting due diligence, it came to the notice of the writ petitioners, applicants, that on 27 January 20, that there were only 3 managers serving on the board of managers as opposed to 5 as claimed by the petitioner on the basis of averments made in the affidavit in opposition filed by the competent authority, as was also denied option by the council. It also transpired that the writ petitioner had suppressed his resignation from the BOM as well as his responsibilities on the board, a consequence on 7th October 2023. It is there then 17. Here we have said on 10th October, for the first time, the review applicant came to know from MyGate app about resignation of Ramkumar Jha among 36 out of 45 board managers. The said document had been suppressed by the writ petitioner in WPO. A copy of the notice dated this, as uploaded in MyGate app, is annexed.
You could have disclosed. Yes. You learned on 10th of October.
This document, because
why didn't you disclose?
Huh? No, this document, why did we not disclose? We haven't disclosed. We have sought to disclose it after conclusion of hearing.
You have not disclosed, and you are arguing that they are guilty of suppression.
That document, 7th October, is not disclosed by us. 7th October, we have come to know after closing of arguments. And 7th October has a bearing. Kindly, my learned friend invited your lordship's kind attention to 13th
October 2023. For the first time, you came to know that MyGate app, from the MyGate app, that resignation, Ramkumar had given his resignation.
Ramkumar's resignation letter was not there.
Maybe,
what was there is page 582.
You came to know that he had resigned?
No. What we came to know is this list at page 585. The status of the BOM at page 585. What we wanted to show by this was, as on the 10th of October or 8th of October, the status of BOM was this at page 585. 585. And 585 would show.
The new discovery of new material is that 7th October email, actually.
Yes.
Which you found from his
and computer. All the other emails, the email of Prakash, the email of Akshay Prakash and the other gentleman.
So how did you find it afterwards? The email?
And here we have come to know, on the 27th of January.
How did you come to know?
We came across, documents. We could lay our hands on documents which was not.
To explain that, Mr. Bhattacharya, if you are to convince the court that you came to know later, you have to disclose your source of knowledge.
I have, kindly takes the trouble to kindly come to.
There's no competent authority. It constituted.
Paragraph B, 17B, page 10. We have come to know, we had no access to the board of, the ex-board of managers gave us this document.
7th October document, how did you get a copy of that? I'm asking that only.
The ex-board of managers gave us.
Where is that?
I'll just. Paragraph G, page 12.
How did you get a copy of that or come to know? That's not explained in Paraji.
He has said it, Read
it out. What does it say about your knowledge of that document?
We have come to know upon inquiry, we have said. We have said on inquiry, we have come to know.
Inquiry, you came to know about the 7th October document. Where have you said that even?
That. 17B.
This does not speak about 7th January.
Paragraph 14 also, paragraph 14.
Not also, because this B does not speak about.
Kindly see page 9, and just one last note. After conducting such due diligence, it came to the notice of the writ review applicants on 27 January 2024. Page 9, that that there were only 3 managers serving on the BOM as opposed to 5 as claimed by the petitioner on the basis of this.
What is the annexion number of page 587? Page 587 is the 7th October email.
597 is the 7th October.
597. What is the annexion number of that?
597 annexion number is annexure L to the review application.
L. So let us.
No, that is 12. Page 12.
You're putting it, yes. G.
Yes.
G is your
yes.
averment on that. Let us see G. Nothing. So how do I know that it was a subsequent discovery? Discovery of new matter?
Reading it together with paragraph 14. Reading it together with paragraph 14 and the supplementary affidavit that was sought to be used, in course of the hearing, which is a part of the records. I can show your lordship, the pleading from the supplementary affidavit.
Their supplementary affidavit cannot disclose your knowledge.
My supplementary affidavit.
Your supplementary affidavit, Mr. Bhattacharya,
was not taken on record.
No.
Was not taken on
record.
record.
Hearing is concluded, nothing can be taken on record. I am clear on the law on that. Please test that before the appellate court.
There's no question of testing it.
No, absolutely. Why not?
No.
I'm very clear on the law that after hearing is concluded, judgment is reserved. We cannot take in any pleadings in any form whatsoever. No court in any legal system that I know of, Mr. Bhattacharya, I know of very few, permits that.
Even before,
unless it's before the appellate authority, order for
our special bench judgment read with the Supreme Court judgment says that before signing the judgment, assume your lordship has delivered a judgment.
Yes.
Before signing, if it dawns that some fact was missed by your lordship may put the parties on notice and conduct a re-hearing.
The discretion vested entirely on the court.
Yes.
Entirely on the court.
Yes. That is
don't have a right
open
of
to your
any pleadings. You don't have a right. The parties do not have right of.
If a material is discovered,
even Mr. Bhattacharya, Code of Civil Procedure is very clear on this. If the hearing is concluded and the party dies, no substitution is necessary. If a judgment is passed, that is not vitiated for nullity. Even if a party dies, what can be more serious than that? Brush up. You cannot file any pleading after the hearing is concluded. It's entirely on the court to think on the whatever hearing is concluded and pass his orders on that. You cannot have a right to put in any pleading on record.
I cannot put my case on a higher pedestal than whatever is there stated. But the fact remains, non-disclosure of 7.
No, I don't castigate you for not disclosing it. My only point is, as Mr. Thakkar has taken a valid point, that if you have to show discovery of new matter, because this is not error apparent on the case of face of record. If it was
from the judgment, your lordship has all throughout,
there is no
speech anchor of the entire judgment is 11th resignation.
Absolutely.
And 10th, he should have been put on notice.
Bhattacharya,
says,
look,
I'm sorry.
10th, the plinth of the judgment is the plinths of the judgments are whatever documents are produced before the court. You say that 7th October document was there, which was never produced. Not produced by him, not produced by you. Nobody produced that. So that could not be a basis of my order or any court's order. You say that I have subsequently found that document and produced it before your lordship. So this is a discovery of new matter. This cannot come under the purview of error apparent on the face of record because of the simple reason that as per your admission, it was not on record on that day, for which ground you are saying that they are guilty of suppression. If they are guilty of suppression, by very definition, suppression means that was not produced before the court on that date. If it was not before the court on that date, it could not have been an error apparent on the face of the record. A document which is not there on record cannot be a basis of error apparent on face of record. Second ground is discovery of new matter. You have to then establish that you have discovered the matter subsequently. Where is that averment even in your review application, Mr. Bhattacharya?
May I most humbly, answer your lordship that, the 7th document.
7th October is the document I am speaking about.
But 7th October document has a bearing on the ultimate conclusion. And therefore, that in my most respectful submission, on being shown.
Please read out order 47 once.
Your lordship knows better than me, I cannot, improve on whatever there.
No, I don't know better than you. Please read out order 47.
Your lordship is correct.
Tell me which of the grounds is satisfied. Any other reason, any other ground.
I say that, this document, my lord, ultimate conclusion reached by your lordship has a bearing on the ultimate conclusion. On the ultimate conclusion, because your lordship's reasoning, my lord, or the reasoning, my lord, given by the court is based on the premise that, my lord, 7th October resignation did not exist.
Yes.
Did not exist. Whereas, my lord,
So it was not at all on that presumption. That 7th October
that is the presumption.
which is not produced before me, that could not be a presumption on my part that a document which is not produced does not exist.
Judgment was on.
I neither found that it does not exist nor it exists.
My lord, I
Because
say,
that document was never produced
I
before.
respectfully say that is your lordship's presumption, the premise I am saying. My lord, the premise, my lord, the fulcrum on which, my lord, the judgment was resting is that, my lord, the gentleman was there on the 10th and he should have been put on notice. Having not put him on notice, the reasoning or the decision is vitiated. That is what your lordship was pleased to hold. But, my lord, I respectfully say that, my lord, the finding reached by your lordship is per se erroneous because of page 597. Because
it was not there in the writ petition.
Which is now being shown to your lordship.
At the review stage.
Persuade your lordship to hold otherwise.
What are you arguing? You have crossed that stage.
My lord, what is sought to be shown to your lordship is that this document, non-disclosure thereof, vitiates the ultimate finding.
Very well. So you are on which you have cited that it can be more than review. Because Supreme Court, you have cited a judgment and the Delhi High Court says it can be recalled also while there is a...
Pardons me for saying this, my lord, your lordship is, my lord, this is, I need not urge this or say this. This is an Article 226 proceeding. In a proceeding under Article 226, the principles of Civil Procedure Code do apply. Review we have filed on the basis of those principles, but at the same time,
please argue, Mr. Bhattacharya. I'll be pleased to deal with that. That Order 47 principles do not apply in a review.
No, I'm not saying.
Please argue that. It will be most welcome. That will be a landmark judgment for any High Court.
What I am on is that,
please convince me that Order 47 principles don't apply.
Justice
with or without an S. Because if it is the arbitrariness of the judge, Mr. Bhattacharya, whatever I feel is justice, that would be palpable arbitrariness. No, it has to be by the parameters of law, Mr. Bhattacharya. Satisfy me on the parameters of Order 47. I'll tell you, I'll be the best court in review. But if you can't satisfy me on Order 47 parameters, then how can I interfere?
Order 47 parameters is one aspect of the matter. The other aspect is, my lord, on the justice part. On the justice part, my lord, this is an Article 226 court, equity court. A person comes to court with clean hands and paying for an equitable relief, which is discretionary.
Right.
Which is discretionary.
That's what I'm saying. The Delhi High Court judgment you have cited also goes beyond review. It can be recalled also if there is a material suppression.
If it is prima facie established, that, my lord, today, my lord, kindly, my lord, I'll take just another second.
Fraud vitiates all, Mr. Bhattacharya.
Seconds, my lord.
It takes less than that. Fraud vitiates all.
Yes.
That's the primary argument.
My lord, today, my lord, the source of a particular document, wherefrom I have got hold of a particular document, in a writ court, ordinarily is never in question when the authenticity and genuineness of the document is not in dispute. My learned friend in his affidavit has admitted...
Mr. Bhattacharya, your arguments are entirely misdirected because I am not eager to know the source of your document. I am eager to know the source, the date of knowledge of your document.
27 January 2024 is the knowledge.
In your review application, you have said, that on 7th of October, you came to know that he has resigned.
No, with respect, no, my lord. Kindly pardons me, my lord. On 7th of October, my lord, I have not come to.
10th of October.
That is, my lord, that is that list. That is for the purpose of demonstrating that, my lord, on the 10th, who were the board managers, which included Ram Kumar. Nothing else. But the fact of his, my lord, the factum of his, my lord, resignation of 7th was not known to me till the 27th. Supplementary affidavit, file is it a part of the records? Is it a part of the records? No, it is not a part of the records. But we had wanted to use a supplementary affidavit, of course, not after conclusion of hearing, but before delivery of judgment. That supplementary affidavit...
Argued it so much, Mr. Bhattacharya. Definitely, I'll take it as a solid point of yours. And I'll deal with that. That supplementary affidavit was sought to be filed, but not permitted.
Kindly, I'm sorry. Just
give me the date when you tried to file the supplementary affidavit?
My lord, that is, your lordship is concluded the hearing. I'm just giving it. Just give 29th of January. My lord, just gives me, my lord, I'm reading
your
paragraph 19. After
Just tell me the date.
29th January,
And when was the hearing concluded?
17th of January. Now, after judgment has been reserved in the matter, and after having gone to extreme lengths to find out pertinent information about the status of BOM, the review applicants came to discover such new and important matters and evidence. In order to place the same before this court, the review applicants had affirmed a supplementary affidavit on 29 and had sought leave of this court to file the same. The Honorable Court was pleased to refuse such leave, and the same has been recorded in the judgment dated 30th January 2024. The review applicants crave leave to rely on the supplementary affidavit affirmed by the respondent number 5 on 29 January 2024.
Just wanted to know the dates.
Yes.
29 was a Monday. We came to Friday we could not go. Saturday was we worked with 29.
Yes.
The 29th was apparently a Monday, and we came to know, I mean, on the last Friday.
Monday? It
So
was a
that was-
Monday.
that was-
Good to know that, but
That is the, this is the factual thing, Milan. I am not.
should I note Monday also?
No. I am only requesting your lordship to kindly, my lord, irrespective of anything, my lord, in an
Kindly allow this
article,
to happen. Kindly allow
in
this to
article
put it in short.
226, my lord, your lordship is hearing an article 226 proceeding.
No,
It is
I'm
not-
hearing a review application from an article 226.
My lord, but my lord, the primary writ petition is of is an writ petition under article
Was
226.
past tense.
The writ petition is under article 226.
Which has been disposed of. There is a review application from that.
And my lord, in the event, my lord, I just was putting this question to myself, my lord, if a document which prima facie has a bearing on the ultimate decision and was not disclosed and was admittedly not disputed in the affidavit, my lord, the effect thereof kindly decides. I am
I'll
not
have to
troubling.
decide the effect, Mr. Bhattacharya, nonetheless. Definitely. Hearing is concluded, judgment is reserved on the review application.
We will also see, kindly make a note of 585, my lord, which they disclosed. The serial 2 says Ram Kumar Jha resigned on 7th October.
Hearing is concluded. Full learned
Oh, sorry.
counsel for the parties are requested. Judgment is reserved now. Hearing is concluded. Learned counsel for the parties are requested to put in their written notes of arguments. When, Mr. Bhattacharya?
Lordship
So
never
that
does this.
now, at least now everything is on record.
Lordship never does it. I'm sorry, my lord. I shouldn't have
No,
submitted.
no. For Mr. Bhattacharya also. When should you file your written notes of argument? Very brief. You will personally settle. Otherwise, every Monday will come in. When? Tell me.
Gives me 7 days time, my lord. I do not know what is going to happen.
The matter
next
shall be
7 days.
listed under the heading to be mentioned on April 29, 2024 for such purpose. Come back. Next.
Wait for this.
Item number
Number 2 is a connected matter.
1 and
Let the
2 is what is 2?
2 is, my lord, the previous writ petition filed by us, whereby we have questioned, my lord, non-issuance of or non-exercise of power under
Is
63
2 dependent on this review?
Yes.
to a very mild extent. Why? Because, my lord, we had made various allegations to the competent authority.
Mr. Bhattacharya, I'll keep 2 open then. I'll
Keep
this-
2 minutes
after deciding on this
Yes.
review.
Yes,
I'll keep 2 open.
item number 3.
2টাও আসবে কিন্তু দুটো একসঙ্গে আসবে।
Who has to be heard entirely? If
I'll
I am
keep
restored, then 2 has to be heard. If I am dismissed, then 2 does not require.
And one before, just one thing your lordship has been pleased to see. Today, as on date, my lord, there are only 2 board managers. That also has a bearing on the ultimate conclusion.
No, you cannot frustrate an order by virtue of the pendency of a review application.
No, not
Seen on the
factual.
date when the competent authority
Factual.
passed
Unless
this
you
order.
win the review application. If you win the review application, there is no question of frustration. In any event, you will.
As your lordship.
It is to be the date, my lord, of the order of the competent authority. I'm sorry. I'll put all this in my written. I'm sorry.
Put whatever you have to in your written.
Yes.
But it has to be brief. Yes, next.
No,
Item number 3.
3.
No, once
2 will appear along with, as to be mentioned, I mean the other matter. I'll fix a date on that date, remind me. Yes. 3, who is appearing? You are appearing. Yes.
My lord, this is that matter against Calcutta Stock Exchange.
Right.
My lord was pleased to hear the matter on 18th of April, and my lord passed an order, my lord, which is effective till my lord 30th April. My lord, here, my lord, fine has been imposed on the company, my lord, petitioner before my lord,
Yes.
for my lord purported non-submission of annual returns. My lord, and the thing is, my lord, two issues were identified, both my lord
Suppose
without
please
notice.
seek for affidavits so that I can direct affidavits and put it on the
But only problem is my lord has
Yes.
injuncted me from recovering the penalty.
Fine, don't recover for some time. The heaven will not fall. Heaven was going to fall on me 2 days back. I mean, when I went to the lounge, not the heaven, but the roof pieces fell.
Which lounge?
Our judge's lounge. So I'll never use the expression heaven will not fall. So, but Mr. Ghosh,
Your
on a
lordship
serious
is
note-
identifying the judge's lounge as heaven. It might
very
be.
good, very good.
might be.
Yes, I very much appreciate that witty comment. I genuinely appreciate that. Yes. But on this, coming back to this, I mean,
Yes, my lord, the main
the recovery of fine,
no,
Calcutta Stock Exchange.
But your lordship kindly, my lord,
Yes.
my lord, kindly, my lord, I hope I could be that generous with my clients. My lord, kindly takes your lordship's last order. There's a recording that they have paid the penalty,
Paid the listing fees.
the listing fees.
Hmm.
But that is not my instruction, my lord. On that basis, really, my lord, your lordship had come to a finding that the listing fees has been paid, and annual return for 2021, at least there has been compliance from submitting of the
Yes.
annual return in
Making-
email.
making such
My lord,
payment.
Yes. Now, my lord, my instructions are that those my lord, payments have not been made. I don't know.
part of the petition itself, page 47. My lord, I have, my lord, specifically, my lord, informed them that, my lord, we have paid.
No,
My lord, I have also given the, my lord, UTR number, check number, and
my
all,
lord, may-
all
may-
information.
I'm not troubling your lordship today. May I?
A short affidavit
Yeah,
of
but,
issue.
but not even short affidavit. If this is there, my lord, I will come back with instruction, my lord. Because my instructions are they have not been able to trace this.
It is part of the
File it by UF affidavit. No, I'm not. We don't want to file and record that.
Well, kindly
but
just
you have to deny somehow.
That's what I'm saying. My instructions are this, but she has pointed out. I've also
Deal,
put that
deal
query.
with this, Mr. Bhattacharya, Mr. Ghosh.
2 days, my lord. 2 days. I'll come back on Wednesday, my lord. I'm not troubling you.
Suppose you have verbal instructions. So how that? I mean, you have to put it on oath. In any event, you have to put it on oath.
Very well, then very
Because
short.
they've
affidavit.
averred it.
Very short.
Yes,
affidavit.
whatever
My
time
lord, 10 days, my lord.
very well, whatever the time you say. I mean, no difficulty on that.
None.
Since certain factual issues are involved in the matter, the respondents are directed to file their affidavit in opposition by May 3, 2024, full stop. Reply, if any, shall be filed within May 10, 2024. The matter shall be placed for hearing in the list on May 13, 2024. The interim order granted earlier is extended till June 15, 2024 or until further order, whichever is earlier.
Grateful, my lord.
Thank you. Huh? No.
Item number 4.
Yes, what is the matter?
No, my lord, I was in reply. My lord.
Yes, right.
Would your lordship be pleased to hear me over the internet, my lord, if your lordship permits, my lord?
But I'm being led by Mr. Ram.
Yes, Mr. Rai.
Sorry, my lord, I could not go to court, my lord. But on the last occasion, my lord, I was placing my lord,
This matter will take some time, as you indicated on the
Well, it
last
will.
also. So I'll
it will, my lord.
hear you today, but I'll put the hearing not at the top anymore because other matters are being blocked. Every day mentioning is being done. So I'll put it in regular
I know,
course.
my lord.
Not matter. Now.
My lord, yes. My lord, I was on the verge of, my lord, I was placing the order with the challenge in the subsequent GA, my lord. And if your lordship remembers the matter, my lord, there was a challenge first to my lord that they said that we were supposed to give back them the money on the ground of admission. Then, my lord, in the midst of that, my lord, when they filed the writ petition, we came up and said that there was a proceeding against them which was not yet concluded. The learned single judge had said conclude the matter within 45 days. Appeal preferred, my lord. In the midst of that appeal, my lord, this final order was passed. The division bench said that they could rely upon or make a challenge to this order, my lord, which they have sought to done by way of a GA application. I had placed, my lord, the documents before your lordship. I think both sides have placed that. And I was in the midst of I had started on the order which they say it's under an appeal under the writ petition, but as a course of maintainability, I said it's not under challenge the writ petition. But again, I said that I will take the point of maintainability at the very end, knowing your lordship that your lordship first likes to get out of the merits wallet. So I'll do that and then I'll take the point of maintainability. But we'll kindly take page 155 onwards of GA1 volume 2.
Yes.
Well, it kindly takes page 155. This is where I ended as a matter of the last occasion. But I was trying to show your lordship what were the documents which were before the committee who was hearing out this application, this complaint proceeding. Now, kindly sees just at paragraph 3, clause 3.
Yes.
Letter dated 7th February 2020 in terms of the aforesaid order of the Honorable High Court at Calcutta, issued by CSC, Mr. Uttam Kumar Mondal forwarding the photocopy of the certificate of deposit of the HDFC Bank to 123, whereby the said broker members were also requested to produce the documents sought for by CSC on earlier occasions within a period of 7 days from the date of receipt of such letter, such that CSC could conclude the said inspection and investigation for the period of 45 days as directed by the court. Next, letter dated 21st February 2022, once again issued by CSC. Then, again they were called for documents. I'm only on the point of natural justice. Again, now sees 5. Mr. Shubhranshu Ganguly, advocate of the broker members, intimated Mr. Uttam Mondal that they have challenged the single bench order by preferring an appeal before the Honorable High Court. Then kindly comes the next page. Clause 9. I just pointed out that there was no stay of the order of the learned single judge, so we proceeded with clause 9. 156, clause 9.
Yes, other matters are released. Yes, sir. Yes. Yes, 9.
This says letter, clause 9, page 156. Letter dated 15th March 2022, written by Shubhranshu Ganguly, advocate of the broker member, to Mr. Uttam Mondal. Now, this is quoted. Since there is no record available from the past, there is going to emerge nothing new, and therefore the decision could simply be taken on the basis of already furnished information, which renders the reconducting of inspection points. So, this letter clearly waives whatever rights they had of placing further documents, and also they submitted to the jurisdiction of the respondent, saying that whatever decision you need to take can be simply taken. And page 5 of the last paragraph states as follows: this reply is issued without prejudice to my client's rights and containing the pending appeal. My client calls to await the outcome of the appeal. Then kindly sees the starting of the ordering portion. It is to be noted that pursuant to a letter of 24th April 2002 issued by SEBI, an inspection was conducted by an inspection team. Malad remembers Mr. Mukherjee on a regular basis, as a matter of fact, while he was submitting, was talking about an inspection report which was not given to his client. That was his main point on violation of natural justice. Remember, he did say so. Now, this was the inspection was carried out. Subsequently, the inspection was filed, which was examined by the authority. The inspection report became the basis on which a show cause was issued to Dalmia Securities Private Limited on 4th March 2004. But I have shown this letter to your lordship, Malad. If your lordship would be pleased to take this, Malad, this letter, Malad, kindly takes, Malad, the writ petition, Malad.
(174) of volume 2 of GA1.
174 of volume 2 GA1.
174, my lord, of GA volume 1. GA1 volume 1. I'm sorry, my lord, volume 2. GA1 volume 2.
Yes, Mr.
Yes.
Rai, 174 of GA1. Second
Malad,
volume.
yes, 174. Yes. Malad will kindly see. I've shown this document earlier also.
Okay. It is Mr. Sengupta only who pointed out, not my own friend.
I know, Malad. I've heard, Malad. once in a while we prepare juniors, my lord, who can help us out, my lord. But he's very competent otherwise. My lord.
Yes, he is.
My lord, will kindly take this, my lord, page 174. My lord, why I'm saying this, my lord, the inspection report, whatever was there, was clearly set out in this letter to Dalmia's.
So you say the non-funded that inspection report is not fatal?
Cannot be. No, because the entire inspection report was placed on them as a show cause. But just see the subject. Inspection of your firm's books on accounts and records under provisions of Securities Act. Please refer toward inspection of your books of accounts and other records on 30th May by Surveillance and Inspection Department of the Exchange. And further details asked for submission as per letter date 21st December 2003. You're advised to submit your comments on the following violation observed from the books and documents produced by you. So whatever was found from the inspection was given to them for their comments. They had given a letter also, and I've shown that. I'm not again leading that. This time I'm only showing this for the purpose of the allegation of violation of natural justice vis-a-vis the inspection report. Now, Malad, kindly again come back to page 156. Malad. Subsequently, Dalmia Securities Private Limited had also accepted jurisdiction for conducting such inspection investigation and filed several replies in said proceedings. The same has been dealt with subsequently hereunder. Board has also produced the report of the inspection team in totality. Board noted the report of the inspection category stated that Dalmia Securities had entered, whatever is being stated here, but I'm not again comparing. Your lordship will find in that letter the same thing was written. So the board was also considering the report which was sent to them for their reply. Malad, kindly comes to the next page, Malad.
Yes.
By transacting, a second paragraph, transacting huge volumes of off-the-floor transactions, Dalmia Securities Limited, along with other defaulted brokers of CSE, appears to have organized a parallel platform working as stock exchange for the purpose of assisting in entering into and performing contracts and securities. Be it mentioned that Dalmia had not reported CSE regarding any off-the-floor transaction entered into by them. It is important to mention here that there is no need for a broker to trade with other brokers of the same exchange for his genuine trades, even though the member is in possession of multiple membership with other exchanges. But if they're on the same exchange, Malad, why will they use the National Stock Exchange? That has been their regular contention. That these transactions were done on the National Stock Exchange. But they did not give us any documents. And when I said so, the answer was that we should have called for the documents and got it from our records. But these records are with them because it was from the National Stock Exchange.
No, Mr. Mukherjee probably these are public records, Mr. Mukherjee indicated. I mean, these are for anybody to see.
Malad, if it is a defense, Malad, then they should produce the document.
All right.
Malad, they were told that these were off-the-floor transactions, to which they suddenly say that no, these are transactions on the National Stock Exchange.
It is not for you to search out their defense. They had to substantiate.
Yes, and Malad, if I go strictly by, Malad, let us say this was a suit, then Malad, I would have taken the point that they are withholding the best evidence. If it was a suit, Malad.
Get your point. Yes.
So that is why I'm saying, Malad, it was their job. Then, Malad, can you see just in between, Malad? Messrs. Dalmia Securities, via its letter of 18 March 2004, publicly claimed that off-market deals had actually been transacted on behalf of their clients on NSE, which includes HCM, such and such and such. Mentioned that all the above three defaulted brokers of CSE have their own NSE terminals.
Are you reading HC Biani as Biani?
Thank God it's not N.
Only one making. Anyway, let us continue.
So that's of CSE have their own NSE terminals, and as such, without dealing in their own NSE terminal, the dealing through Dalmia Securities and NSE terminal tantamount to prejudicial business as per clause 3353 of CSC bylaws. As per regulation 4B of SEBI prohibition of fraudulent and unfair trade practices, regulation 95, no person shall indulge in any act which is calculated to create a false or misleading appearance of trading on the securities market. Therefore, transaction undertaken by Dalmia was not only in violation of bylaws of CSC, but also in contravention of SEBI prohibition of regulations. Present inspection and subsequent inspection has been proceeded with under clause 334, 3 and 5 of the CAC bylaws, which is binding on all members of the CAC. But if your lordship, I had thought I'll place this first and then I'll show the provisions of the bylaws. The bylaws clearly allows this inspection and investigation. Because much was told that because of the mention of the word show cause, much was told that there was no consequences mentioned. That is why you couldn't have been a show cause. Truly, it is not in the nature of show cause. The nature of a proceeding under 334, 3 and 4 of the bylaws. One of the bylaws are with your lordship, I'll place that, but may I just complete with this first and then go to the bylaws, I think that will be easier for me, Then, Dalmia had secreted huge volumes of off-the-floor transactions. Same was stated in the letter of 4th March 2004. In this context, SEBI, by its letter of 14 September 1999, was notified to the member of CAC by its notice dated 16 September 1999 is relevant. Certainly provides that all deeds shall be executed only on the screen of the exchange in the pricing and order-making mechanism of the exchange, just like any other normal trade. The volume of off-the-floor transaction and fund-based transaction were executed by Dalmia without registering the same with the recognized stock exchange, including CAC. Now, when this point comes up, this is what the point was also in our reply, rather the show cause, if I may say so. Then it again becomes more required for the person who's charged with this to show that there was no violation of the SEBI rules because it was done on a platform of the NSE. Till they show that it is on the platform of the NSE, I will be holding it as the off-floor transaction. That is not done through any recognized exchange. And that is the violation. Then kindly keeps just below that, hence by keeping such large volume of the floor transactions, fund-based transactions outside the trading system of CSC, and by not reporting those transactions CSC, Dalmia Securities, along with other default brokers, have willfully concealed huge volume of turnover in securities, therefore interfering with price discovery mechanism of stock exchange, and created a false and misleading appearance of trading on the securities market, also acting in violation of the circular and bylaws 332 and 334(3) of CSC bylaws. So, this entire process was not for any violation of only SEBI regulations. The bylaws, is a contract between me and Mr. Mukherjee's client. The violations are there. And that is what we have quoted. So by saying SEBI has given me a clean sheet, SEBI's clean sheet has got nothing to do with this. I will show that later also, what SEBI has done. SEBI has said, yes, there were violations. I'm giving you a reprimanding you and giving you a caution. But my bylaws, which they're in violation of, is independent to SEBI. And that is why at every instance, we had invoked the bylaws of the CAC, which is binding on them and as well as on me. Now, kindly see the clauses 334, 3 and 5, have been also set out here.
Yes.
Guilty of misconduct. What are the process of misconduct,
Mr.
Then, next page 158.
Sir, did the petitioner disclose any details of the transactions, if not the documents? I mean, NSE transactions?
No.
Anything?
No.
These are the numbers, like the dates.
No. This petition, I would have expected, in this GA, you would have disclosed some. No.
All right.
No, subject to correction, but it is not there.
Very
good. Then, can you see? Dalmia Securities Limited had also done fund-based transaction with Sanjay Kemani, which amounted to rupees 17 crores odd. Stated that all these fund-based transactions NSE obligations for NSE trades, but could not produce any such document in support of the claim. Therefore, such claim is not sustainable. It was very easy for them to show these documents. And may I say this? They are saying that it's been a long time. This letter had gone to them in 2004. My letters of 2021 are just asking them if you want to give further anything else. But in 2004, they would have had the records. So by saying that this has continued for such a long period, I do not have the records, my lord. But that is, my lord, an afterthought. A clear case of afterthought.
Mr. Rai, instead of taking penal steps, why did you prolong it for so long? I mean, you should have taken penal steps much
My lord,
back.
yes. My lord, no, my lord, that was the problem, my lord, because they were writ petitions and suits filed by them.
Achha.
That was the problem.
All right.
And my lord, there is some, I don't know, my lord, there is some kind of a problem with litigants, my lord, also. And if there is a case in the High Court, let us just wait for some time. Here, thank God, my lord, there was an injunction order also for some period. But my lord, that is the reason they did not.
Yes.
My lord, should I continue, or your lordship, my lord, your lordships?
No, you may not.
I thought so, my lord.
Now that, my lord, Mr. Rai has really started again.
Yes.
Perhaps, my lord, we can have it, my lord, tomorrow, my lord, at whatever, my lord, and finish.
No, now I'll not put it at the top, Mr. Banerjee. It will be a part-head matter. Are you enjoying an injunction or any interim order? They are.
Yes, my lord, there is an.
So I'll put it as a
Yes,
part-head.
yes.
The hearing matters go down now. I have to take up the court applications first from tomorrow onwards.
Applications are also coming.
My lord,
I'll make it part. I'll record that it is part-head today also and put it. It will be in the list.
so that, my lord, I know. Perhaps, my lord, now.
It will be in the list. He'll continue for some days probably. You are going to say something.
After the matter is over, I will seek your lordship's leave to mention on matter. After
Other way, I'll just pass on. Hard in part. Let the matter be listed for further hearing tomorrow.
Okay. No, because we had actually
Grateful,
finished
my lord.
November 2023.
Yes.
It is really
It's
not
not that, my lord, but I have not been speaking for 6 months, my lord.
necessary adjournments have only been taken, not
No, no.
unnecessary. I won't say unnecessary.
Acha, এটা হইয়ার পর না, I mentioned এটা নিয়ে
respect, my lord, with your lordship's leave, my lord, one bail has been, my lord, assigned to this honorable court, my lord, division bench, my lord, presided over by your lordship. My lord, I'm in custody for the last 74 days. When I filed the bail application, I was in custody for 62 days. But may I request your lordship to take it up, my lord, tomorrow, submit to my lord.
sitting with justice.
Well, with Justice Sugato Mojumdar, as I've given to understand, my lord. Because, my lord, I think the other side also may come, and if tomorrow your lordship takes it as a, I mean, to be mentioned matter, your lordship may fix it
Tomorrow,
according to-
it's not possible like that. I mean, Mr.
Well, it's then I
Mr.
will notify the
Justice
other side.
Mojumdar has his separate bench. He's sitting singly. I'm not sure.
No, my lord, that I do understand.
Divi, singly question. I'll have a talk with him. Not possible tomorrow. I'll try as soon as possible because of your
Obliged, your
absence.
lordship. I'm deeply obliged.
Very well. Thank you for informing. I'll definitely have a talk with
My
Justice.
lord, again, my apologies, my lord, that I'm
No, no,
troubling
no,
your
no
lordship.
question of apology.
It's a
You are
bail
behind the bar
petition,
for so long. No,
Most
definitely not.